Good morning, Dave.
Hello, Anna. How are you? Can you hear me?
Oh, I cannot hear you.
Cannot?
Oh, there you go.
Can you hear me?
No, I cannot hear you.
I can hear you. This is Kelly Gould. I can hear you, David.
Try
Hello,
one
Kelly.
more.
Can you hear me now, Anna?
Can you hear me, Dave?
I can hear you. Can you hear me?
Oh, okay. So I cannot hear you. Okay, your microphone there.
Can you hear me?
No, I cannot hear you.
Anna, can you hear me? This is Kelly Gould. I can hear both of you. I think it's something on your end. Can you hear me?
I can hear you, Kelly.
Anna, can you hear me?
Let me see.
I think
Is it
it's on
something
your
that is
end.
happening on my end. Let me see. Let me see. Hello.
Hello, Anna.
Oh, there you go. It was my headphone.
All right.
I'm sorry.
No problem. How was your weekend?
It was good. I could do some things that I needed to do. Let's see
Same here.
Mhm.
Mr. Lee, are you on the live stream?
Yes, sir, I am.
Okay, I just want to make sure you can hear and see me.
Yes, sir.
Good, good. Sometimes Zoom plays tricks on me and resets all my microphone settings.
I understand completely.
And David, this is Mr. Albright, just checking to make sure the audio on my connection is okay.
Yes, sir.
Thank you. Hope you had a good weekend.
You too.
So,
Morning, Brad. And Anna.
Good morning.
Morning, Mr. Lee.
Good morning. You're on mute, Judge.
Right.
I'm ready.
Good. All right. Thank you, Mr. Lee. Good morning, all. This is our second week of hearings in case number 21-0017-UT. I hope that everyone had a very, very good long weekend. We are set to proceed, I hope, with PNM, with actually Western Resource Advocates witness, Mr. Batts. With that, Ms. Beatles, are you prepared to call your witness?
Your Honor,
Yes, ma'am.
this
Yes,
is
sir.
Joseph Yar on behalf of Onward. I have a
Yes.
preliminary matter that I would like to just take 2 minits to run by you, Your Honor, if you
Okay,
would
yeah.
allow it. Your Honor.
Hang on. I have not allowed it yet.
Okay, sorry.
PR, I'm sorry, please. We have a lot to get through today. Quite a bit to get through today. That's why I didn't stop and ask, which I usually do for preliminary matters.
Understood,
So
Your Honor.
if you could please keep it brief, we'll move to it. But we have a lot to get through today. And I want to try and get through all of it. So
Okay,
go ahead.
Your Honor, real briefly, I'm anticipating having some time cross-examining one of the witnesses in the case. And in my cross-examination, I'm thinking of possibly using one document to refer to, not to come in as evidence or anything of that nature. I didn't know how Your Honor wanted to proceed with that. It would be just to refresh his memory on certain aspects of his testimony. I have already spoken to PNM. They have no objection to it. I just defer to Your Honor on how to proceed with that.
Well, did you upload it to the folder for this case on Dropbox?
I have not, Your Honor, only because I do not anticipate having it come in as evidence into the record. I just only for his background to refer to.
Do you understand that the rules that the pre-hearing order provided for, even if it's just for cross-examination, that it should be uploaded to Dropbox, correct?
Understood, Your Honor. I'll withdraw it. No problem.
You don't need to withdraw it. I just want to understand the parameters of the issue, and emphasize that this is contrary to what the pre-hearing order required. And so this preliminary matter is another delay on something that was not following the rules.
I apologize, Your Honor. I don't want to belabor the moment. I just wanted to ask for your guidance. And if Your Honor wants to move on, I completely understand.
Well, I might make this exception if I find it in your Onward Energy Holdings Dropbox folder before the time for cross-examination so that other parties can review it. I understand that you said PNM does not object to it, but and please ensure that it's properly marked as Onward Energy Holdings Exhibit 1, even if you're not seeking its admission. Thank you, Mr. Yar.
Thank you, Your Honor.
You're welcome. All right, well, now that we've started on that footing, are there any other preliminary matters that anybody wants to attempt to broach? Ms. Nanazi?
Good morning. Thank you so much. I would like to, during the weekend, I was preparing my cross-examination and I'd like to move my 15 minutes from Brendan Batts to Mr. Graves, if you will. So I would not be cross-examining Mr. Batts at all, and I would add 15 minutes to Mr. Graves.
So you want an hour with Mr. Graves?
Yes, please.
Done.
Thank you so much.
You're welcome.
Hearing examiner, this is Debria Twilliger. I also have a preliminary matter, if I may.
Yes, ma'am.
Yes, thank you. And I'm here just to address this. We'll have to do a quick switch to Mr. Gifford once Mr. Batts gets called up. PNM renews its objection to taking administrative notice of the record pursuant to NEE's July 12th administrative notice filing. NEE did not comply with your oral order from last Friday. Documents continued to be uploaded after 5 p.m. yesterday. And the documents that are currently in Dropbox do not reflect all of the documents that Ms. Nanasi has sought to take administrative notice of. Both in terms of whole exhibits are missing and the pieces of some of those exhibits are also missing. I've unfortunately went through in painstaking detail, to the extent that the July 12th request for administrative notice matches or does not match what Ms. Nanasi has provided in Dropbox. I can do that with you on the record, although that will take some time. But we renew our objection to taking administrative notice to anything that NEE seeks to admit pursuant to the 2016 rate case because it doesn't comply with the rules and she did not comply. Your oral order was not complied with.
Which the oral order was entered into the record verbatim. But I want to observe that Mr. Yar, unfortunately, bore the brunt of what I feared was coming this morning, very first thing. And so quite frankly, I want to get to the witness testimony and I don't want to deal with it. We have more time tomorrow. If a document comes up that needs to be addressed in cross-examination today, as we did last week, we'll address it. But I'm not going to take up any more valuable time today on a pivotal day with these preliminary matters. But I appreciate PNM's objection. But Mr. Yar, as you can tell, I was anticipating we were going here, and I was trying to subvert that by getting right to the testimony. Unfortunately, that was just a wish on my part. But in any event, is there anything else preliminary before we move to the witnesses, the presentation of evidence, which, by the way, is what we're here to do. Attempt to get evidence in the record of this case. And we're having difficulties in some quarters doing that. All right. And one minor example this morning and one potentially very major example that continues to be a drag on this case. So with that, Is there anything else that anybody would like to raise with me before we move to presenting further evidence in this case? Pregnant pause. All right. Ms. Beatles, would you please call your witness?
Thank you. And I have led you and the parties astray by pronouncing his last name as Bats. It is actually Bots. So Western Resource Advocates calls Brendan Bots.
Mr. Batts, would you raise your right hand, please? You solemnly swear the testimony you're about to give in the matter and opinion should be the truth, the whole truth, nothing but the truth?
I do.
Thank you, sir.
Mr. Bots, do you have before you a copy of your direct testimony filed in this matter on July 12th, 2021, which we have labeled as WRA Exhibit 1?
I do.
Do you have any changes or corrections to that testimony?
I do not.
If you were to answer today those same questions, would your answers be the same?
They would.
And are they true and correct to the best of your knowledge and belief?
Yes, they are.
I move the admission of WRA Exhibit 1.
Any objection? WRA Exhibit 1 is admitted.
Do you also have before you a copy of your rebuttal testimony, which has been labeled as WRA Exhibit 2?
I do.
That was filed in this matter originally on August 2nd, 2021. Is that correct?
That's correct.
Do you have any changes or corrections to that, to WRA Exhibit 2?
I do not.
And if you were to answer today those same questions, would your answers be the same?
They would.
And are they true and correct to the best of your knowledge and belief?
They are.
I move the admission of WRA Exhibit 2.
Any objection? Hearing none to this exhibit as well. WRA Exhibit 2 is admitted.
I now pass the witness for cross-examination.
Thank you, Ms. Beatles. I think up first we have Bernalillo County. Is that correct, Mr. Albright?
Yes, Mr. Hearing Examiner, it is.
I think you have 20 minutes.
I thought I had 15, but maybe it is.
Let me, no, actually, we are, I'm sorry, it's not your turn yet. It's actually going in the order of cross-examination. It's PNM's. This is the first non-PNM witness. I'm sorry, I was on the wrong track. Forgive me, Mr. Gifford.
I'm always willing to be deferential to Mr. Albright, Your Honor.
Well, if you'd like to go first, I believe you have 20 minutes with Mr. Botts. Is that correct?
That is true, and I actually hope to not take that much time.
Okay.
But I'm ready if you are, Your Honor.
Yes, sir. Please proceed.
Good morning, Mr. Botts. How are you?
I'm well. How are you?
Good. My name is Ray Gifford. I'm one of the attorneys representing PNM in this case. Now, if I understand your testimony correctly, you support the abandonment of PNM's share in Four Corners, correct?
That's correct.
And you support the use of the ETA to securitize the undepreciated investments in Four Corners. Is that correct?
That's correct.
And let me now get to where you and PNM might disagree, if I might. Does that make sense?
Sure.
And the first place that you disagree is with Mr. Baker on the impairment charge. Is that correct?
I do disagree with that, the impairment charge, correct.
And do you disagree with Mr. Baker's assertion that that charge is on PNM's books and records for purposes of the Energy Transition Act?
No, I disagree with that.
You do disagree. You assert it's not on PNM's books and records. Is that your testimony?
That is my testimony.
Understood. And do you disagree with Mr. Baker's statement that there would be no effect on customers if that charge is added back?
I'm sorry, can you repeat the question? And no effect on customers in terms of what?
So you want that that $27.9 million impairment charge backed out of the securitization amount. Is that correct? Let's stage set here.
No, I want the securitization amount to be based on the language in the ETA that requires the beginning balance to be based on the net book value of that plant or the undepreciated value of that plant on PNM's books as of January 1, 2019, which I had attached to my testimony in PNM's 10K.
And Mr. Baker provides an explanation as to why that impairment loss does belong in the Energy Transition Act charge. Do you acknowledge that?
I know that that's what he testified to.
And you therefore don't think it was on PNM's books and records?
No, if you look at what PNM has filed publicly of this plant balance for that plant on that date in the FERC Form 1, in the SEC 10K, and in its annual report to this commission, the net book value or the undepreciated plant balance for Four Corners is what I use as my starting balance. It does not include the $27.9 million impairment write-off.
So do you have Mr. Baker's testimony, rebuttal testimony in front of you, Mr. Bass?
I can get it out.
It's PNM Exhibit 12, if you could.
It was filed on August 2nd.
Correct.
Okay. I have some pages of that printed. I don't have it complete. So we'll see if I have what you're looking for. If not, I may need a moment to pull it off Dropbox.
Now, I understood, and I'll try and make it quick. And if you need to refer to it, just let me know. If we go to page 4 of his testimony, line 9, the question is, and I'll just read it to you, in case you have it there and don't have it there in front of you. Do you have it?
I do have it.
Okay. So Mr. Baker's asked, does reversing the impairment loss increase the cost of customers? And he says no. Do you believe that reversing the impairment loss increases the cost to customers?
I haven't done the analysis. I haven't looked at the cost of service from the last case, so I can't answer certainly. But what I do understand is some of those costs have been collected in rates since that rate case. So to the effect that part of that is being collected in rates, then and if it's added back in for this purpose, then it should not increase rates for customers.
You would agree with me that if it is in rates, that it would be securitizable as part of the Energy Transition Act. Is that right?
No, I don't agree with that.
Fair enough.
I think there are two conditions there in the Energy Transition Act for those costs. One of them is they need to be the plant balance in the company's books and records as of January 1, 2019, which this 27.9 million is not. And then the other condition is are collected in rates, which these dollars were collected in rates, and I don't dispute that.
That they are collected in rates. You would agree with that?
I agree with that.
Let me go to the second area that you, in reading your testimony, you have concerns with. You talk about the ongoing costs of operating the plant before its retirement. Is that correct?
Yes, sir.
And you think that those numbers are too high, at least in this application. Is that a fair summary of your testimony?
Well, I think the language in the ETA allows those capital costs to be recovered or securitized as part of the ETA. if they're incurred to keep the plant operational through closure. And I think these costs far exceed that. And when you compare the last 4 years of costs, a forecasted CapEx on this plant, shown, I believe it was in Mr. Phillips' testimony, or maybe it was Mr. Fulgren's testimony, to what they're planning to spend in 21 through 24, it's a completely different story. So I think the costs that are being, that PNM is requesting to securitize exceed.
I'm
what
sorry,
is
sir,
allowed
can you
under the
start
ETA.
that last statement again? I missed the beginning. It was breaking up.
Do you recall what I started with?
Go ahead, please.
Go ahead, Mr. Botts.
Well, all I was saying is that I think that the costs that PNM is requesting to securitize the capital additions that are going to occur in 21 through 24 exceed those that are allowed under the ETA.
But you would agree that the costs that can be securitized include costs required to maintain the safe and reliable operation of the plant. Is that right?
That is correct, and that's why I proposed a different value or calculation of those costs.
And you would agree with me that the costs that are ultimately securitized will be trued up to actuals, not projected amounts. Is that correct?
That's correct.
Thank you. No further questions.
Thank you, Mr. Gifford. Now, Mr. Albright, sorry about that. I was on the wrong line, looking at who was cross-examining whom. So, Mr. Albright, you do have 15 minutes, is that right?
15 minutes, Your Honor.
Okay, please proceed.
Thank you. Good morning, Mr. Botts.
Good morning, Mr. Albright.
I'm with J. Albright Law LLC, and I represent Bernalillo County in this proceeding. So I do have a few questions, and some of which you began or at least provided some response to Mr. Gifford. So there may be a little bit of overlap there. Would like you to turn to your direct testimony, please. And first, I'd like you to take a look at page 7, please.
Okay, I'm there with you.
Okay, and when you at lines 15 through, I guess it's 18 or 19 there, you talk about the company assumes a 20% forced outage rate, which PNM concludes reduces the available capacity to 160 megawatts. Do you see that statement?
Yes.
When you're looking at overall capacity, is it normal, or looking at securitization, for example, is it normal to include the forced outage rate as part of the overall load, or does it go to a reserve margin, or why does the forced outage rate, how does that get factored into what gets included in securitization?
Well, in terms of securitization, I'm not sure that there's a relationship. But if you're conducting analysis about a replacement portfolio or replacement of an asset, and you want to understand whether or not the replacement resources that you're reviewing or analyzing are on the same footing from a reliability context, you want to look at things like forced outage rates and ELCCs to determine or to make sure that what you're analyzing to replace with is actually a valid replacement.
And is there a set number, or does it vary over time? I mean, how do you come up with a forced outage rate that's consistent across a longer term of a replacement resource?
Well, I mean, for existing plants, you would want to look at plant data that you have available to understand what that has been historically and what it may be in the future. But in a situation like this, where you're looking at a proxy resource, like a combustion turbine, and you're making really an assumption on what the forced outage rate would be. There's a lot of good benchmarks and metrics available because there have been so many of these assets built. And I think what PNM used was from the National Renewable Energy Laboratory and the U.S. Energy Information Administration to draw those assumptions. And I think they're valid and I think they're reasonable.
Would you turn to page 13, please?
I'm there.
And beginning at line 3, there's a question. Please summarize other assumptions and inputs to your analysis that have not been previously mentioned. Do you see that question?
Yes, sir, I do.
Okay. And and you have an answer there. And my question there, does that number that you have, the 1.1 million megawatt hours, does that account for the 20% reduction in the availability time?
So the 1.1 million megawatt hour number is what PNM forecasted Four Corners to operate at and produce every year for the remainder of its life. So that assumption is specific to Four Corners and it's directly from PNM.
Okay, and then continuing on that same page, you said that your analysis, the question at line 29, did your analysis include any impacts from the seasonal operation agreement? And your answer was no. Would you explain why you would not include the seasonal operation agreement and the impact there, since it would be equivalent to like a forced outage, I would assume, if they're not operating one of the units. So why didn't you include that in your analysis?
So at the time that we were finalizing the analysis in this testimony, the seasonal operations agreement had not been finalized from what I recall. And it's also, from what I understand, the seasonal operations agreement is contingent upon approval of abandonment. And so we didn't include it in the analysis for those reasons. We're still unsure if it may happen. And elsewhere in testimony, I think it follows in the next page. I talk about the problems with the seasonal operations agreement and the fact that the way it's drafted, the effect of it will likely be to keep the plant operational longer, which we caution is a problem for the seasonal operations agreement and the continued operations of Four Corners. In fact, it's actually better if the seasonal operations agreement is not approved, if abandonment is approved.
And would you explain why that would be the case? I'm not quite sure I understand.
Well, the effect of the seasonal operations agreement is that it extends the life of this power plant. So as the operating agreement currently exists, plant owners can vote unanimously to close the plant, which starts a 24-month clock to end the coal contract or the coal supply agreement without penalty. And if the transfer agreement is approved as drafted and PNM transfers this plant to NTEC on January 1, 2025, then let's just say hypothetically that day the owners vote to close Four Corners. Then the earliest it could close without penalty would be January 1, 2027. But if the seasonal operations agreement is approved with the provisions that we have on the table now, that 24-month clock that I just spoke of turns into a 48-month clock. So if the owners decide on January 1, 2025 to close Four Corners and vote unanimously to do so, the plant could close on January 1, 2027, but then NTEC would need a $200 million payment. Then if you wait another year, it turns into a $100 million payment. And, in my opinion, that's going to keep the plant open longer, which would, it would really kind of peel back the benefit of the seasonal operations agreement if the plant operated another year or two because of it. And then there's a question of who pays the $200 million. Would it be APS ratepayers? Would it be TEP ratepayers? And I do quite a bit of work in Arizona, and I just don't know how that is going to go over with the Arizona Commission.
Okay, well, thank you for that explanation. I would like you to turn to page 15, please. Again, we're still on your direct testimony here. And I think, all right, and I think this may have been clarified with Mr. Gifford a little bit. You mentioned at lines 13 through 15, the 27 million with regard to the impairment write-off. And there are numerous references. You continue on that page, 27 million and so forth. That's not a precise figure, correct? You're referring to the 27.9 or what? Well, let me just ask the question. What is the correct figure?
Well, you could find the correct figure in PNM's Form 1, which would have been filed.
Sorry, in PNM's?
FERC Form 1, FERC, Federal Energy Regulatory Commission Form 1, which was filed on April 17th, 2019, and is on file with this commission in its annual report. If you look at page 123.7, they actually have the exact amount right in the Form 1, which to start would have been.
I don't have that in front of me, so if you have that, could you just tell us what that is?
Sure. It's $27,937,581.
I'm sorry, 27,931,000.
937,581.
Thank you.
But that is the balance as of December 31, 2017. The balance as of December 31, 2018 would have been $27,631,667. And that would have been deducted from the plant balance that is actually on page 123.73 of the same document, the same FERC Form 1.
And having declared it as an impairment write-off, why is it your opinion that PNM can't now claim it as to reverse that and do it as an expense? Why isn't that possible?
Well, it's not an undepreciated plant balance. It's an unamortized loss. And it's recorded on PNM's books today in that manner, according to testimony from Mr. Baker. And, you know, as I said, the ETA is pretty specific about what would be securitized, and it's the plan and service balance or the undepreciated plant balance as of a specific date. And there are 3 public filings with the New Mexico Commission, the FERC, and with the SEC with this plant balance for this plant. And it does not reflect the unamortized loss that Mr. Baker is attempting to add back in for securitization.
And thank you for that explanation, Mr. Botts.
About 3 minutes, Mr. Albright.
Thank you, Mr. Hearing Examiner. Just checking through my notes here. Mr. Hearing Examiner, that's all the questions I have for Mr. Botts. Mr. Botts, thank you very much for your testimony this morning and your response to my questions. Appreciate it.
Thank you.
Thank you, Mr. Albright. Okay, up next, I believe, going along the line here is Sierra Club with 25 minutes for Mr. Botts. Mr. Gerhart, you ready to go?
Yes, Mr. Hearing Examiner. Can you hear me?
loudly and clearly, much better than last week.
Great.
Yes.
Glad it's
All
better.
right. Please proceed. I believe you have 25 minutes, correct?
Yes, that's correct.
Okay, go ahead.
For the record, this is Matthew Gerhardt representing Sierra Club. Good morning, Mr. Batts.
Good morning.
Mr. Batts, I'm trying to understand how your recommendations conflict with Dr. Fisher's recommendations. So I'm going to start with where you may agree and then get to where I think you disagree. Would you please turn to your direct testimony, page 4, line 24? Please let me know when you're there.
Page 4, line 24.
Yes.
Yeah, I'm here with you.
So you see that sentence that starts, I have also reviewed. Do you see that?
Yes, I have.
My understanding of this sentence is that you're saying the provision of the purchase and sale agreement that could extend the life of Four Corners is not in the public interest and should not be approved. Is that correct?
That's correct.
And you recommend that the purchase and sale agreement be approved only if the provision with that voting restriction were modified or stricken. Is that right?
That's assuming the PRC has the authority to approve that agreement. That's correct.
PNM has not in fact filed an amended purchase and sale agreement. Is that right?
That's not to my knowledge.
Okay. So setting aside the legal issue you just mentioned, if it were the case that the purchase and sale agreement were required commission approval, then you're recommending that the purchase and sale agreement not be approved, correct?
That's correct.
Did you
So
say
now-
we go? Council, setting aside the we go?
Setting aside the legal issue.
Legal, thank you.
Sorry, Mr. Lee. So Mr. Butts, now I want to get to where I believe you and Dr. Fisher may disagree. You're recommending that the commission approve PNM's abandonment application, correct?
That's correct.
Okay. As a practical matter, the purchase and sale agreement is the mechanism by which PNM is proposing to accomplish abandonment, correct?
Correct.
So the purchase and sale agreement specifies when abandonment would occur and the terms and conditions on which abandonment would occur, correct?
Can you restate your question, please?
Sure. The purchase and sale agreement specifies when abandonment would occur, correct?
It specifies when the plant would be transferred to NTEC.
And that's the mechanism by which abandonment would be accomplished, correct?
I believe from PNM standpoint, that is the case.
In other words, PNM can't just declare we abandon the plan, right? It has to have some legal mechanism by which it accomplishes abandonment, right?
Not without facing severe penalties and breaches of contract. That's right.
Okay. So if the purchase and sale agreement is the mechanism for accomplishing abandonment, would you agree that to evaluate whether abandonment is a net benefit, the commission has to evaluate the effects of the purchase and sale agreement?
Yes, that is my testimony, which is why I suggested they deny that provision in the purchase and sale agreement.
Okay, thank you. In your direct testimony, you conducted your own economic analysis of exiting Four Corners in 2024 versus 2031, correct?
That's correct.
Okay. I'm unclear what methodology you used. Did you use a model or a spreadsheet analysis?
It was a model built in a spreadsheet.
So you didn't use the Encompass model that Mr. Phillips used?
No, I do not have access or a license to Encompass.
Okay, thank you. I want to follow up on questions Mr. Albright asked you about seasonal operations. At the time you filed your direct testimony, the June 25 amendments to the Four Corners project agreement had not yet been finalized. Is that right?
I believe so.
Okay, so when you conducted your economic analysis, you were not able to incorporate into that analysis changes to the Four Corners agreements that were made in June of this year. Is that right?
Which changes are you referring to?
Well, you're aware that under the seasonal operations agreement, PNM will own the unit that does not operate seasonally, correct?
Correct.
Okay. And those agreements change PNM's ownership share in terms of minimum loading, minimum take, and which unit it will own during seasonal operations, correct?
Correct.
Okay. And those changes are not reflected in your economic analysis because the agreement that made those changes wasn't final when you conducted your analysis, right?
That's correct.
Okay. Have you seen an analysis by any other witness that reflects the June 25 changes to the various Four Corners agreements?
I'm not aware of one.
Okay. So for example, you haven't seen an updated analysis from Mr. Phillips that reflects the June 25 changes to the Four Corners agreements, correct?
Correct. I'm not aware of such analysis.
Okay. So I want to understand how you dealt with recovery of undepreciated Four Corners costs in your analysis. My understanding is that in the portfolios where PNM exits Four Corners in 2024, you reduce the amount that PNM securitizes by approximately $70 million. Is that right?
That's the scenario with the two adjustments that I spoke to in my testimony. As a starting point, there were no adjustments.
Sure, and then you made these adjustments where the securitization amount is reduced by approximately 70 million. Is that
That's
accurate?
correct. Yes.
Okay. So I'm not asking you for a legal opinion here. I'm just asking about your modeling. In the scenario where you made that $70 million adjustment, if for some reason that adjustment were not authorized by the ETA, then the cost of exiting under that scenario would increase by the amount of that adjustment, correct?
Correct.
Okay.
But it's not as simple as just saying a $70 million adjustment, because the value that you're talking about, or the dollar amount you're talking about, the 229 million, would be the net book value of the undepreciated investment as of December 31, 2024. But the adjustments are made over a series of time. You know, the first
I'm
one
sorry,
is
undepreciated investment up to, or the date?
it would have been December 31st, 2024.
Thank you.
And the adjustments occur at different times. So the first adjustment would have been a reduction in the beginning balance of January 1, 2019. And then the other adjustments are reductions to the capital expenditures in 21, 22, 23, and 24. Just to be clear on that. So it's not as simple as a $70 million adjustment if there's a bunch of timing differences.
Understood. So on a present value basis, it wouldn't be as simple as just adding in 70 million. You're saying on a present value basis, it might add up to a different amount, taking account for when those adjustments will be made. Is that what you mean?
That's right. But the number, the $230 million number, isn't present value either. It's a book value as of December 31, 2024.
Okay, thank you. So I want to understand how you dealt with recovery of undepreciated costs in the scenario in which PNM exits in 2031. So in that scenario, what did you assume in terms of recovery of undepreciated Four Corners costs, specifically with regard to the undepreciated costs that were at issue in the 2016 rate case?
Well, so in the 2031 scenario, specifically related to those costs, we assumed a debt-only return on those costs, as was the case in that order from the commission. And then in terms of the plant balances from those investments, I believe they're fully depreciated by the end of the calendar year 2031. There was a small balance that was left over from additional capital expenditures that were incurred in the later years of that plan that shows up as a regulatory asset after closure. And I think we just assumed that would be expensed or recovered in 1 year. I think Mr. Baker had assumed a much longer recovery period of that in his analysis of, I think it was 10 to 20 years. We didn't think that was realistic or reasonable. So we just assumed it was expensed with a return on in 1 year, or collected with a return on in 1 year.
So if I'm understanding you correctly, you're saying that in the 2031 exit scenario, you assumed that the costs at issue in the 2016 rate case continue to be recovered in rates at the cost of debt until they're fully recovered.
That's right.
Okay. So you didn't analyze a scenario in which the commission issues a disallowance of some or all of those costs?
No, I did not run a scenario with that.
Okay. Would you please turn to your rebuttal testimony to page 2, line 26? Please let me know when you're there.
Page are you on? There's not many here, so I can get that pretty quickly.
Sure. Page 2,
Okay.
line 26.
Okay, I'm there.
Okay. So if I understand this portion of your rebuttal, you're saying you don't have an opinion on whether PNM acted prudently in 2031 in extending its participation in Four Corners. Is that correct?
2013. Yeah, that's right.
Sorry, I misspoke. I meant 2013. Thank you. So did you read any of the evidence in this case and or the 2016 rate case concerning prudence?
Not closely.
Okay.
I'm generally aware that that is an issue in the case. There's several parties who have filed testimony on that issue, but was not in the scope of my testimony, so I didn't closely read the arguments on prudence.
Okay. If you turn to the next page of your rebuttal, you offer opinions on what the remedy should not be if the commission finds PNM acted imprudently, correct?
You're talking about the question that starts on line 9? And the
Yes.
answer that follows. That's just some considerations I put out for the commission to consider if prudence is at issue in this case, and the hearing examiner decides to determine some sort of reduction based on prudence, because there's a number of factors that should be considered. And I believe one of the parties recommended full disallowance, which, in my opinion, seems excessive, given these investments were made several years ago and will continue to be used and useful, and customers are, receiving power from the facilities. So I laid out just a few considerations that the commission may want to take in if prudence is determined to be found in this case.
Prudence reviews are, by definition, conducted after a utility has made an investment, correct?
Correct.
Okay. So isn't it true then that in general, when a prudence review is undertaken, the utility's customers have been receiving service from the investment that is the subject of the prudence review? Is that accurate?
I think that's generally the case, yes.
Okay. So I'm trying to understand your argument. Wouldn't your argument categorically rule out a full disallowance as a remedy in any prudence review?
Generally, yes.
Okay. Did you review any New Mexico law on the appropriate remedy for imprudence before you filed your testimony?
I did not.
Okay. Thank you, Mr. Batts. Thank you, Mr. Hearing Examiner. I have no further questions.
Thank you very much, Mr. Gerhardt. Mr. Botts, let's see, I believe that we have Water Utility Authority has requested 15 minutes with you. Is that correct?
That's correct, Mr. Hearing Examiner. I don't believe it'll take that long.
That's fine. Please proceed, Mr. Harris.
Okay.
Thank you.
Good morning, Mr. Botts. My name is Dale Harris. I represent the Water Authority. It strikes me upon reading the various expert testimonies in these cases that the analysis of benefits is an art as well as a science. Would you agree with that?
No, I think it's really science.
Well, the various experts in this case use different models, reach different conclusions, put emphasis on different elements. Isn't that correct?
There are differences in opinion and differences in approach and methodology, yes.
Okay, and that was what I was meaning by the art is what factors to select and how to do the analysis. But turning to your testimony, direct testimony on page 9.
Okay, I'm here.
Okay. On table 1, you have, I guess this is a proxy replacement portfolio, and you have an all gas scenario. Correct?
That's correct.
Okay. And what you show here is an incremental capacity that you used of 167 megawatts, correct?
That's correct.
Okay, and that 167 megawatts is based upon, I guess, the forced outage data that you collected from PNM that you discussed with Mr. Albright this morning, correct?
That 167 megawatts is just based on an equivalent megawatt for megawatt replacement of Four Corners with a CT with the adjustments that are in PNM's IRP.
Okay. And where I'm leading with this is that when Mr. Phillips did his analysis, you're familiar with his testimony, correct?
Yes, sir.
Okay. In his testimony, for his replacement portfolio for the time period of the Four Corners and Palo Verde, he came up with 360 megawatts of replacement capacity in his technology neutral scenario. Is that correct?
You're referring to his testimony in this case or his testimony in the Palo Verde case?
His testimony in this case, his direct testimony at page 27, he had a table NLP-1 that shows Palo Verde. He came up with.
I'm familiar with that table, and yes, I mean in that table he shows the replacement resources for Palo Verde and Four Corners in one table. So it's a bit difficult to tell which resources he's assuming would replace what capacity. So that's why, I mean, you can see here actually this table that you're referring to in my testimony, there's 11 portfolios we looked at.
Right.
And 2 of them are based on his table, NLP1 tech neutral, NLP1 renewables. And I did best I could to back out what had been proposed in the Palo Verde case with, what Mr. Phillips had shown in that table to determine what was being assumed to replace Four Corners in this case. We had asked PNM to explain this several times and they wouldn't. So that this is as close as we could get to backing into these numbers. And that's why we also looked at 11 different scenarios too, to get a full idea of what is possible and what the potential effects were.
Well, and the only reason I'm pointing this out is not to say anybody is right or wrong. It's just, it seems to me that different methodologies lead to different results. And in this particular case, when Mr. Phillips was doing his analysis for the replacement capacity on that neutral proxy in the time period of replacing Four Corners and Palo Verde, he came up with 360 megawatts, and there's 200 megawatts of Four Corners and 114 megawatts of Palo Verde leases, and the numbers don't really tie. And that was the only point.
I think that's a great question, and we tried to get an answer to that, and we could not, like I said. So we did our best and looked at a number of different scenarios to see what it could be.
Okay, and is it your understanding that in making a decision in this matter, the commission has to balance the interests of shareholders and ratepayers?
I think that the commission has to balance a wide variety of interests and consider in making any decision. And amongst those issues are the 2 parties that you just spoke about.
Okay, among the factors. And my question is, did you take that into consideration when you made your recommendations in your direct testimony of balancing the interests of ratepayers and
Yes, this
shareholders?
is Stephanie Zer. Just wanted to confirm the appointment you set up for me Thursday to replace somebody who had to cancel.
Ms. Zer? Hold on, I'm trying to find Ms. Zer on our roster here.
Yeah, you said September 9th, Thursday the 9th, I believe
sorry.
at 2.
All right, I'm sorry. Please proceed.
Okay. I have more of a sense of humor about this than the Herring Examiner does. This is just the what happens with these Zoom meetings. But at any rate, do you recall my question, Mr. Botts?
I do. You were asking if I considered the interest of the shareholders in my analysis.
Well, shareholders and balancing what the commission has to do when you make your recommendation. Was that a consideration of balancing interests in making your recommendation?
Not directly. I mean, the shareholders, the PNM filed this case, and our recommendation is to approve abandonment subject to the conditions I described and the adjustments I described. The adjustments are clearly not going to be supported by the shareholders. But I think that, what we have put together and proposed in this case is a good balancing of interests, and I think it's the best outcome here. I think abandonment makes sense in any case, really, that's on the table here. And it's really a question of, does this transaction slow or stop the closure of this power plant? And if the goal of ETA is to close power plants and reduce emissions, and an abandonment proceeding like this one puts forward a bunch of contracts and agreements that would actually extend the life of a plant, then it may not be in the best interest. So that's why we supported or propose this position where we support abandonment. The economic analysis makes sense. Customers are way better off under abandonment, but also with the caveats that the language in the transfer agreement should be struck that extends the life, and the seasonal operation agreement provision should also be struck because they extend the life.
Okay, I understand that. Thank you, Mr. Botts. I have no further questions, Mr. Hearing Examiner.
Thank you, Mr.
Thank you,
Harris.
Mr. Harris. Thank you, Mr. Harris. Mr. Botts, I just have a quick question. You said during your testimony that I believe maybe in response to Mr. Gerhardt's question, that you recommended rejection of the purchase and sale agreement, but that's not what you recommend, is it?
Well,
is it?
So it kind of, that boils down to a bit of a legal question, because I think PNM in this hearing has made clear that the commission does have authority to approve or disapprove of this purchase and sale agreement. And at the time that this testimony was drafted, I wasn't sure if that was the case. So the language in there is about, assuming the PRC has the authority, approve the agreement if these provisions are struck. But really, it boils down to the abandonment. And if the language is kept in the purchase and sale agreement that is in there currently, that would potentially extend the life of the plant. And if the language is kept in the seasonal operations agreement and associated updates to those agreements, then we would not support abandonment.
Because of the seasonal operational agreement.
Correct.
Or the seasonal operation agreement. But you contend that the seasonal operation agreement effectively extends the life of the plant?
That's correct. Because it really turns what is currently a 24-month clock into a 48-month clock for the parties. Once they vote unanimously for early closure, this clock starts for all parties to exit the coal supply agreement without penalty. And it's currently 24 months. And now with the seasonal operations agreement, that turns into a 48-month agreement. Years 3 and 4 have $200 or $100 million penalties that would be paid to NTEC. But in my mind, that's a large enough number that it could sway the analysis one way or another into keeping the plant open longer.
It couldn't, or it could?
It could.
But couldn't you see the $200 million payment, or alternatively the $100 million payment to NTEC as an inducement to early closure, arguably?
I don't think so. I think that it just adds dollars into the economic analysis for closure that weren't there before.
You said you were involved in you're familiar with the Arizona Corporation Commission proceedings?
I was a party of that case, the last APS rate case, and I was also a party of the previous Tucson Electric Power rate case.
Does Arizona have a provision for securitization of analogous to in the ETA?
Currently, they do not, but from my understanding, there's draft language floating around for legislation that would be introduced soon. But they currently do not have any securitization mechanism.
And how is the process going with the abandonment of the Navajo generating station in Arizona?
I haven't followed that, so I can't answer that question.
So you don't know if there was any provision there for payments to the Navajo Nation or funds for to deal with the economic impacts of the closure of that plant?
I know that in the order, I don't remember the exact amount, but I know in the recommended opinion from the ALJ in that case, or administrative law judge, there was some dollars that were approved for, they're calling it just and equitable transition. And I think that's related to the Navajo generating station closure, but I don't recall the exact amount. And I think that is still, there's a lot of activity between a recommended order and a final order in Arizona. There's a couple open meetings, and then the commissioners will generally put forward amendments. So I think there's already been amendments proposed that would reduce that amount or change the burden of who is going to pay it between the company and customers.
So I have one more question. It's regarding the reversal of the impairment loss, that $27.9 million reversal. How do you respond to Mr. Baker's rebuttal testimony on page 4 that the unamortized impairment, which is required under GAAP accounting principles, he says, it's the middle of page 4, will have no impact on customers because it will not impact the amount of undepreciated investments to be recovered through securitized financing as ETCs or energy transition costs. How do you respond to that assertion?
Well, what Mr. Baker is saying there is that those dollars, the plant balance dollars, are being collected in rates, which I don't dispute. And that if those dollars were rolled back into the securitization balance and customers were to pay that, there would be no increase in rates or charges to customers that are currently on the books. And to me, that's a side issue. Mr. Baker is just trying to make it more palatable to the commission. If these dollars are rolled back in, to say, look, if they're rolled back in, there's no increase in cost for customers, which may be true. But in my mind, that's not the question. The question is, what are the appropriate costs to include in securitization? And those dollars were not in the net book value for this plant on all the company's books and records on file in this commission, Federal Energy Regulatory Commission, and the SEC. So I mean, while what he's saying may be true, I don't think it matters. I don't think it's the right question.
I understand. Okay, Mr. Botts. Thank you very much for answering my questions. Ms. Beatles, do you have any redirect?
Thank you, Your Honor.
Yes, I have a couple of questions. Mr. Botts, if that impairment amount was added to the net book value, you just said it wouldn't increase rates, but would it increase the energy transition charge?
Yes.
And with respect to questions asked by Mr. Gerhardt on your recommendations regarding commission action.
Well, Ms. Beatles, can I just pause you there? I want to, that's why I wanted to go back to, you're saying, Mr. Botts, you're saying that yes, it would increase the securitized amount, but that's directly contrary, isn't it, to what Mr. Baker, I just want to understand. That's why I'm pausing the redirect, and I'll add back your time. But that seems to contradict what PNM is saying in Mr. Baker's rebuttal testimony. Please explain.
Well, what Mr. Baker is saying is that in accordance with the commission order in 2018 on the 2016 rate case, the company was allowed to recover that plant balance in rates. And I don't disagree with that. So those dollars are currently in rates with a debt only return. But then, and they would be in rates until they're fully depreciated, which is probably another 10 years. But then the next question is what cost should be securitized? And you have two scenarios. One scenario where the company continues to collect that plant balance and rates with a debt only return versus a scenario of securitization where you're trying to determine the securitization balance. If the ETA is followed as written and the balance is based on that January 1, 2019 net book value for that plant, then the securitized balance would be reduced by the 27.9 million that Mr. Baker is suggesting should be added back in.
And he adds it in after the fact, according to you, based on GAAP accounting, following GAAP accounting principles.
That's correct.
It's an after the fact adjustment, you're saying, or after, and he's saying that it's required by the modified revised stipulation, paragraph 8.
That's right. I think Mr. Baker said it would be added in after the abandonment, before the securitization. I think that was the timing he walked through in his testimony last week.
Right. All right, Ms. Beatles, yeah, add back your time, but I wanted to try and nail down that point from my understanding. So thank you for your indulgence, Ms. Beatles.
Oh, of course, it's important. So with the questions by Mr. Gerhardt regarding your recommendations to the commission about how to manage the NTEC sale agreement, I mean, what was your ultimate conclusion about, in your conclusion, what was your ultimate recommendation about how the commission should manage any action or approval on that NTEC sale agreement?
Well, as I noted in the testimony, it's about whether or not the commission has the legal authority to request changes to the agreement or deny the agreement. What that means for abandonment, it's hard to say. And that's why, I mean, the better recommendation would be did not approve abandonment subject to the changes in those two contracts, the purchase and sale agreement and the seasonal operations agreement, because as they're written now, they're not in the public interest.
Were you suggesting that the commission amend the agreement directly, or that PNM file an amended agreement?
PNM should file an amended agreement.
Okay, I have no further questions. Thank you.
Thank you, Ms. Beatles. I have one further thing I'd like to take up with Mr. Bott, so hang on with me, Ms. Beatles. Again, going back to your experience with the Arizona Corporation Commissioner, Mr. Bott, we're about to hear a lot of discussion of potentially what the other co-tenants in the Four Corners Power Plant, such as APS and TEP, their decisions on continuing and making capital investments, like for instance, the SCR in the Four Corners Power Plant. And you say you're familiar with ACC proceedings, right?
Yes, sir.
And it is true. Do you recall Mr. Fogren's testimony at all? Did you read his testimony regarding the different interests of the different co-tenants and continuing and the interest in continuing at different levels and for different periods of time?
I generally remember that, yes.
Have you seen any indication at all? Well, first off, do you disagree that Four Corners Power Plant may be more important in terms of a reliability perspective for the likes of APS, the operator, and TEP than it would be for, say, PNM?
I think it's a big issue for APS. APS owns over 1,000 megawatts of that plant, and they rely on it quite a bit.
They have,
TEP is a much smaller share, but they're a smaller company too, so.
but TEP has expressed an interest in apparently continuing until
They have.
2031.
Yeah, I mean, in Arizona, publicly, all the utilities, SRP, TEP, and APS, have been very public that they plan to continue the plant through 2031. There has been extensive discussion and back and forth through the IRP process, even through the energy rules negotiations, and in the last APS rate case about early closure of that plant. And, parties seem to be very focused on the dates of, 2026, 2027, which is, why we focus on that provision in the NTEC transfer agreement about early closure. Because the reality of this plan is that it's just not economic. It produces power at a cost that way exceeds most other resources and market prices. So eventually these utilities are going to need to get out of it to save ratepayers money. And there's a lot of pressure on APS now to publicly do so.
Earlier than 2031.
Earlier than 2031. And again, a lot of the discussion is focused on 2026 or 2027. But, there's a lot of things that need to happen between now and then. There's no securitization law there. APS has substantial investment in this plant. And they were just disallowed, I think, nearly $400 million for their SCR investment, which I assume they would appeal. So there's a lot of factors in play. And for APS to, for the timeline of this, so for APS to really replace their share of Four Corners is going to take several years. I mean, they would need to initiate the process now, get responses to RFP, evaluate them, file another case with the ACC, which would take probably a year and a half, and then build those replacement resources, which again are over 1,000 megawatts. APS's system is growing, so they may want to even put more capacity online than the 1,000.
Okay. Since I opened that discussion, I think it's only fair to allow PNM. Do you have any questions on that, Mr. Gifford?
No questions, Your Honor.
Any redirect? I'll allow Mr. Gerhart who may have an interest in this. Do you have any questions on that?
No questions, Mr. Hearing Examiner. Thank you.
Any final redirect, Ms. Beatles?
No, thank you.
Okay. Mr. Potts, thank you very much. I appreciate your testimony.
Thank you.
Very much. Thank you. You're excused. Yep. Okay, thank you. All right, let's do we have we probably have a changeover now in attorneys. Is that right, Mr. Gifford?
Yeah, I think we need to get Mr. Graves set up, Your Honor, which should take just a few moments, but if we want to take a quick break.
Let's take 15. Let's go ahead and just take our 15 now and start up. Let's start up at 10:35, actually, if that's all right. 10:35. It's 10:17 now. All right, thank you. We'll see you at 10:35. Good morning, all. We're back from our mid-morning break. Up next, we have PNM's next to last witness, I believe. Mr. Gifford, is that correct?
That is correct, Your Honor. PNM would call Frank Graves as its next witness.
I'm here.
I'd ask that the witness be sworn, Your Honor.
Yes. Mr. Lee, please.
Would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter and opinions be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
Good morning, Mr. Graves. Could you state your name for the record?
Certainly. Frank, middle initial C, last name Graves, Graves.
And Mr. Graves, who do you work for and what do you do?
I am a principal at the consulting firm, the Brattle Group, where my office is located at our headquarters, which are in Boston at 1 Beacon Street.
And Mr. Graves, do you have in front of you what's been pre-marked as PNM Exhibit 16, the supplemental testimony of Frank C. Graves?
I do.
And do you have any corrections to that testimony?
I do not.
And if I asked you those same questions contained in that pre-filed testimony here today, would your answers be the same?
They would.
Your Honor, I'd move admission of PNM Exhibit 16.
Any objection? Hearing none, PNM Exhibit 16 is admitted.
And Mr. Graves, do you also have in front of you what's been pre-marked as the rebuttal testimony of Frank C. Graves?
Yes, sir.
And you prepared, or it was prepared under your direction, is that correct?
Yes, it is.
And do you have any corrections to that testimony?
I do, a minor one.
Please.
On figure 1, which is on page 18. Sorry, not page 18. Yes, page 19, at least the way they printed out for me. The savings that were initially entered as 42.2 million should be 40.1 million. And any other references to that in the text should be also 40.1.
And those corrections have been made in the version uploaded into Dropbox. Is that correct, Mr. Graves?
That is correct.
And with those corrections, do you have any other corrections to your rebuttal testimony?
I do not.
With those corrections, Your Honor, I would move the admission of PNM Exhibit 17.
Any objection? PNM Exhibit 17 is also admitted.
And finally, Mr. Graves, do you have in front of you what's been pre-marked as PNM Exhibit 35, the sir rebuttal testimony of Frank C. Graves?
I do.
And that was filed just last Friday, if I'm correct, Mr. Graves. Is that correct?
That is correct. Yes, the 3rd of September.
And that testimony was prepared by you or under your direction. Is that correct?
Yes.
And do you have any additions or corrections to that testimony?
I do not.
With that, Your Honor, we would move admission of PNM Exhibit 35, the sir rebuttal of Frank C. Graves.
Any objection? Hearing none, the sir rebuttal testimony of Frank Graves, PNM Exhibit 35, is admitted.
With that, Your Honor, the witness is available for cross-examination.
Thank you, Mr. Gifford.
Mr. Hearing Examiner, this is Ms. Zurheer.
Yes, ma'am. Hi.
Yes, just to let you know, I'm waiving my 5 minutes so that there won't be any lag in getting the next attorney up for cross-examination.
Okay, thank you, Ms. Zurheer. So before we were to get there, we have 15 minutes with Bernalillo County. Mr. Albright, do you have cross-examination of Mr. Graves?
Yes, Mr. Hearing Examiner, I do.
Okay, please proceed.
Thank you. Good morning, Mr. Graves.
Hello, Mr. Albright.
I'm with J. Albright Law LLC, and I'm here on behalf of Bernalillo County this morning. I would like you to turn to your supplemental testimony at page 7, please. And again, given all the time by other attorneys here, it might have, most of my questions may have been answered had I gone last instead of first, but we'll try to make do. I'd like to call your attention to lines 14 through 17. And specifically, this addresses the NTEC agreement. And let me just read there, and then I have some questions for you. At line 14, it states, under the agreement, comma, NTEC would also assume ongoing fuel, operational and capital costs. In exchange, PNM would pay NTEC $75 million for a portion of its previous future cost obligations under the CSA, which will be borne at shareholders' expense. Have I quoted that correctly, Mr. Graves?
You have.
Okay, so I'd like you to explain what the portion of its previous future cost obligations includes.
I can only answer that at a general level, as I wasn't privy to these negotiations or transaction process. But my understanding is that that effectively marks the CSA contract to market for the intended future use, and it may include some other costs as well. But it's basically an adjustment to the fuel contract.
Okay, but this is your testimony here, correct?
Of course, yes.
Do you know if that would cover decommissioning and reclamation costs?
I don't know again how it was earmarked. I understand that it helps suspend all future obligations after 2024, which could well include those items, but I don't know that that amount was specifically targeted at those expenses.
Okay, I'll move on. Turn to page 44, please, of the supplemental testimony.
Sure.
Are you there?
Yes, I have it.
Okay. Toward the bottom, you discuss some expected load increases and some change in load increases. And specifically at line 16, you state that PNM's reserve margin would fall to 7%, well below the required margin. What is the required margin for PNM?
It has been evolving. My understanding is that it was, they used a 13% planning reserve margin until recent studies indicated that with declining depth of supply in the Western market generally, and with increasing reliance on renewable resources, they're going to have to boost that up to, I believe, more like 18%. But at this time, it would have been 13%.
So it's your position that 18% is an adequate reserve margin?
Oh, it's not a topic I have studied specifically. I'm aware that that is the, I believe that's the number that's being used as the target in the most recent resource planning studies.
Do you know what the projected reserve margin is for 2022?
I do not.
Okay. And would you turn to page 57 of your supplemental testimony, please?
Okay, I have it.
All right. And at line 14 through 16, you state, if it were a per se bad plant, the majority of the co-tenants would not have decided to continue in the plant. And in fact, the other owners are still indicating that they will continue to rely on the plant until 2031. Have I quoted that correctly?
Yes, you have.
Okay, and so I want to make reference to footnote 60 that you have at the bottom there. That, and I'll just let you read it, but you don't need to read it out loud, and I'll just ask a couple of questions.
Okay, I reviewed it.
Okay. States there that FCPP is more economical, more reliable through 2031 than shifting to a portfolio of over 2,000 megawatts of solar, wind, and storage that would be required to replace it earlier. Do you see that?
I do.
Okay, then you go on to state this does not indicate that let me start over. This does not indicate that that is also true for PNM, as each system is different, but it does show that the plant is not intrinsically uneconomical under current circumstances. Have I quoted that correctly?
Definitely, yes.
All right, so why is it not true for PNM?
Well, PNM has recently completed studies showing that moving away from FCPP is going to save money in 98% of many scenarios that they've analyzed, recognizing the specific characteristics of their system, as to whether it needs capacity or energy and what the economics of the resources that it has. So those are idiosyncratic to an extent to each utility, and the observations here were about APS, not about PNM.
I understand that, but I'm looking for what the main differences are between PNM's reliance upon solar, wind, and battery storage. I assume that's battery storage there, and other facilities, as opposed to APS. If you're not in a position to comment on that, that's fine.
I don't have a very specific way of characterizing the differences. There are different environmental expectations in New Mexico than Arizona, for instance, and those may have entered into the findings that moving more towards renewables is preferred in New Mexico than it is in Arizona. But I haven't studied the APS decision closely.
Would you turn to page 5 of your rebuttal testimony, please?
Sure. Sorry, I have to open it.
And at line 4, are you there?
Not quite, almost, sorry.
Okay.
I actually have a paper copy, but it's so small to read that I'm moving to my electronic copy. Page 5, I have it.
Okay. At line 14, you state, importantly, PNM has recently made other changes in its planned duration of commitment to FCPP in order to achieve significantly reduced future costs, thereby mitigating some portion of the potential consequences of that prior plan, even if it was ill-chosen. Do you see that?
I do, and you have read it accurately.
Isn't it true that PNM's early exit in FCPP is an attempt to avoid a finding of imprudence?
I've certainly never seen it characterized that way, and I would argue that that would have been a poor perception of the optics of that decision if they were thinking about it that way, because it in fact triggers questions about why a resource is being abandoned that was previously deemed attractive. So if anything, it would, I think, garner the opposite kind of attention rather than prove that it was prudent.
But isn't it also true that by abandoning FCPP, your reserve margin is going to go down, at least in the near term?
Not having it, everything else being equal, certainly would lower the reserve margin. Of course, they are anticipating replacing it with many possible slates of resources that will attain capacity adequacy.
4 minutes, Mr. Albright.
Thank you, Mr. Hearing Examiner. Could you turn to page 9, please, of your rebuttal testimony?
I am there.
And this may be addressed in greater detail by Mr. Fisher later on, but I'd like you to look at line 5 and 6 on page 9. You state, again, I concede that some of the omissions in the May 2012 study were material and should have been considered at the time. I'd like you to elaborate on which omissions you believe were material.
Certainly. The first half of my supplemental testimony responded to several criticisms that were raised later on, to the effect that capital expenses were omitted for the plant that should have been recognized, and I agree with that. I made a handful of calculations there that corrected for those expenditures the corresponding expenditures that were omitted on a gas CC, the difference in timing between when those expenses would have been avoidable versus otherwise unavoidable, and I believe also decommissioning expenses that would have been incurred. So all of those were several millions of dollars, certainly worthy of recognition, and that's why I corrected for them in my supplemental testimony.
Hey, Mr. Graves, I'd like you to turn to your sir rebuttal testimony at page 3, please.
Okay. Sorry, this will take me a minute to pull up. Okay, page 3, I have it.
All right, and toward the bottom, you state the resource mix I have chosen is one very responsive to the desire to soon have cleaner renewable resources for FCPP's replacement. which I have evaluated at costs generally consistent with recent market prices. Do you see that?
I do.
Okay, and what do you mean by the phrase generally consistent with recent market prices?
It's my understanding that purchase power agreements with solar facilities have been being marketed in the Southeast in the $20 to $25 per megawatt hour range recently, which is the cost I assume for the solar replacement portion of my.
I'm sorry, $25 per megawatt hour.
Yes, which is the cost I apply, $25 is the cost I apply to the solar replacements in my simulation.
With respect to those solar replacements, hasn't there generally been a delay in delivery with regard to solar installations? If we're talking recent market trends, hasn't there been delay in solar delivery?
I believe there have been some kind of generalized supply chain frustrations, probably mostly due to COVID, but I have not made a study of how those have impacted PNM or the Southwest, or how large they are in.
So you have no idea whether, I'm sorry?
Or how large they are in specific circumstances. Of course, these replacements would be for 2025 and beyond. So there's some time to deal with, lagged supplies here.
Mr. Albright, time's up.
Thank you very much, Mr. Graves, for your answers this morning. And thank you, Mr. Hearing Examiner.
Thank you.
Thank you. Thank you, sir. I'm sorry to cut you off, but we have so much to get to with Mr. Graves.
Understood.
Thank you, sir. Okay, up next we have Ms. Namazi, 60 minutes with Mr. Graves. Is that correct, Ms. Namazi?
Yes, thank you.
Please proceed.
Good morning, Mr. Graves.
Hi.
Would you mind going to your rebuttal testimony? And could you please go to page 7? And I'm looking here specifically at lines 1 and 2. And the last full phrase here says, the most important consideration is whether or not PNM conducted a thorough, which you have in quotes, analysis at that time. Do you see that?
I certainly do, yes.
But this is not a debate about the thoroughness of PNM's analysis. It's a debate about whether the analysis was an honest evaluation and if it was performed in a contemporaneous time period. Is that correct?
Well, those are certainly allegations that couple with the observation that the analysis was incomplete compared to normal analysis, and that may have reflected in the views of interveners a bias or indifference, I guess, to updated information. I do not read the history that way, but that could be the perspective of some.
Excuse me, I didn't mean to interrupt. Well, you know that this was not just interveners' response or analysis, but it was the hearing examiners in the 16276 case, as well as the commission, correct?
I guess your question is a little vague as to what this is that was being alluded to there, but all of them certainly agree that the early analysis was inadequate and had flaws in it. I don't recall them going to a statement that it was deliberately biased or willfully incomplete.
We'll get to that in a minute, but let me just ask you also to go to the same place that Mr. Albright questioned you about on page 9 at line 5 and 6. Here you say that, again, that you can see that there were omissions in the May 2012 study that formed the basis of PNM's decision to extend the life of the plant and invest further, correct?
You're paraphrasing my discussion in sort of lines 6 through 10. Am I correct?
Yes.
Sure, I'm acknowledging that there were omissions, but that they were in fact bigger than and different than those that were the immediate source of criticism from Ms. Crane and to some extent from the hearing examiners at the time, in that there were additional missing expenses, and some of the expenses that were missing were not in fact avoidable. So they were somewhat mischaracterized by the early reactions to them.
Okay, we'll get to that in a minute, and I appreciate their response. Let me ask you something. Have you ever bought a house, Mr. Graves?
Yes, I have a couple of times.
Did you have a realtor?
Yes.
Did the realtor show you one house or many houses?
Many houses.
Mm-hmm. And the realtor had you perform an inspection to determine if there were any major flaws with the residence, correct?
Yes, we certainly did that.
He or she did this to ensure that you weren't overpaying for the property. Is that true?
I guess that's a fair characterization. Yes, to see if it needed any additional work that would adjust the purchase price.
Correct. There's a colloquial term for this kind of due diligence. It's called comps, right?
Actually, it's not a term I'm familiar with, but I'm curious what it stands for.
Does it mean when the realtor showed you the different houses and also asked you to perform an inspection, that was to see the comparable price, the price you were paying or you might be paying in comparison to both other houses and the value of the house you were seeking, correct?
I can see where that information is useful. I don't, in fact, think that's the purpose of the inspection. And in fact, the realtor didn't provide us, never provided me anyway, with comparables. We looked at other houses that might be interesting in other ways, but we never had a point where we got to the end and said, okay, here's this one, and now here's 5 comparable things for you to validate the price against. That has not been my experience.
And when the realtor showed you those other houses, he or she showed you those other houses that were on the market, correct?
Of course. Mm-hmm.
And you say, of course, and why would that be an of course answer?
It would be a bit presumptive to try to buy a house that wasn't on the market. So they stuck to the stuff that was available.
And they wouldn't show you a house that was on the market a year and a half beforehand, would they?
Not unless it was still on the market.
Because that would be crazy to do so, because that would be stale information that would not be useful, correct?
Well, I don't want to get too much into the weeds of how real estate is sold, but in fact, we were told about the prices of houses at past times, including ones we looked at to see whether they were moving up or down and whether the seller was desperate, that sort of thing. So it's not uninformative, but it's not sufficient for making a decision.
So you wouldn't tolerate information on houses for sale a year and a half before. Are you suggesting that ratepayers should tolerate information from a financial analysis that was done a year and a half prior to the time of actual decision making?
As a general rule, no. The updated information is, of course, very helpful. There are practical limits to how much it can be updated and practical limits as to when it is necessary, according to whether more things have changed in one direction than another. If several things have changed, but some are positive and some are negative, it may not be so important. But in fact, the whole purpose of my supplemental testimony was to fill in some of those gaps that would say if PNM had updated its information, would it have reached a different conclusion or not? And I think they would have reached the same conclusion.
Did you, when you did your post hoc analysis, did you use strategist?
I did not. I used some information from strategist runs, but not the model itself.
And you know that the single strategist run from May 2012 was the basis that PNM stated was for their decision to continue investment in Four Corners.
I can't remember whether it was one run or more. I believe it was more, but it's certainly true that they were relying on findings from May 2012 that were hosted by strategists.
I stand corrected by your answer. It was about 4 runs that, but it was one analysis, one strategist analysis. Is that correct?
Sure, that I'm willing to call it one analysis.
Okay. On page 8, line 1, you say that.
Sorry, of which report?
Rebuttal, same thing.
Okay.
I'll let you know. Thank you. If we move off of that.
Okay.
You state here that there may have been no harm whatsoever. Do you see that?
I do.
Has your focus been entirely on financial assessment of harm?
Numerically, the only measures I have looked at are costs that would be incurred by ratepayers. So in that sense, it's all financial. On the other hand, the circumstances I'm studying and comparing also consider things like reliability and so on in the alternatives.
Sir, do you believe that we are experiencing a global warming crisis that has had and is having massive consequences for the United States and the world?
I certainly do.
Did you read the front page of the New York Times on Sunday that stated that there has been $450 billion in damages nationwide since 2015, and that the number of disasters causing more than $1 billion in damage reached 22 last year, which was a record?
Your Honor, I'm going to object that this is improper questioning. There's no foundation, and that Ms. Nanasi is testifying.
Overruled.
I did not read that article, but I'm aware that that is a general perspective on the consequences of global warming, and I have seen similar data in other sources.
Do you know that when El Paso Electric announced that it would exit Four Corners, that almost caused the Four Corners power plant to shut down?
No, I can't speak to the organizational consequences of that.
Did you read, what did you read in preparation for your testimony?
Well, many documents. I don't know that I can enumerate them all. Certainly the IRPs of the company over the last 10 years, the specific studies that were done for Four Corners, the intervener testimonies, of course, the hearing examiner's opinion, Testimonies of other PNM witnesses, especially Mr. Phillips. And various source documents that underlie the planning studies that PNM did and that that also were necessary for my supplemental work, like load forecasts and gas price outlooks and things like that.
And did you use, let's say, load forecasts from the 2016 rate case?
I don't recall specifically using that. And the bulk of my focus is on the May 2012 through end of 2013 time period as to what was evolving in market conditions at the time and what would have been believed or understood about future costs. So I don't do very much reassessment of the 2016 perspective.
What do you mean by that last statement, that you didn't do any or much reassessment of the 2016 perspective?
Only in my SIR rebuttal testimony have I re-evaluated what happened historically from 2012 to the present, and then extrapolated that onward. So that would have included actual loads, actual gas costs, and so on. But that's the extent of my analysis of 2016 and 17 market conditions.
Did you look at the exhibits from the 2016 rate case?
I may have, I don't recall them specifically right now.
And did you read the emails between El Paso Electric and the other co-owners from that time period, specifically from in the 2013 period, that the last 6 months of 2013?
I did not.
What was EPE's share percentage ownership?
Of Four Corners?
Yes.
I believe it had 7%.
And if PNM had stated that it would, that it wanted to exit at that time in 2013, and you added PNM's share, which is 13%, and EPE's share of 7%, that would have equaled 20%. Do you think that that might have ended up closing the plant?
It's a pretty speculative question, but I would guess probably not. APS still had a much larger stake and a larger previous finding of benefit from retaining its involvement. It did absorb the EPE share, and whether or not there was a tipping point there from parties leaving would have partly depended on how much they could walk away from their ongoing obligations at the plant. If they were required to continue paying off costs unless and until a new owner was found or some other means of mitigating those costs, then it might not have changed the costs for APS very much. It would have just created a stranded cost for PNM and El Paso.
Well, do you know that during that last 6-month period in 2013, that Tucson Electric Power and SRP Salt River Project refused to take any more shares in the plant?
I did not know they had considered it, but I know they did not take any of those shares.
Do you know that PNM actually stated that if they would not take any further shares in the plant, that neither would PNM?
Sorry, can I hear the question again? It was a little obscure to me.
Did you know that PNM's position was if Tucson Electric Power and SRP were not in to sign the contracts that were pending, that PNM wouldn't be in either?
I don't know that I was aware of that, but it wouldn't surprise me. They would certainly want continued shared interest in the plant from the other owners.
Why didn't El Paso Electric exit the plant?
El Paso Electric did exit the plant. Do you mean?
Why did it do that?
Well, they had done a study finding that it was going to cost them more to retain an interest in it than not by, I believe, $100 and some million. That was a study, I believe, done around 2016 that updated an earlier finding that it was marginal as to whether the plant was worth having or not. They had already in 2009, I believe, started developing alternative peaker capacity or considering all peaker capacity as an alternative to their needs. And I think they felt that, they could get by with a more specific capacity resource than Four Corners.
Okay, we'll get back to El Paso Electric, but I would like to ask you to turn to page 10, please.
Okay.
At the top of page 10, from lines 1 to 6, you state here that essentially the hearing examiner's finding of imprudence was based on 2 reasons. One was ongoing capital expenditures, and the second one is a lack of an updated analysis, correct?
I do state that those were 2 reasons. I didn't mean to say those were the only reasons, but those seem to me to be important ones.
And let me ask you something. You read the certification of stipulation that the hearing examiners wrote in the 16276 case, correct?
Yes, I did.
And by my count, there's at least 9, if not more, other reasons that the hearing examiners gave for their finding of imprudence. Do you recall what any of those other reasons are?
It's been a while since I looked at that document, but I believe there were other concerns like declining performance of the plant, either in terms of availability or cost. I think there was a reference to the fact that other parties were considering leaving or had left their interest in their stakes in it, especially EPE. Those are the ones I remember right now.
Was it true that they found that PNM's description of its May 2012 analysis was confusing, frustrating, and at times contradictory, drawing into question what PNM actually considered?
Yes, that's a fair point. They certainly were also frustrated with the analysis itself.
And did they also find that despite, quote, forensic accounting, unquote, PNM's witness, Vice President of Generation Olson and Director of Planning and Resources O'Connell, could not accurately explain the documents that allegedly formed the basis for PNM's decision to reinvest in Four Corners?
Your Honor, I object. The decision speaks for
Overruled.
itself.
Well, apparently not. Or at least not fully. So we'll see where this goes, but overruled.
Understood.
I certainly accept that those are part of the hearing examiner's concerns. I hadn't recalled those, but they're of the family of concerns that the analysis was poorly done and presented.
And I think you mentioned unreliability and costs to increase performance. Is it also correct that co-owners were reluctant to invest in an unreliable plant, that there was uncertainty as the other co-owners were considering exiting the plant, and that maintenance had been deferred and quote, a lot of money would be required for capital expenditures to increase performance?
Are you referring to the hearing examiners now or PNM's conversations or what are we talking about?
The hearing examiner's rulings and findings about imprudence.
Yes, I recall that they noted there had been a decline in maintenance expenditures on the plant and that would have to be remedied.
And that it would be, a lot of money would be required to fix that.
That was the suspicion. I don't recall any amounts being tagged to that, but at least the possibility was raised.
And did they also find that there were dramatically increasing cost estimates for SCR pollution controls?
I believe that's correct.
Did they also find that there was no sensitivity analyses that were conducted?
Yes.
Did they also find that the 2011 and 2014 IRPs were not accepted by the commission and the cost inputs per metric ton of CO2 were inconsistent and failed to abide requirements set forth in case number 0600448 UT, and that if carbon costs were consistently applied, the strategist run would have favored PNM's exit from Four Corners?
I generally recall that conversation. I can't speak to the validity of the inference, but that I do believe that was part of the opinion.
Did they also find that the load forecasts compared to actual data in light of actual sales were overly optimistic?
I accept that. I don't recall that one.
And my personal favorite, Mr. Graves, because it took me tens of
Your Honor,
hours.
I'm going to object to the characterization of her own opinion.
Well, hold on. I'm going to allow you to make the characterization, but I'm not sure you want to, Mr. Nazi. Go ahead.
Okay.
I'm interested. I'm intrigued that you actually might want, I'm not sure you want to go somewhere, but I hope you're not going where I think you're going.
Okay, so sir, can I ask you to please turn to New Energy Economy Exhibit number 3, if you would.
That is going to take me a moment to accomplish here because I've had limited success getting onto the
Dropbox?
Yeah. Mr. Gifford, would this be in the PNM venue that we've been using to?
It would.
Yeah, Ms. Nanazi, this NEE3, the one that I have is dated August 27th, and it's not marked. Did you go back in and change it?
I believe it's marked at the top. It says New Energy NEE Exhibit 3.
Yeah, I may have not. I'll have to go to the Dropbox folder. I downloaded everything into my folders, so let me go in there as well. Go ahead. Don't let me hold this up.
Are you there, Mr. Graves?
No, I'm not. Sorry, I'm trying to get in, but it's not letting me in. I think I mistyped the password.
Yeah, the NEE Exhibit 3 in the Dropbox folder uploaded September 1st is properly marked as NEE Exhibit 3.
Sorry, I have to check the password here. I had opened this before, but it signed off. So let me. Okay.
Mr. Hearing Examiner, could you just note the time, because I'm really worried that I won't have enough time.
Noted.
Thank you.
Okay, I am in, and now if you can refer me again to the document that you want me to look at?
It's New Energy Economy Exhibit 3, sir. These are answers to interrogatories.
All right, it'll take me a minute to find that as well. Mr. Gifford, are you aware of which folder it's in our collection?
Yeah, it should be under the NEE, and we'll email it to you presently, Mr. Graves, to make it quicker and easier.
Okay.
And Mr. Graves, make sure you stay in the Dropbox folders for the remainder of your examination today.
Yes, sorry about that. I actually thought I was, but I guess it timed out or something.
Sure. Those things happen. I'll just add a few minutes to Ms. Nanazi's cross-examination now so that we don't have to
Sure.
go back and have any issues with regard to that.
Are you there, sir?
I'm sorry, so is this in your first discovery request or which one?
Third, NE Exhibit 3.
Sorry. PNM, nope.
You should have it now in your email to Mr. Graves. Sorry.
Okay, thanks. Let me use that instead because I'm hunting here and not very efficient at it. Thank you. There we go. Thank you. I've got it. Okay.
I've added, excuse me, Mr. Graves, I've added 4 minutes now. I've gone back and looked at real time where we started this dialogue and trying to find an AE Exhibit 3. And I've added 4 minutes to Ms. Nanazi's cross-examination to account for the delay. Okay, go ahead, Mr. Graves.
Okay, I have it open. What page do you want me to be on?
So could you look at page 4 of 6 and 5 of 6? And these are interrogatories that New Energy Economy posed and that you responded to. Do you see that?
Yes, at the bottom of 4 of 6 is the question to me, and then my answers on the next page.
And then there's interrogatory NE 3-5, 5 of 6. Do you see that? You also answered that question.
I do.
Okay, and then could you go to the very last page of that document, or almost the last page, and it says, second to last page, and it says here that you affirmed that the answers you gave on June 21st, 2021 were true and accurate, right?
Yes, I did do that. Mhm.
Okay, can you go back to page 5 of 6? And I'm going to read the question, and if you wouldn't mind reading your response. What does Mr. Graves believe is the significance of PNM Senior Vice President Patrick Apodaca's statement on December 18th, 2013, quote, among other things, maintaining our same level of ownership at Four Corners avoids a possible distraction with our BART, B-A-R-T, filing with the PRC next week and our negotiations with the owners at SJGS, unquote. And then it has a site, 16276 certification of stipulation, October 31st, 2017, page 51. Please explain in detail. And could you read your response, sir?
Yes, although all I have is the first sentence, apparently there's a confidential part that was flagged up, but the part that I'm responsible for is that Mr. Graves does not know the full context of that statement and cannot comment on its significance.
Did PNM show you the document that contains this statement?
I don't recall seeing it.
And did you read it in the certification of stipulation?
Presumably, yes.
But
I did read the certification, so I just don't recall it.
Okay. If PNM's reasoning for investing in the Four Corners plant was to avoid a possible distraction with the BART filing regarding the San Juan generating station, would you agree that that is not a justifiable reason for extension and investment in the Four Corners plant?
Well, if we interpret this meaning it's literally only the question of being distracted, sure, that would not be a good enough reason for saying we didn't look at other things. I would imagine the distraction is referring to the fact that
Your Honor, I'm going to object. This is
No. You're objecting in the middle of your witness's answer. Go ahead, Mr. Graves.
Thank you. I would interpret this as meaning that if San Juan was going to have to reduce its capacity or change its configuration to satisfy haze requirements and other environmental rules, that would change the importance of having Four Corners in the system and maybe made it seem less relevant to study downsizing Four Corners at that point.
Well, hold on, Mr. Graves, for the record, when you were talking about haze, H-A-Z-E requirements, right?
Yes, that's correct.
Okay, just want to make sure the transcript captures that.
Mm-hmm.
Go ahead.
For air pollution control.
Speaking of that, what were the environmental regulations at the time that PNM was concerned about regarding Four Corners?
I believe at the same time as it was evaluating what to do with San Juan, it had been deemed that SCRs were going to be necessary at Four Corners.
Anything else?
That's all I can remember.
And were there any other environmental regulations that PNM was concerned about during that time period?
Well, sure. Generally, I mean, there are ongoing criteria pollution rules and a variety of other emerging EPA regulations and possible CO2 regulations that might happen under the Obama administration.
And at that time, there was concerned about National Ambient Air Quality Standard, mercury rules, Clean Water Act, other things as well, correct?
Yes, many of them were ongoing, but some were being sharpened or reconsidered, mercury in particular.
Did PNM or PNMR advise the SEC, that's the Securities and Exchange Council, and Wall Street investors of the risks of environmental regulation and warn them that it might have an impact on the economic viability of Four Corners going forward?
I'm not aware that they did or didn't. I have not looked at their investor disclosures.
Did you see that as part of the exhibits that were that were included in the Four Corners 16276 rate case?
I do not recall them, certainly didn't review them.
Do you have access to Dropbox now, sir?
I'm in it, but I can't claim to be adept at it, but we could try.
Could you go to new energy exhibit number 30?
Okay, this is notes to consolidated financial statements, page 1 of 4.
Correct, thank you.
Mhm.
Could you read the 4th paragraph on the 2nd page, page 2 of 4? This was admitted into evidence by New Energy Economy. It was New Energy Economy number 7, and this was a response to a bench request in that case, and it was PNM Exhibit 7-25, bench request 5. Could you please read that 4th paragraph on B, what's labeled B93 at the bottom, but it's page 2 of 4 at the top?
Starts with the phrase, the Four Corners participants.
Please.
Your Honor, the witness has testified that he did not read this material as part of his testimony. I'll object to it being beyond the scope.
Is that required for cross-examination? And it was a document admitted in 16276, wasn't it? I may have been uploaded late, and so it may not be admitted, but it's appropriate within the scope of cross-examination. So go ahead, Mr. Graves. You might want to tee it up again, Ms. Nanazi, about where we are. It's Four Corners, paragraph B-93, and you have some highlighted language. Is that right? Highlighted in yellow?
Yes, sir.
Okay, go ahead.
Could you read that, Mr. Graves?
Certainly. The Four Corners participants' obligations to comply with EPA's final BART determinations, coupled with the financial impact of possible future climate change regulation or legislation, other environmental regulations, and other business considerations, could jeopardize the economic viability of Four Corners or the ability of individual participants to continue their participation in Four Corners.
So if it's correct that PNM Resources was advising the SEC and Wall Street investors about this possible risk, did you include in your analysis post hoc what the possible environmental regulations or cost risks were at that time?
So in my supplemental testimony, I did not consider alternative future costs for the SCRs, which would have been the BART technology there, I believe. So the answer is no.
But it would have been other things as well, because we didn't know at that time, as you already stated, what was going to happen with mercury, for instance. Is that right?
I think that's true. The mercury rules were still emerging at that point.
And that
I did look at CO2 variations as one of the items I considered in the supplemental report, but not mercury.
And what about coal ash, coal combustion residue? That was being also looked at by the Obama administration at that time. True?
I believe so. Yeah, that's an ongoing environmental issue at coal plants, and I was not aware of any sensitivities that had been identified around that, so I did not include it.
Sir, do you know that PNM's, let me just ask you, who was the chief negotiator for PNM during that 2012, 2013, 14 period?
in regard to, actually, I don't really know, but I assume you mean in regard to the contract extensions at Four Corners?
Correct.
Yeah, I don't know who was the key task manager for that.
Do you know who signed the contracts for PNM?
I don't recall.
How many contracts were up at that same time that PNM had to recommit to?
3 or 4 is what I recall.
Would it surprise you if the actual answer was 14?
I suppose not. I mean, the amount of nuance in these things can be quite high, and getting everybody's individual responsibilities specified is quite a detailed process. So there could have been a lot of subcontracts for parts of the bigger architecture.
Mr. Herringsheimer, how much time do I have left?
21 minutes. And I'll try to remember to give you the 5-minute warning.
Thank you so much. Could you, sir, go to Exhibit 19, New Energy Economy Exhibit 19? So we were talking about El Paso Electric, and you also talk about it in your testimony, and why they chose to leave. And I believe that you said that they started to perform some studies as early as 2009 to determine if staying in Four Corners was going to be useful to that electric monopoly in New Mexico.
Oh, I'm sorry. Can you restate that? I was trying to double task here and find your exhibit at the same time as I was listening to your question.
We're all doing that.
And Mr. Nazi, could you identify this document?
Yeah, I haven't started asking about it yet, but I will.
You might want to get there because you're going to run out of crossing.
Was it Exhibit 3? I'm sorry. What did I have?
Exhibit 19.
19.
Exhibit 19. Okay.
Which is the certification of stipulation in El Paso Electric's abandonment and sale of its 7% ownership in Four Corners, Unit 4 and 5.
Yes, I have it now.
And could you please go to page 16?
Hold on. Okay, I have it.
Have you ever reviewed this document?
I have not.
I think you said before that your understanding was that El Paso Electric began studying the exit of Four Corners somewhere, and I don't recall what your time period, you said 2008 or 2009?
2009 was my recollection, but certainly before this time period.
Okay, and if you could look at this document and read what you see, that part in the middle of page 16 where it says EPE's economic analysis supporting exit decision.
Yes, at Roman 6.
Do you see here that EPE did conduct a life extension project analysis?
Actually, I kind of read it differently than you. It says that they had chosen to not participate in a life extension project. Presumably because they had found that they didn't have an ongoing interest in it.
And what are the things that, if you could read the factors that they considered as to why they didn't want to continue in Four Corners? Could you just read into the record the different factors that they included in their consideration?
Sure. There are 4 of them listed on that page and the following page. The first one says, factors considered include number 1, economic analysis by EPE. I'll paraphrase a little, showing no clear advantage to continuing with Four Corners versus alternative generations based on future costs, essentially. Number 2.
Those costs, if I could just interrupt you, those costs included future capital and operating costs, cost to install SCR to comply with existing environmental regulations, correct?
Correct, yes. Sorry, I didn't know if you want me to literally read them all, I can, or I was trying to condense them a little bit for you.
I think that would be great.
The second is about risks associated with those potential future environmental regulations and potential litigation if they were a co-owner, which they say favored alternatives to coal-fired Four Corners. The third is the addition of locally located generation capacity that EPE has built that will allow them to have reliable service absent Four Corners. I believe these are the peakers I mentioned that they started evaluating around 2009, although it doesn't say that there. So they had a replacement already for reliability. And number 4, after Four Corners, the company, meaning El Paso, had added an increased share of ownership in Palo Verde nuclear plant, which gave them baseload generating resources and fuel diversity. And they had contracted for 100 megawatts of solar PV generation. So apparently those, coupled with the peakers, gave them a sufficient system.
And then if you go down a couple of lines past that, it says here, does it not, that these risks not only included the potential for increases in cost to comply with environmental regulations, but also included the financial and legal risk of having to shut down the plant prior to the end of the proposed life extension. Do you see that?
I do. You read it accurately.
In everything that you saw from the prior case, is there anything that PNM produced in testimony that says that they considered the potential cost risk of possibly having to shut down the plant prior to the end of the proposed life extension of Four Corners?
I'm not aware of anything specific. In their 2011 IRP, they did consider what would be the system consequences of getting out of Four Corners and most of San Juan prematurely at the end of their current contract periods, and decided that that was more expensive than staying with them. But it was not an alternative shutdown date. Those were just contractual endpoints that they considered.
Could you go back to your rebuttal, sir? And I'm asking you to look at page 11, line 5.
Page 11. Almost there.
So
okay.
Here you're talking about that certain parties specifically Ms. Crane from the New Mexico Attorney General and Dr. Fisher from Sierra Club and Christopher Sandberg from New Energy Economy, you're stating here that any disallowance should reflect an amount equal to the harm from choosing an alleged unreasonable investment. Is that right? But only if I'm sorry.
But only
if a finding of imprudence is made. Correct?
Yes, I think that's a good regulatory principle to use generally beyond this particular context.
You would agree that the purpose of a prudence review is to hold ratepayers harmless from any amount imprudently invested, and that a disallowance should equal the amount of the unreasonable investment.
I would say that's merging two issues that are both relevant but not properly thought of as the same thing. The prudence evaluation ought to decide whether a mistake was made. That analysis would look at the present value of costs over a very long time period into the future, and should look at what was known at the time in making that decision. If it's deemed that there was a mistake made, then it's better to, from that point, to say, okay, what were the consequences in terms of living with that poor choice as opposed to what should have been chosen? And that requires looking at realized costs through the present and then reprojecting those into the future for current conditions. So they're not quite the same thing, but they're similar.
But you do agree that a disallowance should equal the amount of the unreasonable investment if there is an imprudent finding.
Subject to that equaling the amount of harm, which it might well, but not necessarily. Depends on what's happened since then.
Is the decision-making process of a utility properly included in the prudence analysis?
Do you mean the mechanics of it, or is that what you're alluding to?
Just the decision-making process. What led up to the final decision? Is that properly included in the prudence analysis?
Well, it can certainly inform it. I don't think there's a per se requirement that the process has to be of type A or X to be sufficient. What's necessary in one setting may not be necessary in another, but it's important to know what was reviewed and whether it was properly indicative of market conditions at the time, whether it was robust enough. So there are many of those questions that do involve the process, but the process itself doesn't dictate whether a good decision was made or not.
Do you know that the chief negotiator for PNM admitted that he never even looked at the strategist runs before he recommitted to Four Corners Power Plant and signed the contracts?
I was not aware of that.
Well, if your entire analysis is about looking at the validity and of the prior strategist runs, correct?
Validity, sufficiency, accuracy, that sort of thing. Yeah, there's more than one dimension, but yes, although I will tell you, looking at a strategist run by itself is not very satisfying or informative because they're staggeringly detailed, and so you might well be reacting to summarized information about it, and it would be more informative than the run itself.
I'm not saying to you that the strategist run or runs or the financial analysis should be the entire reason to invest in a plant or not. We agree there, don't we?
Sure, I agree with that.
But if PNM testified that that was the basis that for their life extension and investment in Four Corners, and then the chief negotiator who signed the contracts to extend the life and invest in that plant did not review that financial analysis, that would be a fundamental flaw in your eyes, wouldn't it?
Well, if he was truly oblivious to the findings and whether to the extent to which they supported the decision he was going to make, that would seem inappropriate. But I mean, I can't imagine these people didn't have advisors and weren't speaking to other people who had done the analysis and were aware of the strength of it and the scope of it. So I can't speak for whether he was, relying on secondhand information that he thought was credible, or whether he had no information. I don't know.
And sir, did you read the testimony, the actual testimony of PNM witnesses who, in the Four Corners case, the 16276 case?
Your Honor, could Ms. Nanasi cite the witness in the testimony she's alluding to?
Do you have a cite, Ms. Nanasi?
I do, but I think that really that would be, Mr. Graves has said that he doesn't even know who the chief negotiator was. So I don't really want to say that because I don't think it's appropriate for me to be testifying about that. I'm just trying to find out if he read PNM witnesses who provided testimony in the 16276 case that that justified this investment.
You're not going to make me go hunt through the record to find it later, are you?
Nope, I'm definitely going to cite it for you.
I don't recall doing so. I may have, I looked at portions of lots of sources, but I can't pin them back to docket numbers and specific people in general.
5 minutes, Ms. Nanasi.
How much have you or Brattle Group been paid thus far by PNM?
I don't know the actual figure, but I would expect it's between $300,000 and $400,000.
And will you be paid more after your testimony today, or maybe after you help with the writing of briefing?
Well, I expect so, in the sense that, I'm billing them for my time. And if they want that help continuingly, then sure, we'll send them an invoice. But it's not conditional on anything. It's just time and materials.
Now, sir, you testified in PNM's San Juan abandonment case in the case number 19-00018 UT, correct?
I did, yes.
And I cross-examined you in that case. Do you remember that?
I do.
And in that case, you told us that, as a matter of fact, between the 2012 and 2015 period, that you yourself, as part of the Brattle Group, were helping at least 3 utilities, if my memory serves me, actually exit coal. Is that right?
Certainly it's true we have. We performed some general studies of the viability of coal throughout that time period, and a few firms asked us to help them assess the health of their plant in relation to those trends and in relation to environmental expenditures they were otherwise going to make. I don't remember whether it was 3, but that's pretty believable that we were working at off and on such cases.
And did PNM ever ask you at that time during that period to help them analyze whether it was prudent to remain in Four Corners?
No, PNM was not one of our clients in those studies.
And do you know of any analysis that PNM did other than this strategist analysis, these different runs that they performed? Do you know of any other analysis besides that couple of strategist runs that they performed to evaluate the prudence of staying in Four Corners?
Do you mean in that time window? Of course, their IRPs have, to varying degrees, reconsidered the mix of plants they should have over time. And there's been one of those every 3 years. But beyond that, there were, I'm not aware of any.
And sir, in that 1918 San Juan abandonment case, you know that one of the issues was the requirement that PNM comply with its own agreement to have what was dubbed a 2018 review hearing. You recall that?
I'm sorry, can you say that again? I was trying to ask about your previous question, sorry.
So in the San Juan abandonment case, when you testified last time before this commission, one of the issues in that case was whether PNM complied with their regulatory agreement to have a 2018 review hearing, or just a 2018 hearing. Do you remember that?
Vaguely, yes, that sounds familiar.
And in this case, one of the issues is another regulatory commitment that PNM made to have a prudence review hearing. Is that correct?
Yes.
And you know it's PNM's position in this case that the ETA trumps that agreement, essentially a contract with the PRC and signatories to have that prudence review hearing.
I generally understand that they regard that as transcending that requirement because of other terms and conditions in the ETA.
You've been a regulatory expert for more than a couple dozen years. Do you think that the commission should find it troubling that PNM makes regulatory commitments of a certain magnitude and then skirts those legal obligations?
Your Honor, I'm going to object the characterization in the question.
Sustained. Mrs. Nazi, I need you to wrap up. You're over time.
Thank you so much. Given that, I don't want to have any disrespect, and I will end.
You can ask one more question.
Do you think it's troubling for the commission that PNM signed a modified stipulation and agreed to a prudence review hearing, but is now taking the position that they don't have to comply with that regulatory commitment?
So I don't want to go too far into agreeing with your characterization of their viewpoint, but I would say, of course, normally it's nice to see continuity in previous regulatory and political agreements, but it is not unusual for them to be superseded either by political changes in state policy or state rulemaking, so that previous agreements may or may not still hold. And I'm not qualified to say whether this is the ETA is a sufficient reason for waiving those prior plans or not.
Thank you very much, Mr. Graves. Really appreciate your testimony.
Thank you. Nice chatting with you.
Thank you, Ms. Nazi. We're at about 12:05. Mr. Elliott?
Yes, Mr. Hearing Examiner, my questions have been answered. I would like to shift my time over to Miss Eden if possible.
So you want to take 25.5 minutes and shift it to Ms. Eden?
Yes, please.
All right, let's do that.
Thank you.
You're welcome. And so with that, our next cross-examination is by Onward Energy, Mr. Yar, and he has 53 minutes. So I suggest that unless his cross-examination has shortened considerably, that we take the lunch break. Mr. Yar,
I have no objection to that, Your Honor.
to taking the lunch break?
Yes, Your Honor.
And you still have 53 minutes.
I don't think I have 53 minutes. It could very well be 30, but I wouldn't know for sure, Your Honor.
All right, thank you. Let's take our lunch break. We'll be back at 1:05 p.m. Thank you, Mr. Graves. Thank you, parties. See you in an hour.
Mr. Harris, you're not on mute.
Oh, thank you, Mr. Lee.
Hello, Mr. Lee.
Good afternoon.
Just checking my volume. Can you hear me okay?
Yes, sir, I can. Thank you.
All right.
When you're ready, Judge.
I'm going to admit these folks. And okay, Mr. Lee, let's start. Okay, we're back from our lunch break on this Tuesday afternoon of this hearing in case number 21-00017-UT. Mr. Yar, are you prepared for your cross-examination of the witness, Mr. Graves?
Yes, I am, Your Honor. Thank you.
Your Honor, I think we need Mr. Graves still.
We do. I'm sorry. I should have checked the panels before I did that. Sorry, Mr. Yar.
It's okay.
I think he should be seeking to be let in.
I haven't. I just admitted some folks and I haven't had a request from Mr. Graves yet.
Okay.
It says, I have down here on the list, PNM witness guest muted and the camera's off, so he's
Yes, Your
logged
Honor.
on, I think.
Yeah, I think that's our setup in the conference room next door to
Oh.
me here.
Okay.
Mr. Graves is testifying from his office in Boston.
Yeah, I should have indicated that it shouldn't log off. That doesn't matter.
I just emailed him to log back in. If you indulge me a moment, I'll call him right now too, Your Honor.
I just admitted him.
Ah, got it.
Thank you.
Hey, folks.
There we are.
Yeah, sorry, I was trying to reactivate my Dropbox account, which went to sleep.
Okay, great.
It looks okay.
Thank you, Mr. Graves. Okay, Mr. Yar, are you ready to proceed?
I am, Your Honor. Thank you.
Okay, please do so.
Hello, Mr. Graves.
How do you do?
Good. Welcome back. My name is Joseph Yar. I'm here appearing on behalf of Onward Energy Holdings LLC. And I would like to ask you some questions regarding your supplemental testimony and your rebuttal testimony.
Sure.
Mr. Graves, it's my understanding from your March 15th, 2021 supplemental testimony that you were retained by PNM for this case to independently evaluate the prudence of PNM's decision to extend its participation in the Four Corners power plant instead of abandonment. Is that correct?
Yes, that's a fair characterization.
It's also my understanding that when you say independently, you mean independent of any direction, supervision, control by any PNM personnel. Is that correct?
Yes, other than having them facilitate access to system analyses and information they relied on so that I can reconstruct it.
Okay, fair enough. Thank you. And as I understand it, in your rebuttal testimony, you provided what you refer to as your independent ex post analysis or harm analysis regarding the prudence of PNM's decision in 2013. Is that correct?
That's a significant portion of it, yes. It's harm separate from prudence. In effect, to bother doing the harm calculation, I'm conceding that there's a prudence doubt. I actually disagree with that, but if there were, then you would want to figure out what the harm was.
Fair enough. Thank you for clarifying that, Mr. Graves. Can you please turn to your rebuttal testimony that you filed on August 2nd, beginning at page 15. The next set of my questions will kind of involve that area of your testimony. Let me know when you're there.
Okay, hold on. And what page again did you want?
Starting on page 15, I'll be bouncing around, but if I need you to look at something specific, I promise to point you to it directly. I just want you to be there so that way my questions are easy to assess for you.
Sure. Okay, I believe I'm on it.
Okay, perfect. So is it correct that for your analysis, you compared the 20-year present value of revenue requirements, or PVRR, of two scenarios? Is that correct?
Yes, from 2017 through 2036.
Okay. And the first scenario that you considered was PNM's proposal to exit Four Corners power plant at the end of 2024 and replace that with 461 megawatts of solar and 92 megawatts of gas combustion turbines that would operate as peakers. That's the first scenario. Is that correct?
Yes, with those replacement amounts being ones I calculated myself.
Okay. And then the second one was a hypothetical decision by PNM in 2013 to instead abandon PNM's share of Four Corners Power Plant in 2016 and replace it with 252 megawatts combined cycle plant that would have been online beginning in 2017. Is that correct?
Yes.
All right. And to model the costs of the hypothetical, the second one, you use cost assumptions provided by NREL's 2021 Annual Technology Baseline and PNM's recent resource planning process. Is that correct?
That's true of both scenarios. The different kinds of information came from different sources, but those were major sources.
Okay. Now I'd like you to turn to page 17 and line 3 of your rebuttal testimony when you say PNM's recent resource planning process. Do you mean the costs for PNM's resources in its existing supply portfolio and potential new resources provided in PNM's 2020 IRP that was filed with the commission? Is that what you're referring to?
Yes, some of the numbers came from that. There was also an assessment which we asked PNM to prepare, which would analyze the costs of going forward with the gas plant if it were operating.
Okay. Okay, that's helpful. So to some extent, the 2020 IRP was used in your analysis. Is that correct?
Yes, that is correct.
Okay. So is it fair to say, while you describe this ex post analysis as independent analysis by you, that is independent of any direction, supervision, or control by PNM personnel? As I understand your testimony, you rely for your analysis to some extent on PNM's resource modeling costs and other modeling assumptions in the 2020 IRP. Is that correct?
Yes, that's right.
Who specifically were the PNM personnel that you dealt with that provided you with the 2020 resource planning information?
Nick Phillips was by far the dominant source. He had various people who were assisting him, but he was the main channel.
Okay, thank you. And in what form was that cost information provided to you? Was it provided by spreadsheets or copies of the pages directly from the IRP?
Certainly there were some spreadsheets. I don't recall the formatting, to be honest.
Okay.
But I'm sure there were some spreadsheets. There may have been other just, emails with numbers and that sort of thing.
Okay, thank you. And that information that was actually provided included the costs in the IRP for PNM's gas-fired resources in its existing supply side portfolio that PNM relied on for its modeling in the 2020 IRP. Is that correct?
Can you restate it or just repeat the question?
Sure.
I'm not sure I followed you.
Sure. Okay. So that information that was provided to you that we were just talking about, it was based upon the information of its existing gas facilities. Is that correct? As according to the 2020 IRP.
Yes, that's generally true.
Okay. Okay, so let's go back to the rebuttal, and this time I want to take you to page 18, specifically lines 7 through 12.
Sorry, page 18, did you say?
Yep, in your rebuttal.
7 through 12. Okay, I have it.
There's the first full sentence, the start of the full first sentence on page 7. On line 7 and going through line 12. Can you read that for me? It starts with my analysis.
My analysis accounts for these requirements by assuming that PNM's oldest gas facility, CC unit, Luna Energy Facility, would stop generating after 2031. And the declining gas-fired generation on the system would be met by just the larger Afton and new CC plant.
met by just a larger,
Afton, AFTON, that's the name of a plant, and new CC plant. CC is the two letters CC.
CC is the,
CC is the letters for combined cycle. It's just an abbreviation.
And that next sentence?
Oh, therefore, this scenario gets a savings from the fact that PNM would avoid costs related to operating Luna after 2031.
And you go on in a footnote in there to say, I assume that Luna would be kept online to provide capacity. Is that correct?
Yes.
Okay. Okay. And what I'd like to do is kind of focus on your terminology that you use in there, saying Luna Energy Facility. Is this the same Luna Energy Facility that's listed in PNM's 2020 IRP?
I believe so. Sure.
Okay.
So
All right.
combined cycle plant.
Okay, perfect. And is it correct that Luna has been determined in that 2020 as an intermediate duty cycle facility, as distinguished from operating as a peaker?
You know, I don't recall that nomenclature being assigned, but it wouldn't surprise me that being a CC, it has, and fairly efficient, it would run as more than a peaker.
Okay, fair. And would you also agree with me that Luna, as described in the 2020 IRP, has an assumed 4% forced outage rate and is assumed to provide PNM with capacity and energy through December 2039?
Oh, sure, I accept that.
Okay, perfect. So just to confirm, you said that in your ex post analysis assumes that even though PNM customers would continue to pay for keeping Luna online post 2031, they would not be receiving the benefit of any energy that facility could provide post 2031. Is that correct?
What I'm doing in this is representing the fact that from 2031 and beyond, the carbon emission standards for that PNM is aspiring to under the ETA tighten considerably. And any kind of gas units that are running at that time will probably have to be used less heavily than they would have been in the past. Doesn't mean they're not used at all, but they're used at a declining rate, and some may become used primarily for standby or capacity value.
Okay. So can you clarify what you mean when you refer to, I assume that Luna would be kept online to provide capacity in your footnote? I'm not sure I follow you.
I don't assume there would be any closing costs or cancellation costs or shutdown costs associated with it in that period, because it would still be useful as a capacity resource.
So in other words, you're saying that it would be used for energy also?
No, maybe you may not be entirely familiar with the distinction between capacity and energy. I think you are, but you can have resources that are retained primarily for their standby value in the event that other units don't perform. Those are dubbed capacity resources, though of course, when they actually perform that function, they provide energy. Otherwise, they're doing nothing except meeting a numerical standard. And sometimes that's all they have to do. If by luck, there's no contingencies where they're important. But by and large, a capacity resource occasionally provides energy, but it's not being retained because of the savings that arise from its repeated energy use. It's being retained because it's a cheaper source of reliability than a new facility.
So turning back to your rebuttal testimony, that same section, same page number, where you're talking about the alternative path used for your ex post analysis, you assume that PNM's Luna energy facility would stop generating after 2031, and that would result in some cost savings. What specific avoided costs are you talking about? Are you referring to the projected O&M costs?
I believe that's the case. I would have to refresh my memory by going back into the work papers and seeing what it was. But it would be, you would continue to pay for the presence of the thing, but O&M costs and variable operating costs and so on would be avoided.
I'm sorry, you would continue paying for the presence of the thing and
And the presence of the plant for reliability, but you would avoid some operating costs such as fixed O&M and variable O&M.
thank you.
So, Mr. Graves, can I turn your attention to an exhibit to help refresh your memory? Onward 1. If you could take a moment and take a look at that, it's on the Dropbox under the Onward file.
Sure. Let me see if I've been successful at maintaining access to this. Oops. Sorry, there's so many files on this. They would go onward. Onward 1. Okay, I have it.
Okay, great. Now,
Appendix H.
right, that's
Yeah.
it. Perfect. Thank you. And so, would you agree with me that this Appendix H is the cost and performance data for PNM's existing generating resources as it is in the 2020 IRP filed with the commission?
Yes, that appears to be correct.
Okay. And if you would please, can you turn to page H9 of that exhibit?
Okay, I have it. Fixed
So
O&M.
as you can see at the top of this table, it says fixed O&M costs. And you'll look at each one of the facilities are labeled there, and you'll see Luna. It's the 1, 2, 3, fourth one over from the right.
Okay.
Okay. And when we were just a moment ago talking about the O&M costs, are those the costs right there in that column, 2031 through 2036? Are those the cost savings that you were referencing when you said in your testimony that this scenario gets a savings from the fact that PNM would avoid costs related to operating Luna after 2031?
Those are the types of costs. I can't recall specifically how much, if any, adjustment we made for fixed O&M. We certainly know that you would have been using trying to use more efficient units more often than not, which is a source of savings in fuel. I don't recall whether we also had a fixed O&M savings to this column or not.
Okay. So kind of following along with that train of thought, the next page, H10, table H9, that's the taxes and depreciation expense. Would that be a cost savings in your analysis?
Sorry, what page are we on now?
It's the next page. It's page H10 of that exhibit.
Okay, sorry. No, I would not think so. These are related to carrying the revenue requirement forward for the plant, not, and it doesn't change if it's still a capacity resource.
Okay, so those, just to be clear, your ex post savings analysis did not include any post 2031 taxes and depreciation costs through 2036.
I believe that's correct.
And the reason for that is because, as you indicated in your footnote 22 on page 18 of your rebuttal, your analysis assumes that even though Luna won't provide PNM with energy after 2031, Luna will remain online after 2031 for capacity through 2036 which would be consistent with the planned 2039 retirement date for Luna, which is contained in the 2020 IRP.
Yes, that's correct.
Why did you assume for your ex post savings or harm analysis that Luna would remain online after 2031 for capacity?
Well, what I have tried to do is sustain the same amount of capacity in both scenarios without reanalyzing exactly whether all of it is needed or not. But that's simply so that they're on an equal footing. And Luna was, in that regard, standing capacity beforehand. And unless there was a finding, which is not conducted in my analysis, that less capacity would be needed, which would have been true in both scenarios, then there's no reason to remove it. I was just looking for operating savings, not fixed cost, sunk cost savings that you might avoid if you could shut down the plant. Not clear you could avoid those even if you shut down the plant sooner, but I was not looking for those.
So just to confirm, your ex post analysis assumed that based on the information in PNM's 2020 IRP, if PNM had acquired 252 megawatts gas combined cycle
I'm
resources.
sorry, if PNM had acquired
a 252 megawatt gas combined cycle resource for service online in 2017, it would still need its 190 megawatts of capacity from Luna after 2031 to meet its resource adequacy needs for the period 2032 through the end of 2036.
I guess the answer is yes. I'm assuming that there was no reason based on the 2017 outlook to assume that Luna would not continue to be useful, rather simply that it would not be able to generate as much because of the tightening carbon emissions requirements.
Did anyone from PNM ask you to make that assumption in your analysis?
No.
Okay. So the assumption in your analysis that Luna post 2031 would be online for capacity only, is that based on any kind of planning reserve margin that PNM has proposed?
No, my analysis here is, in a sense, agnostic as to future changes in reserve margins and how they might be met by other system adjustments. I'm comparing what are the consequences of relying on a 2017 CC for 20 years in compliance with ETA's carbon emissions versus pursuing the FCPP abandonment plan and relying on its replacement, similar quantity of replacement resources in both gas and energy through the same time period.
I'm sorry, in both what in energy?
A similar quantity of the same quantity of capacity and energy through 2036 to see what the relative costs of that portion of their system would be. If in 2031 and beyond, less capacity was needed, it would be less needed in both scenarios, and I would have had to adjust those too. Or they would have occurred outside of these two assets and would not have affected the cost of these two comparisons.
Mr. Graves, though, I fail to understand why you picked Luna to be idled and only be considered for capacity if that were the case. If you weren't considering the planning reserve margin, why would you even why wouldn't you just retire it completely? Why are you keeping Luna online for capacity purposes?
Well, again, I don't have any reason to believe that less capacity is needed by then or not. I mean, there's no, that's an assumption you've sort of made up for purposes of our conversation. The system is by and large growing and might grow more rapidly in the future with electrification and electric vehicles and all sorts of things that are emerging. And again, if a different system quantity of capacity was needed, that adjustment could be made outside of the use of the resources that I'm modeling. You could retire something else. I don't know that I'm not proposing Luna be retired or not. I'm just sustaining the two scenarios on an equivalent footing.
Following along assumptions, I have another question. So based on the assumption, on that assumption in your ex post analysis, that Luna would remain online after 2039 for capacity, does your analysis, or let me rephrase this, your analysis does not include any savings on capital expenditures that PNM may have to make for its share of Luna Energy facility to keep that facility online after 2031. Is that correct?
That's correct. There's no adjustment for, maybe it can be maintained at a lower cost because it's just a capacity resource or something like that.
I'm sorry, sir, you're dropping your voice. There is no.
I'm sorry. I say there's no adjustment for a presumption or an analysis to the effect that it can be maintained at a lower cost as just a capacity resource.
And it is correct for the purposes of your ex post analysis, you didn't consider whether PNM may need to pay for additional capital expenditures for its ownership in Luna post 2031.
No, I believe I projected Luna the way it had been carried in the 2019 study. I mean, in the 2020 IRP. I didn't change it to any other vision of Luna.
Yeah, I think, I'm sorry, I may have, we may have misunderstood. What I'm talking about is additional capital costs that would probably be ascribed to PNM as a shareholder in that facility to continue to keep it operational going forward. They still would have to pay their share of that. Do you follow me, Mr. Graves?
Yes, and I think those are included in my analysis. I'm assuming it's paid for, it's just used less. And in fact, in my first rebuttal, I acknowledged that Afton would have probably been the better plant to adjust downward than Luna. But apart from that distinction, which has the same questions about capacity, I assume that it continues to be paid for, just used less.
Yeah, we're talking about the revenue requirement that is based upon PNM's cost. But are you aware that gas facilities from time to time need to be upgraded? There are certain additional capital costs that become part or added to in a subsequent rate case to maintain the facility?
Of course.
Okay, were those projections included in your ex post analysis?
To my recollection, there's nothing broken out as a periodic capital addition for purposes of overhauling turbines or making periodic adjustments, as is often the case and is required. Instead, there's just the representation of O&M and capital expenditures as PNM had modeled it, or had projected it for the plan, which tend to generally, sometimes average those costs in. I was not aware that there was any reason to add any additional costs or to take any out for it.
Okay. Fair enough. Thank you. Thank you, sir. I'm right here. Let me just take a look at some of my notes here. One final question, Mr. Graves. Your ex post analysis of the alternative path regarding Four Corners power plant did not examine whether PNM could have achieved additional savings by abandoning and possibly selling its share in Luna in 2031 and replacing that intermediate duty facility with other resources for PNM to obtain the post 2031 capacity it projects it would need after 2031. Is that correct?
That is certainly correct. I did not look at any other ways of re-optimizing the system once you started down that path of the 2017 CC.
Mr. Graves, thank you for your time. I appreciate it.
Sure.
No further questions, Your Honor.
Thank you, Mr. Yar. Yeah, next is Sierra Club. Mr. Gerhart, are you there?
Yes, I'm here, Mr. Hearing Examiner.
I have you down for 70 minutes. Is that going to work for you?
Yes, that's correct.
Okay, please proceed.
Thank you. Good afternoon, Mr. Graves.
How are you?
I'm doing well, thank you. Would you please turn to Exhibit SC-3? Please let me know when you're there.
Can you give that a more familiar name? Do I need to find that in the venue, or what am I looking for?
I believe, if I might interrupt, Mr. Gerhart, I did send that to you, Mr.
Oh,
Gray,
okay. Yes, you
Mr.
did.
Gerhart.
Yes, let me go find that. Sorry, give me 1 second here. SC3, C3. Okay, I have it.
Great. This is a letter from you and a colleague addressed to PNM's Associate General Counsel. Is that right?
Yes, it is. Dated February 1, 2021.
You sent this letter before PNM had formally retained you for this case. Is that right?
Sure. Yes, this is meant to explore how we might be retained.
Okay. At the time you wrote this letter, you had not yet conducted your own quantitative analyses of retaining Four Corners in 2017 versus exiting in 2017. Is that right?
That's right. I was familiar with the debate, but not the numbers.
Okay. Is it accurate that you were proposing in this letter that your scope of work would at least in part be to respond to interveners' past criticisms of the prudence of PNM's actions?
I don't know that we said that explicitly, but I think it was implied.
Okay.
We did, in a way, the top of page 2 of 3 addresses that. Point B that says, if I may, quote, as needed, Brattle may be able to construct or reconstruct additional analyses that address the significance of specific criticisms.
You wrote this letter before you had seen any intervener filings in this particular docket, correct?
Yes.
Okay. Did you, when you wrote this letter, did you understand that you were committing yourself to respond to intervener filings in this particular docket?
I'm not sure I understand the distinction between that and the previous question. To the extent the intervener filing specified a viewpoint, what was reasonable, sure, we would have responded to them.
Sorry, let me try to clarify. If you go to the first paragraph of the first page, you say in the second sentence, based on our review of background materials to date, this appears to be motivated by interveners' criticisms of decisions made around 2013 for SCR investments. Do you see that?
I do.
So were you referring there to criticisms that were made in the 2016 rate case?
I believe at that time, those were the only ones we were aware of. And there was, a good summary of those in the hearing examiner's report.
Okay. So what I'm getting at is, in this letter, you are proposing to respond to the intervener criticisms that had been made in PNM's 2016 rate case, right?
Not explicitly, but to such criticisms in general.
Okay. So the distinction I'm trying to draw here is, were you also committing yourself to respond to intervener criticisms leveled in this docket, even though you hadn't seen those criticisms yet?
Well, I would say committing to is a misplaced verb. I mean, we were offering to assist, and if the company found that there were new and related allegations that we could address, we assumed that we might be involved, but we weren't committing to do anything.
Okay. Would you turn to page 2 of this exhibit to point 2A as an apple?
I'm there.
In the material in parentheses, you say, harm would not be the cost of the entire plant, even if there were flawed decisions, just the incremental cost of the bad decision. Do you see that?
Yes.
You're not an attorney, correct?
Very true.
Okay. At the time you wrote this letter, had you done any legal research on the appropriate scope of remedies for imprudence under New Mexico law?
Certainly not as a point of legal scholarship. Yeah, I had already testified in the San Juan case, I believe, at this time, and there was, of course, discussion there about various disallowances that had occurred in the past and the basis for those. So I was contextually aware of some of them. More generally, I've testified on prudence and imprudence many times in many venues. So I think I was presuming there was some generality to that experience.
Okay, thank you. Your Honor, I would move the admission of exhibit SC-3.
Any objection?
Objection.
No objection. Okay. Hearing no objection, Sierra Club Exhibit 3 is admitted.
Mr. Graves, in the 2012 to 2013 timeframe, prior to deciding to extend the coal supply agreement for Four Corners, did PNM retain any consultants to analyze whether it should remain in Four Corners?
During the period from in 2012 and 13, is that the question?
Yes.
I'm not aware of whether they did or didn't. They certainly did not retain us, but I have not asked them if any others were retained. I would be surprised because I would think we would have been aware of any studies that came out of that from third parties, and I'm not aware of any.
Okay, so just to be clear, you're not aware of PNM having hired any consultants in the 2012 to 2013 timeframe to help PNM assess whether to stay in Four Corners?
Correct. I am not aware that they did so or whether they did so.
Okay. So then, as far as you're aware, would it be correct that PNM is spending more money on consultants to defend the prudence of its decision than it's spent on consultants to make the decision in the first place?
Well, I have no idea what the amount of expenditures were that went into the earlier analyses. There are many, many components which of analysis which they do pay for: gas forecasts, load forecasts, financial advice. So I don't know that there was I have no idea how much was spent in the past.
Okay, thank you. So in the summer of 2016, the then existing coal supply agreement was set to expire, correct?
In the summer of 2016, it was not, by then it was not set to expire. It had been extended, but that would have been its expiration had they not previously extended.
Okay. So in 2013, PNM is deciding whether to renew that coal contract that was set to expire in summer of 2016, correct?
Yes, that was one of their concerns.
Okay. And the proposed coal contract amendment that PNM was considering in 2013 was a 15-year extension from 2016 through 2031, correct?
I believe that's right.
And in 2013, PNM could and should have expected that if it agreed to that contract extension, the revenue requirements associated with that extension would amount to several hundreds of millions of dollars. Would you agree?
Sure, I can't vouch for the isolated value of this coal contract itself, but it would have been presumed, I think, that those costs would have been recoverable.
What I'm trying to get at is, for a utility of PNM's size, do you believe that PNM's 2013 decision should have been viewed as a decision with potentially significant cost impacts to PNM's customers?
Of course, and that is what is embedded in a calculation of the present value of future revenue requirements, recognizing that while there's a lot of costs to the one choice that was in play, there would have been a lot of costs to the other as well, such as buying a new combined cycle plant and paying for its fuel. So there was big money on both sides, but the net is more important than the fact that each is a big dollar amount to start with.
Thank you. I want to ask a few more questions about the details of the 2016 coal supply amendment that PNM was considering in 2013. So are you aware that the proposed extension to the coal supply agreement had minimum take requirements that PNM would be responsible for under the contract?
Yes, I know that.
Okay. And the contract also had minimum load requirements as well, correct?
load isn't the term I would have reflected, but there are obligations on both sides for meeting minimum quantities. Is that what you mean by load?
Yes, yes. So there was a certain inflexibility in the contract the PNM was evaluating, in that PNM would not be able to easily get out of those minimum take requirements if it signed the contract. Would you agree?
Well, I would assume that applies to all the terms of the contract, not just the minimum take. If whatever they agreed to would be then binding unless there were explicit out clauses written into the contract itself. So the minimum take would have been one of those terms, but payment terms and pricing terms, others would have also been binding.
What I'm getting at is, theoretically, a utility could be faced with a decision to renew participation in a coal plant without minimum take requirements for every year of a 15-year contract, right?
It is certainly possible to write contracts like that. Other terms will differ generally when that's the case, and whether the sellers are interested in that kind of term depends in part on how readily they can remarket their product to other buyers. So it's not per se that you could just decide not to have a clause like that. You could negotiate another arrangement, which might be more expensive but more flexible, for instance. I think you may have frozen up, or whoops.
Looks like Mr. Gerhardt dropped off. He was having internet issues last week, and it looks like it just recurred again. I hadn't had any problem hearing him or any issues today.
Yeah, it was clear on my end until he disappeared.
Okay, I'm waiting for him to establish the connection.
While he does that, I'm going to lower a curtain in my room because I'm getting a lot of direct sun here. And pretty soon I'm going to look like a ghost in my room. Hold on.
Mr. Hearing Examiner, let me know if it would be helpful to reach out to Mr. Gerhardt at all and see if his issues seem like something he's going to be able to resolve.
If you have his number,
I do. So would you like me to reach out?
Please
Okay.
do. Thank you, Mr. Tisdale.
Yes.
'Cause if it's an indication that it's a longer term problem, we'll have to move forward. Ms. Beatles, are you there?
Yes, I am, and I have no questions at this time for Mr. Graves, but if Mr. Gerhardt is allowed to continue questioning, I'd like to just know that I have the opportunity to ask, a question if it arises.
Yes, I'm just trying to, here we go. All right, he's back. My point is I just needed to move on and see who might be prepared to go ahead of time. But Mr. Gerhardt is back. Okay. He's connecting to audio. There we go. Mr. Gerhardt, are you back?
Yes, I apologize. My internet.
Yeah, we were doing so well today, but it looks like it's a little possibly glitchy, but we'll go forward.
I apologize for that.
No need to apologize. It's not your fault. Go ahead.
Sorry about that, Mr. Graves.
Yeah, can you refresh me on where we were? I think I've lost track of our.
Yes, yes. I'll move on with a new question. In comparing the costs of two different generating assets, would you agree that the main components of costs include capital, O&M, and fuel costs, among other things?
Sure, that's typically the lion's share. There might be some surcharges, taxes, that sort of thing, but basically that's the core items.
Okay. When PNM decided in late 2013 to extend its participation in Four Corners, the most recent economic analysis PNM had conducted of retaining Four Corners was a May 2012 analysis, correct?
I believe that is correct, yes.
And you're aware that that May 2012 analysis omitted the forecasted capital costs of both of the scenarios it analyzed. So both the Four Corners retention and the new combined cycle unit, correct?
That's correct, which is one of the adjustments I make in my supplemental report.
Have you ever made a similar omission of forecasted capital costs in a similar analysis that you made?
I'm not aware of having done so. Certainly, I would normally worry about capital expenses or ongoing capacity maintenance expenses. Some firms bundle those with their fixed O&M in their forecasts, and some forecasting services do the same. So you have to be careful about where they are and whether they're in there. So sometimes it's tricky, but they should be recognized, except if they are not avoidable or if they're equivalent across the alternatives, in which case you can add them in, but for comparing the difference in value between two alternatives, they will net out.
Thank you. Would you please turn to your Sir rebuttal testimony to page 22? Please let me know when you're there.
Sure, hold on. Sir rebuttal testimony. Okay, page 22?
Yes, please.
Almost there. Okay, I am there.
If you look at line 17, there's a sentence that reads, "It is more credible that the decision between FCPP and New Gas made back in 2013 was a close one." Do you see that?
I do.
Okay. In your supplemental direct testimony, I don't recall you saying that the 2013 decision was a close one. Do you?
I did not present those words. I did show some figures that showed that the savings were modest from the FCPP alternative to the gas plant, and uncertain that depending on what gas and CO2 and so on other prices turned out to be, they could be positive or they could be negative. More likely to be positive in my view, but within a range of uncertainty that could make the gas plant more economical under some circumstances.
Thank you. Do you recall in your direct testimony noting that in its 2011 IRP, PNM had concluded that staying in Four Corners in 2017 would have a net benefit of approximately $200 million.
Yes, I believe in 2011, they were evaluating whether they could move away from their coal plants, and they decided it was not economical.
Okay, so I want to assume for the purposes of this question, just for a moment, that you're right, that a proper 2013 analysis would have shown that it was a close call economically whether to retain Four Corners or not. So that would mean then that between the 2011 IRP and May 2012, the economics of Four Corners had deteriorated by approximately $200 million. Is that right?
That sounds plausible, and I suspect most of that would be due to declining gas prices.
Okay, so shouldn't a approximately $200 million deterioration in Four Corners economics over a roughly 1.5 year period have led PNM to do further analyses before it committed to staying in Four Corners?
I would say that is not a safe generality you can make from the fact that a plant changes value over a short time period, for a couple of reasons. This is not like the reason it had lost value, as I say, is I have not studied this, but I would guess it's because gas prices fell dramatically in that time frame. And they were generally regarded as bottoming out in around 2012. In fact, it was one of the cheapest years for gas prices in that time frame from about 2008 through 2015. And there were good reasons to believe they were going to rebound. So the cause that, if that was the primary cause for the change, it would have appeared to be cooling off. It's not like this was a snowballing process that once it got started would get worse. It was due to exogenous factors that could easily have turned around by 2012. So I think evaluating it from a 2012 perspective wouldn't carry much weight because of how much different it had looked in a few years before, or even a year before.
Are you aware of any evidence in the record where PNM conducted the kind of analysis that you just gave here on the stand? By which I mean where PNM sought to determine what factors might have led to the change in economics from 2011 to mid-2012, and whether those factors were likely to persist.
No, I'm not aware of anything explicit they would have done, but to the extent they had experienced system planners who were involved in both earlier studies and the 2012 studies, they would have had that context in mind, I'm sure.
Okay, thank you. I have some questions back on your supplemental direct testimony.
Okay.
And I'll ask you some general questions. If we need to, I can point you to specific pages. But my understanding is that in your direct testimony, you did two kinds of quantitative analyses. So you made adjustments to PNM's May 2012 analysis, and then you also created a 2013 update to that 2012 study. Is that accurate?
Yes, that is a pretty good summary. Figure 4, I think, summarizes the first, and if I recall, figure 10, the second.
Okay. And apologies, I know this is obvious, but I just want to confirm it. These analyses that you did were not ones that PNM in fact did in 2012 or 2013, correct?
That's very true. I'm offering them as supplemental evidence of what they would, in my view, have been concluded had the gaps in analysis been filled at the time.
Okay. So then when PNM made its decisions in late 2013 about whether to extend its participation in Four Corners, it couldn't possibly have had your analyses to rely upon in making its decisions, correct?
As an analytic matter, that certainly is true. They would have still only had the 2012 findings that it was $33 to $43 million better in their view at the time to retain Four Corners. They would have, of course, known that circumstances were changing in the market, some of which were favorable and some of which were not to Four Corners. And so they weren't unaware of the situation, but the only analytic number they would have had would have still been from May 2012.
Thank you. I have some questions for you about what certain people have referred to as the seasonal operations agreement, and which encompasses the June 25, 2021 amendments to the Four Corners project agreement. So my first question is, are you aware of the June 25 amendments to the Four Corners project agreement?
Only in general terms. I have not seen the specific language of what was agreed, but I understand that it changed the plan so that there would be seasonal activity for units 4 and 5, but PNM's share would be steady throughout the year. Or not seasonal.
So to clarify, you haven't read the final executed version of those June 25 amendments to the Four Corners operating agreement?
That is true.
So then is it also true that your quantitative analyses don't reflect changes made in those June 25 amendments to the Four Corners project agreement?
That is true. I'm not aware that if I had read the document that I would make any adjustments. My understanding is the volumes that I projected for Four Corners through 2024 are ones that are consistent with the seasonal schedule, even though I developed them without that in mind, awareness.
Would you please turn to page 64 of your supplemental direct testimony?
Okay. All right, I'm on it.
Okay. So in the last paragraph of this page, and then continuing on to the next page, you're discussing the intended and unintended consequences if the commission were to order a disallowance. Is that accurate?
Yes, I think that's pretty clear from the first sentence on line 17.
Is it correct that one of the assumptions you're making here is that a disallowance has an effect on utility behavior going forward.
Yes, and I'm actually, of course, that's true, in that it can create constraints as well as signaling to the utility. But I'm actually speaking a little more broadly here about utility regulation in New Mexico generally, that if there's a perception that prudently chosen past things can be penalized because market conditions change and they don't continue to be as economical as originally hoped, that sends a signal that the cost recovery process of regulation is now to be trusted. And that will spill over to investors' view and utilities' view of what to do in terms of risk taking for the future.
Thank you. Would you please turn to the next page? So page 65, line 7.
Okay, I have it.
There's a sentence that begins, if those circumstances, comma, should they arise, comma. Do you see that?
I do.
Okay. So in this sentence, my understanding is that you're talking about investors and the opportunity to earn the cost of capital on investments. Is that right?
Yes, that's true.
Would you agree that an investor-owned utility such as PNM considers the opportunity to earn the cost of capital on its investments when it's making forward-looking decisions?
Of course.
Okay.
It does that in the context of also some beliefs about the way judgments will be applied in the future about the acceptability of those investments. So there's not just a hope, but also an understanding of what the rules of the game are, so to speak. And if they have to have confidence in the continuity of those rules.
Thank you. Would you please turn back to your surrebuttal testimony?
Sure. Okay, I have it.
Would you please refer to page 9, line 15?
Okay, I'm there.
There's a sentence there that begins, however, comma, we do know here what the alternative would have been. Do you see that?
I do.
Okay. So my understanding of this sentence is that you're suggesting that for purposes of assessing damages from PNM's decision to stay in Four Corners, that had PNM exited Four Corners in 2017, we know that PNM would have replaced Four Corners with a new combined cycle gas plant. Is that an accurate understanding?
Yes, or a little more shaded, and I hope more accurate version of that would be to say, all we know that is being offered and tested as an alternative is the alternatives that were under consideration at the time. Those are the disagreement with those decisions are why some people, the Sierra Club included, have challenged the past as having not been prudently pursued. But no one has offered any other view of what an even better alternative would have been. So it's the only thing we have here is a reference point for what the world would have been like, but for the FCPP plan. is what was being used to prove that it was a bad decision, or being used to suggest it was a bad decision by its critics. I don't know that that would have been exactly what it would have been, Bill, but it's the reference point that we should use here to decide both prudence and damages.
PNM's May 2012 analysis was conducted in Strategist, right?
Yes.
Couldn't you have rerun Strategist with the adjustments you discussed to see whether the optimal replacement for Four Corners would have been a new combined cycle unit?
I'm not sure that would have been very easy to do or not. I'm not even sure that PNM still even has Strategist or a license to it, no less the data sets for describing the simulations they did back in 2012. So that might have been a monstrous or infeasible exercise. What I did was take marginal cost information out of those runs and adjust it for the changes in the underlying factors to get a first order approximation to what a new Strategist run would have shown. And my supplemental testimony showed that for somewhat different reasons, the FCPP plant would have still been economical relative to a CC. I'm not trying to decide if a CC would have been the next best thing they could have. That would have still been the best alternative, but it was better than that. That is, FCPP was better than a CC.
Okay. Would you turn to page 10, line 18, please?
Same report?
Yes, please.
Sure. 10. With the sentence beginning first, it is true?
Yes.
Okay.
So that sentence reads in part, first, it is true that an a priori integrated resource plan.
I'm sorry, first it is true that I didn't hear that next word.
Sorry, Mr. Lee. A priori integrated resource plan, parentheses, IRP, case has less incentive to bias results than a prudence review. Do you see that?
Yes, I do, and you read that correctly.
So why do you believe that there's less incentive to bias results in an IRP case than in a prudence review?
Well, I'm actually agreeing with Dr. Fisher here, whom I interpreted as saying the initial problem of finding what appears to be the least cost alternative is one in which the utility is relatively neutral. They'd like to find the cheapest thing and reach agreement on it. So in that sense, they're unbiased. If later on they are challenged and you are wondering whether there's an incentive to bias, which I reject has happened here, but he alleges it has happened, then that would happen when you started reviewing the prudence. It doesn't happen only when you start reviewing the damages, because you would want to prove the prudence and prove that there's no damages. So his notion of when the bias kicks in is wrong. It kicks in earlier than he thought. That said, there isn't a shred of that in the way we approached the analysis. We were fully independent and not guided to try to reach any conclusion or to try to use any particular data or method. Just work with as much time and information as we had.
Thank you. Would you please scroll down to page 12, line 5?
Sure, and I'll just say as an aside, I believe this is the first time in my many years of testifying that I've ever been asked to scroll down to a particular page as opposed to turn to it. So that either means Zoom or technology is taking over. Sorry about that. But I have done that. I have scrolled down.
Thank you. This is new for me as well, Mr. Graves. So on page 12, line 5, there's a sentence that reads, "My plan is more solar intensive than any of his." Do you see that?
I do.
Okay. And to put this in context, you're saying that your replacement portfolio for replacing Four Corners differs from Mr. Phillips' replacement portfolios by having more solar resources. That's the context here, correct?
Yes, that's correct.
Okay. Are you aware that in Mr. Phillips' analysis, most of the replacement portfolios associated with the greatest cost savings were the technology neutral portfolios that included new gas?
I do remember that, yes.
Okay. So what I'm confused about here is PNM has used a set of replacement resource portfolios in Mr. Phillips' testimony for the purposes of estimating cost savings from abandonment, right?
Yes.
Okay. And then you've used a different replacement portfolio for the purposes of assessing damages if there's a finding of imprudence, correct?
Yes, that's true.
Okay. So my question is, why didn't PNM present a set of consistent replacement resources for both purposes? Why the discrepancy between the replacement portfolios in Mr. Phillips and your analyses?
I think there's probably a couple of reasons. First, I don't believe Mr. Phillips would say that he has identified a planned or preferred replacement for Four Corners after 2024. What I think he's shown is that if across many ways of replacing it and under many different circumstances, it's going to be cheaper than than retaining it. So his basic point was not to choose the replacement plan, but to show that it was abundantly likely that the replacement plan that many kinds of replacement would save money. But none was offered as the best alternative. We had not, given that none was identified as a preferred alternative, we simply tested what would happen if the alternative was to replace it with mostly renewable resources, as the ETA seems to be, and New Mexico policy aspirations seem to be leaning towards, to see if that technology would provide an opportunity to be as cheap or cheaper than running with the gas plant. Since gas was pretty attractive in these, we were wondering if renewables would be more attractive. And in our analysis, that appears to be the case, that it's at least as attractive or more so than having stuck with the gas CC in 2017. But I guess in some ways, it's testimony to the fact that we did our work independently. We didn't try to align it with his.
Thank you, Mr. Graves. I just have a few remaining questions for you. And these relate to Exhibit SC-4, which If you don't have on the Dropbox, Mr. Gifford, I believe, emailed this document to you as well.
I think you did as well. Yeah, let me find that. Okay, I think I have it. This is a set of interrogatories.
Yes.
Okay, I have it now.
Would you please take a moment and review this document and confirm that it contains discovery responses sponsored by you?
Yes, these are all responses from me to your interrogatories, to Sierra Club interrogatories.
So to confirm, you've seen this document before and you're familiar with its contents?
Of course, yes, I prepared the answers.
Your Honor, I move the admission of Exhibit SC-4.
Any objection?
No objection.
Hearing none, Sierra Club Exhibit 4 is admitted.
Thank you very much, Mr. Graves. Thank you, Mr. Hearing Examiner. I have no further questions.
Fine.
You sure? Ms. Gerhart?
Yes, I'm
No.
sure, Mr. Hearing Examiner.
I'm only partly joking. I've always got, sorry that my sense of humor is kind of, my wife doesn't like it, let's put it that way, sometimes. But no, I was partly serious because we had for the first time and maybe hopefully the last time, I admitted sir rebuttal testimony. So we had a lot of testimony from Mr. Graves for you to go through, and I want to make sure you had enough time to do your cross-examination appropriately and fully.
I very much appreciate that. Thank you.
Okay, thank you. Yeah. All right, so next up is Ms. Beatles. You have 10 minutes.
I have no questions for this witness.
Okay. Water Utility Authority, Mr. Harris.
I do have some questions. Thank you, Mr. Hearing Examiner.
All right. You have up to 30 minutes.
Okay.
Sorry,
Mr.
Judge, I
Harris?
didn't hear you. I'm sorry,
Yeah,
Judge.
I was trying. No, yes. Thank you, Mr. Lee. I was trying to indicate that Mr. Harris had reserved 30 minutes with Mr. Graves.
Well,
Go ahead.
thankfully, for both the Hearing Examiner and Mr. Graves, it will be much shorter than that.
Whatever.
Okay. It all pays the same, as they say.
Let's try it. Yeah, sure.
Good afternoon, Mr. Graves.
Nice to meet you.
Okay. Please turn to page 5 of your supplemental testimony.
All righty. Page 5.
As we say, scroll down.
Yep.
Okay.
Yes, and the modern.
And looking at lines 10 through 12 of your testimony.
Okay, I have it.
Are you familiar with the testimony of Miss Crane in this case?
I believe so. Yes.
Okay. And did you listen to any of her testimony, oral testimony, when in this case?
A little bit, but not too much.
Okay. This
I was
seems
busy writing my sir rebuttal at the time.
you gotta, you know, idle hands are the playmate of the devil. But there was a discussion that she had, and I'm not going to quote it, but it seems to me that your testimony here on these lines touches upon what she was struggling with, which is if a utility invests prudently and technology changes, what happens then? Who is to bear the cost? And as I recall, and I'm not going to testify for it, there's a consideration of risk that a utility undertakes when they make an investment, and that's one of the reasons that they get a heightened return on their investment. Do you agree with that analysis?
Sure, at a very general level, that's completely true. The utility investors bear a certain kind of risk and get ideally an allowed ROE that's commensurate with it. The question, though, remains about what kinds of risk that covers and who bears them. And one of the things I think I disagree with Ms. Crane on is that if an asset that is invested in turns out to be
I'm sorry, sir. Is that in finance terms?
No, is that if an asset is invested in by a utility and it turns out to be a huge success, saving even more money than it was expected to, the utility only recovers its costs and all of the benefits go to the customer. All of the extra savings that good decision produced are to the benefit of the customer. If the opposite happens, where a good decision is made but adverse circumstances arise, if the utility now has to absorb the downside for that to protect the customer from that experience, it ends up with a funny kind of a deal where it can make its costs and only its cost in fortuitous circumstances, and it loses money in adverse circumstances. And any plan is going to have a little of each built into it from the beginning of its choice. So if you take away the money when a prudent decision turns out to be not still attractive, you're making it the case that the company cannot expect to earn its cost of capital from day one. It's built into the investment that there's a likelihood that it will get curtailed and not earn its cost of capital. So that's why I think the risk bearing actually calls for continued full cost recovery, not sharing, as you would suggest.
So that reasoning would apply to, I guess, a multitude of stranded costs where utilities have to, for one reason or other, abandon generation resources. Haven't regulatory commissions struggled with this issue?
Very true. There's always two questions. One is, why was it stranded? Is that proof that something untoward was done years ago, or is it just bad luck? And then there's, as is occurring here, the question about what's an equitable risk bearing for that. And I think that's where the confusion often arises, because customers understandably would like to not pay for an asset that's not performing as well as hoped. But they wanted the utility to choose that asset initially when it was expected to produce savings, but not guaranteed to produce savings. So you kind of can't have it both ways.
But it sounds like from our discussion, you would favor, when the commission, all else being equal, when the commission is looking at stranded costs, you would favor 100% recovery of those costs to going to the utility.
To the extent they didn't arise out of mismanagement, but simply changing market circumstances that were bad luck, yes, I would say that's on the equitable solution is full recovery.
Okay, then skipping down to the last line on page 5 on line 18, we're continue that conversation about what's the remedy. And then going on to page 6. And this expresses your idea of the 100% recovery in the event that a asset no longer is the best asset. But the question that I have is, if the utility bears no risk of changing circumstances and an asset no longer being the most cost-effective asset, why are they paid a risk premium?
They're paid a risk premium for bearing many other kinds of risk. There's lots of uncertainty about whether even a prudent asset that's fully in rate base will earn its cost of capital that are associated with things like changing load conditions, ability of customers to pay under stress conditions like recessions and so on, whether the cost of money will, become volatile and change relative to their initial expectations. So they're bearing risk, but a risk that if circumstances turn out to be bad relative to original expectations, they will get penalized is not one of the risks they're bearing. And in fact, financial markets don't even score that risk in the cost of capital. They treat it like an insurance loss that you might face. It lowers the value of your assets, but you don't get a markup in future returns because of it.
Okay.
The market will not tell you, oh, because you have this risk, you should earn more. It doesn't. It just marks you down.
Okay, let's turn to your rebuttal testimony.
Okay. Okay, I have it. What page?
Okay. Oh, I guess it's one of the deals in this case is the various experts have various opinions on this cost recovery issue.
Yes, that's for sure.
and that's why every expert, it seems to me, that's testified in this case has come up with different remedies. So it is not as simple. I think, as the hearing examiner characterized it, it's a troubling issue. Okay, on your rebuttal testimony, on page 11.
Page 11. Okay, I'm there.
Okay, and the heading on that is disallowance of investments incurred after, and you're dealing with your remedy here.
Yes.
Okay, and then here's my question. Going down to the bottom of the page, and then going on to page 12, you're discussing that the commission has already penalized the PNM, and that should be sufficient. Is that sort of your conclusion on page 12?
Well, I guess there's sort of two parts to my conclusion. First, I would, in my own view, the supplemental analyses I presented showed that PNM was not imprudent. They weren't impressive in the way they did their analysis, but they weren't imprudent. In that I think they chose a resource that they would have chosen with even more analysis that would have fulfilled some of the criticisms that were raised in 2016 and since. So I don't think it merits disallowance because of, I don't believe there's imprudence. But here I've switched the question to, okay, let's concede or suspend that question and just say, has there been harm? When you think about an imprudence calculation, it's looking at the present value of cost for 20 years out, say back in 2013, some of which would not happen until 2033. But we're only in 2021. So some of the present value of what was might be deemed to be a bad decision hasn't even happened and may not happen yet. So I'm suggesting we need to switch to focus, if you believe there's been imprudence, to saying how bad is the consequence of what happened, not how big was the mistake in the analytics at the time. And when I run those numbers, I also find there really isn't a good reason to believe that there's any net harm, because the current plan for Four Corners abandonment actually mitigates almost all the concerns that would have arisen from the original choice. So I think the answer is 0 because of that. I'm simply pointing out at the end here, if you do decide that there's some number that you want to penalize, you ought to net out the fact that you've already taken some out.
Okay, hold that thought, because that's the follow-up question. But the question I was really going to ask is that in 16276, did the hearing examiners and their recommendation limit their analysis to the selective catalytic reduction issue in the case?
No, I don't believe so.
Okay.
They're worried about all the other expenditures as well.
And subsequent, didn't the commission in their final order in 16276 reserve further action that they put in basically a placeholder on the prudence issue to be addressed in the next rate case?
Yes, I believe that's right.
Okay. So that at least it appears in the commission's mind, there wasn't a final resolution of what, if anything, in total should happen to the prudence issue.
I think that's fair. Yeah.
Okay.
That's why I submitted my testimony in part to help inform that.
And then the what I told you to, hold the thought was on your proposed remedy. Isn't this in fact an analysis now? Isn't your analysis really a hindsight review saying that there's no harm? No harm, no foul.
The rebuttal testimony is a hindsight review. That's correct. The supplemental is a foresight review trying to reconstruct an improved 2013 assessment.
Right. And then your rebuttal is, well, in hindsight, it didn't cost anything, so that there shouldn't be any further action on the part of the commission.
Well, or at the very least, it didn't cost anything resembling all of the expenses since 2016 or 2017, which is a couple $100 million. You can quibble about my analysis and maybe say there was some harm, but I can't imagine anyone could conclude that it's $200 million worth of harm.
Okay. Well, thank you on your insight into all this. I appreciate it because it will help us move the ball on what do we do now, which is the core issue in this case.
Sure.
And all the hearing examiners or the experts in this case are opining on what a fair resolution would be. So thank you very much for your testimony.
Sure.
Mr. Hearing Examiner, that's all of my questions.
Thank you, Mr. Harris. Mr. Borman, you have 15 minutes with Mr. Graves.
Thank you, Mr. Hearing Examiner. My questions for Mr. Graves have been answered already.
All right, thank you, Mr. Borman. Mr. Graves, mine have not entirely been.
Okay, happy to try.
Thank you, sir. So you've testified in many utility proceedings in the past, haven't you?
Sure, I suppose it happens once or twice a year for quite a part of my career.
And you testify in the capacity as an expert witness as an economist? Or how would you classify your expert testimony in most cases?
That's usually the label I've used. My formal training is actually in finance and mathematical optimization, but by virtue of 30-some years in the industry, I've done virtually all the kinds of planning analyses that utilities do and third parties in the industry do. So I'm pretty embedded as an industry economist.
And in doing your analyses, you're conversant with the legal and regulatory principles that inform your analyses, right?
I think so. Many of them, anyway.
In fact, they guide your analysis to a certain extent, don't they? Or should, at least.
Yes, I've tried. For instance, the notion of how to construct a prudence analysis from then prevailing conditions and the distinction between harm and foul, or in a sense, liability and damages is an example.
So generally, the legal or regulatory principles are set forth in old Supreme Court decisions that are handed down. And then the experts apply the analytical tools of regulating electric utilities, such as engineering, accounting, financing, economics. Is that fair?
Sounds about right.
And in this case, you performed in your supplemental testimony what the parties have called an ex ante analysis.
Could you spell that?
Yes, that's why I said it, Mr. Lee, because I wanted to spell it for you. It's EX, it's a Latin word, EX space ANTE. So EX is one word and ante, ANTE, is another. And that means, Mr. Graves, it's before the event or before the fact, basically, right?
Yes, in my supplemental testimony, where I reconstruct a 2013 forward-looking view, that's the ex ante part.
And then in your rebuttal, you do an ex post, EXPOST analysis, right?
Yes, which is looking back to see what's actually happened and what have been the consequences of 2013 decisions.
Applying data from the period after the event. That it wouldn't have been data known to PNM executives in making the investment decisions and decisions generally that we'll talk about before or in making their decision, right? You're applying data that looks at things looking backwards. In other words, like the definition of ex post, it's after the fact or after the event data.
That is completely correct, with one little proviso, which is I also look forward from the present to what the remaining implications of those decisions would be. So that's sort of midstream ex ante, I guess, but it's all ex post relative to 2013.
Fair enough. Good observation. Mr. Gerhardt showed you a letter that you wrote to Miss Stacy Goodwin, then associate. Yeah, I think it was Sierra Club Exhibit 3. I'm not sure, but I believe it was that one. But in any event, it was that letter from February 2021. Had you discussed the matter with PNM, anyone at PNM, before drafting or sending that letter to Ms. Goodwin?
Oh, to be sure, yes. We had been on the phone a couple of times talking about, what was what were the issues and what was the likely scope of the problem? What was the opinion that was already circulating?
And I'm going to go back to those overarching traditional legal principles that inform or guide your analysis. Did they discuss any particular case with you that might inform your standard first on the ex ante analysis or the ex post analysis? Sorry.
Okay. I would say no to both. We, I think, by common understanding and strong industry tradition, were completely aligned on the fact that an ex ante analysis was going to be required. And so, except for maybe wondering about which of the various analytic tools you mentioned before would be used, that was sort of the default assumption. The notion of doing I'm sorry, go ahead.
No, go ahead.
I was going to say the notion of doing the ex post actually hadn't occurred to us at the time. That arose as we looked at the decisions and the events since then to try to see what had been the consequences. And it occurred to us it's not so obvious that a harm has happened here, even if it was a bad decision. So that was something we actually thought of, shortly before the, in order to prepare the rebuttal testimony.
But just as a general idea, the decision that PNM that did not make in 2013, as of, I guess, the critical date that we found in the certification of stipulation was October 22, 2013. The critical decision that PNM did not make on that date was to exit the Four Corners power plant and not make $148.7 million in capital investments in the facility. But now it's seeking to exit Four Corners in this proceeding, right?
That all sounds correct to me, yes.
Okay. So they didn't discuss, or are you not familiar with otherwise, the Oregon Public Utilities Commission decision of Pacific Corp from 2012?
Not at all. No, I was not familiar with that until it was raised in, I guess it was raised in your hearing examiner's report. So until seeing it there, I was not familiar with it.
When did you read the certification of stipulation?
I certainly scanned it back in the times when we were formulating our proposal, but I don't believe I read it carefully or in its entirety until sometime thereafter.
Did you ever read the PNM versus NMPRC decision from 2019, from July 2019, which addresses the Pacific Corp decision from the Oregon PUC?
I don't recall reading that, no.
Is that PNM tends to emphasize some language in that decision that seems to support your analysis.
Okay.
And that is, and let me read it to you. It goes through the standards. So I'll go through the standard from Pacific Corp is basically prudence, and I'm reading from the Pacific Corp decision. That the numbering is Oregon PUC Lexus 474, and the Lexus numeration is 71 to 72. It goes on to 73 and 74 with the Lexus numbering. And I'm sorry for that, but that's what the commission's subscription is to now, is to Lexus. So bear with me. But basically, it's prudence is determined by what a utility, quote, knew or should have known, quote, at the time the decision was made. It is possible that the utility may be able to present sufficient information from external sources, and in parentheses, what it should have known, to establish that its ultimate decision was prudent, regardless of what internal decision-making process was used. And then in parentheses to finish the quote, what it knew. It seems to me that that's what the, that sets the framework for the ex ante analysis, at least, right?
It does seem very harmonious, yes. We offered to reconstruct and evaluate whether we would have made the decision the same way or to the same decision at all. And so from our point of view, that included knowing what you knew and bringing in anything else you should have known.
Well, that's apparently what PNM interpreted you as doing, because Ms. Sanchez's testimony, Laura Sanchez's rebuttal testimony says that that's basically what you did, because in her rebuttal testimony on page 22, she says, and I basically quoted that language, and she talks about the external sources.
Okay.
She emphasizes external sources. And then she says, the evidence presented, starting on line 5 of her testimony, rebuttal testimony, on page 22. Now I'm quoting Ms. Sanchez. The evidence presented by PNM witness Graves in his supplemental testimony is the type of evidence from other sources that the New Mexico Supreme Court said can be presented to evaluate and ultimately establish as prudent the utility's decision-making processes.
Okay.
So it sounds like when they paid you for the supplemental testimony or asked you to conduct that study, they had in mind the external sources language from that it initially came from the Pacific Court decision that the Supreme Court cited with, if you will, approval, for want of a better term. Okay.
It's certainly plausible that I wouldn't be at all surprised if the attorneys were well aware of that precedent. It wasn't part of our conversation, but there may have been something they were hoping would emerge from our analysis.
Yeah, and so when I'm talking about external sources, there's a point of concern here that some of the lawyers may not have realized or grasped, or probably did grasp, in the Supreme Court's quoting of the Pacific Court decision. Because now I'm quoting from the PNM versus PC decision, and it's in paragraph 32, and they quote the Pacific Court decision to say, it is possible that the utility may be able to present sufficient information from external sources, and then there are 3 ellipses, to establish that its ultimate decision was prudent, regardless of what external decision-making process was used. Now, what's interesting is the ellipses leave out what it should have known, that parentheses, right? Okay, see? And so, but at the same time, the Supreme Court says, quoting from my former colleague's rendition of the prudence standard, that and it's quoting, and there she's quoting case number 2087. And this is paragraph 29 of that 2019 PNM PRC decision. Prudence is the standard of care which a reasonable person would be expected to exercise under the same circumstances encountered by utility management at the time the decisions had to be made. In determining whether a judgment was prudently made, only those facts available at the time judgment was exercised can be considered. Hindsight review is impermissible. Imprudence cannot be sustained by substituting one's judgment for that of another. The prudence standard recognizes that reasonable persons can have honest differences of opinion without one or the other necessarily being, quote unquote, imprudent.
Okay.
Do you disagree with that standard?
No, it sounds to me quite harmonious with what I think is the general philosophy in nearly every state regulatory jurisdiction.
Indeed. And it says there that in paragraph 30 that thankfully for PNM and you, PNM does not disagree with the prudence standard
there we go.
Articulated above.
Mm-hmm.
So, but in any event, looking at that standard, what it should have known, my point is that your ex-ante analysis, which is detailed, looking back at what the various things that hearing examiner Schanauer and I found so disturbing about PNM's decision to continue with the Four Corners, your ex-ante analysis actually makes what PNM did arguably even worse, even more troubling. even more disturbing that they didn't. What they should have known is you highlight some of the things that they should have known. Am I making sense?
Well, sure. That was to some degree my aspiration, is to say, what do I think they omitted? And now I can't claim to be 100% exhaustive of everything that additionally could have been brought into the analysis, but I at least picked the things that I thought were most commonly significant drivers of those decisions and updated them as I could.
Wouldn't a prudent utility executive should have known of those data pieces that you articulate or bring forward in your ex ante analysis?
Yes, and I'm not by any means endorsing the rigor of their analysis in May 12, 2012, or at the end of 2013. I guess what I'm attempting to show is, whether by luck or by intuition, they ended up about in the right place anyway. And I don't think it's just out of indifference or ignorance, because as I mentioned, these are sophisticated system planners, and they would have known, for instance, that gas prices had changed and the carbon outlook was different, and some of those were likely to be helpful and some weren't, and also their system needs were changing. So, they would have known that generally what was happening, but they wouldn't have run the numbers like I did.
But gas prices were, in fact, historically low, according to your testimony during that period.
They were quite low in 2012, and looking forward from there, by the end of 2013, a couple of forecasts were down from there, and another one was up considerably. There was a lot of uncertainty about gas prices at that time because the fracking technology was new and it was being pursued for reasons that weren't always economical. There were a lot of financial incentives to develop wells that didn't have anything to do with the value of the gas. So a lot of people thought that was going to go away and prices were going to rise. Other people thought it was going to be cheap forever. And
yeah, I'm very familiar with the debate. I was immersed in it during that time period and looking at different replacement resources in various challenges, not involving PNM necessarily. But I'm very familiar with the terrain. But in any event, juxtaposing your data sets with what the utility executives of PNM actually looked at and did, which we chronicle in detail in our decision, one could argue that your ex ante analysis is actually a damning indictment of what they didn't know and should have done. Respond to that, please.
Well, I certainly agree. They could have known that and may have known
Should
it
have.
and should have.
You were going to say should, weren't you?
I guess I don't know that they didn't, but I do know they didn't do an analysis with it. So I think it would have been helpful to do an analysis. I guess I would say they should have done that. But again,
so, no, you're saying they should have done it.
Sure, I think it would have been a better analysis to use things more comparable to mine, and in principle to use even more analytic techniques. But they're under time constraints and other reasons for what they did. So I'm not able to judge the full context.
Yeah. And then on page 9, now shifting to, you had done a little bit of a shift, and I want to go back to it for a second. We were talking about your ex ante analysis. That's what I'm still talking about.
Okay.
But it seemed like then you subtly shifted to your ex post analysis and saying, yes, but looking forward, it turns out it was, and I can go back through real time and find it. But did I detect a shift in your approach a few minutes ago? I can go back and find it. And I have the transcript here. I can go back and find it, but I'm going to ask you first to hopefully not to delay the discussion.
Sure, no, that's fair. I think a moment ago we were discussing a portion of my my SIR rebuttal testimony, which is admittedly a shift from ex ante to ex post. But it was over the question of whether I was saying in general there shouldn't be any damages because it was a prudent decision and just forget about it, or there was more than one reason. And I'm simply saying there's more than one reason. I don't think it was an imprudent decision. It was a bad process, but it wasn't an imprudent decision. But I think even if it was a bad decision, the harm is very small or zero. And so that's why I flipped it just from sort of liability to damages.
Which goes to your ex post analysis, right?
Correct. Yes.
So it was a shift. It's from your ex ante prudence / assistance
right
analysis. In other words, help PNM in making it look prudent versus an ex post damages analysis.
That's exactly right. Yes.
Okay.
I'm trying to offer two kinds of analyses that are different purposes.
I get that. But let's go back to your rebuttal testimony now.
Okay.
And I'm not talking about your ex post analysis yet. I'm looking at where you say on page 9 at the bottom on line 18, starting there at least, you say, because the commission's final order did not adopt the hearing examiner's findings, relying on those findings is a flawed approach. Right? What do you mean there?
I certainly do say that. I guess I just was meaning that isn't as I understand it, a formal decision, and that in fact we're still in the debate about the prudence of the activity, even though there was a strong statement suspecting it was imprudent in the 2016 certification.
Are you aware that on December 20, 2017, the commission issued an order partially adopting our certification of stipulation?
Generally, yes, I am.
And are you aware that the commission there did adopt our findings on imprudence?
I believe so. I can't claim to remember that in close detail. Here I was simply commenting on the fact that the 2016 finding was by itself not that dispositive.
And yet it would be fair to say, and you call it a flawed approach, it would behoove you in doing your analysis that you look carefully at the evidence marshaled in the certification of stipulation on the issue of imprudence, right?
Very fair, yes. And in a large degree, I attempted to do that with the first aspects of my supplemental report, which addressed the questions of capital expenditures, and which was a big factor in the perception of sloppiness and inaccuracy in the PNM analysis. But admittedly, I didn't cover every one of them.
Okay. And to be clear, let me go back to where I should have started on this. Now, when we're talking about the prudence determination, and I think some of the lawyers touched on this, but I want to make sure that for future reference that we're working again off the same sheet of song of music, and that is that we're looking at PNM's final decision on October 22, 2013 to extend participation in Four Corners, the operating agreement, and the coal supply agreement, and making investments in SCR and additional capital improvements between the roughly 2016 to 2018 period, correct?
Sure, all the ramifications of that commitment that spilled out from it were.
Now, okay. Now you recall that I read to you the legal standard, the regulatory principles that guide your analysis. Looking at your ex post analysis, isn't that a hindsight analysis, a textbook hindsight analysis?
entirely. And I don't feel like I've contradicted myself there because I'm not offering it as a prudence analysis. I'm separating the two and saying you can have your own opinion about the prudence. Mine is that it was not imprudent, but obviously that isn't a shared view from everybody in this proceeding. But we can then say, okay, how bad is the consequence of what was chosen versus what is being represented as well? What would have been a better choice? That's a hindsight question.
But it's an interesting methodological issue because what you do is you negate that determination on disallowing the investment on the SCR at Four Corners and the additional $58 million in capital additions or capital improvements by shifting out of the paradigm of prudence to a paradigm of an ex post damages analysis, which is a hindsight analysis. And in the process, you wash away the determination of imprudence entirely.
Well, that is a mathematical result of the way I deem the hindsight analysis to be properly done. But it could have gone the other way. There's no finding that said, or no basis for saying a hindsight analysis will always clean up a foresight analysis. It could easily be that in hindsight, it was far worse than was expected, that the coal plant became worse and worse and worse, and the gas plant became better and better, and there was no mitigating, so that maybe the damages are much larger than the consequence of the original decision. Because the original decision is a valuation based on expectations. The consequences are based on real circumstances that have evolved. It just happens, I think, that in this case, they are not worse than the original plan. And PNM has, with its abandonment, a means of mitigating the exposure going forward.
Okay, I want to be clear what we have established, though. In doing your external sources analysis, that applies to the ex post damages analysis as well, right? Correct? I want to go back and try and find the legal principle on which you hinge your ex post damages analysis.
Okay. Well, of course, it uses external sources. You're right about that, but so did the ex ante. I guess what I was trying to get at.
Hold on for a second.
Yeah, sorry.
Because what I'm liable to hear from PNM in briefing is, well, the Supreme Court said, look at external sources. And that's what we did in both analyses, and therefore that's incorrect. But that would be profoundly imprecise because that ellipses, you see why I'm focusing on that ellipses, what they should have known. It's still clearly an ex ante prudence analysis that we're talking about. That's the theoretical construct on which a determination of prudence or imprudence is based. Now, let's step out of that and go to your ex post damages analysis.
Okay.
What is that founded on, if not the external sources from PNM versus PRC, reading, maybe not too carefully, the Pacific Corp decision?
Oh, well, I certainly didn't try to ground it in that. I'm not offering it as a fine legal assessment. It really is more like the basic principle of liability and damages, that damages should restore the injured party to the situation they would have been in had the liability not occurred, but not better. It shouldn't make them better off than if the problem had never occurred. So what I'm trying to do is figure out how much harm has occurred that needs to be rectified, so that the ratepayers are put back to a whole position, but not made sort of better off where they can have their cake and eat it too, where they disallow a lot of money and get the benefits of a situation that's less costly than was expected.
Yeah, make them whole, not make them rich.
Right, exactly.
Have you ever performed this kind of an ex post analysis in a utility proceeding before?
To be honest, no. I am borrowing it from my experience in civil liability and damages cases.
What sorts of cases?
Oh, I've been involved in dozens of them where contract performances were breached or failed, and one party sued for the lost performance or for the lost profits. There's a variety of ways that damages can be calculated, and pretty much unless there's a finding of malice or negligence, usually those are designed to, once liability is established, to repair the damage, but not over repair the damage.
And right. And in any of those cases, have opposing attorneys in the civil cases ever criticized your analysis on the base that it's heavily biased cherry picking?
Well, I can't say that they haven't disagreed with them. Of course, there's always room for arguing about assumptions, especially if some of it is prospective conditions to be occurring in the future. So sure, there's been disagreement, but I haven't been accused of bias.
Well, I think counsel in this case, counsel for some of the parties do criticize, or at least Dr. Fisher maybe criticizes you for engaging what effectively is biased cherry picking.
Sure, I think he did, which I, to be honest, I find a little offensive, but.
Good. Okay, please respond to it for me and for the commission. I'm here right now, just stepping out of the picture for a second, but I'm listening.
Okay. Well, I think the main objection I have to that is that, as I described, we were operating in a manner independent of PNM's oversight or control as to methods, data sources, scope. And we were basically asked with a quite open question to say, what is the exposure that PNM has here to being found imprudent? But it was an open question. So PNM was very ethical in my view on that, and we certainly would have been offended if they had said, we need you to find X or Y, or we'll only give you this or that data. So A, that did not occur. B, there's nothing in the sources or assumptions that I made that aren't related to the way industry planners do this all the time. Dr. Fisher, suggests some adjustments. I described, and I don't mind his disagreement. For instance, we disagree on whether it's better to use cash costs versus revenue requirements. But that's not a source of bias. It's just a methodological disagreement and one can work in some circumstances as well or better than the other. He hasn't, in my view, been consistent about the way he suggested improvements. But disagreement is not bias. That's what these hearings are for, is to argue about what should have been assumed.
And don't take what I'm saying as criticism. I'm trying to take the case in and understand it.
Oh, perfectly fair. I understand why you're asking. I'm just saying I think he overreached in that opinion.
Okay, fair enough. I think I have one more question in regards something that you said regarding, may have been in your supplemental testimony. I'll find it here. Hopefully. it's in your supplemental testimony where you talk about the problems with coal, and I'm paraphrasing, and the desirability of maintaining a coal generating source were not readily apparent in the time frame that PNM was making the decision. Do you recall that testimony? I highlighted it, but I'm not coming up with it right now.
I do recall generally discussing the fact that, you know, the coal, there's been some bad surprises for coal over time. And I'd be happy to explain why I think not all of them were foreseen.
Yeah, please.
But I
please
don't
do.
remember
Go
where
ahead.
that is.
I'll find it. Go ahead.
Sure.
Just generally.
Well, starting around, you know, 2013, 14, 15, through that time frame, the whole coal industry began to shrink because it was finding that the persistent low price of gas was making the marginal cost of power low in their market areas. There was far less load growth occurring after the end of the financial crisis than had been expected. And there was a big improvement in the relative cost of renewables, but really very little of this was foreseen even 2 or 3 years before to the same extent that it actually occurred. So a lot of coal plant companies were caught by surprise and have continued to be finding that, you know, decisions that looked smart in 2014 to add pollution control equipment or, you know, recontract now aren't looking so good. Some of that pretty much surprised everybody as to the persistence and depth of those changes. And now I think companies like PNM and others that are saying, well, it's time to fess up that this isn't working any longer and change our approach, I think are actually doing a favor, not admitting they were foolish.
Okay. And yet, a utility company down the road, down Interstate 25, El Paso Electric, apparently decided in as early as 2009 to terminate its participation in Four Corners. It had seen, and that's according to the commission's own findings.
Yes.
That Ms. Nanazi talked to you about a little bit, right?
Yes, I understand that to be the case.
So those executives down I-25 in El Paso, at El Paso Electric, looking at this, had seen the writing on the wall about coal, apparently, already. So it's fair to say that the indicators were there, isn't it?
I would say in 2009, there weren't very many indicators that emerged much more in a few years after that. But I think the real, you know, I can't claim to have studied that decision in close detail, but I believe they basically decided they only needed capacity equivalent to Four Corners. They didn't need the energy because they were the shape of their demand and the circumstances they were in didn't require it anymore. So they already started to evaluate getting peakers, which would be a cheaper thing to own and maintain and more flexible. But it doesn't mean they thought coal was generally a bad thing for anybody. It was just not their thing anymore. It's sort of like if you move to the city and you don't need a car anymore, maybe you can just take taxis because they're kind of like peakers. You use them when you need them.
Yeah.
But it doesn't mean cars are a bad thing.
Well, on page 16 of the certification of stipulation, in case number 15-00109-UT, hearing examiner Sondheim lists the factors that EPE considered. And the first factor was an analysis, and I'm paraphrasing, that accounted for Four Corners' expected future capital and operating expenses, including costs to install SCR required to comply with existing environmental regulations, right?
Yes.
And then the second factor, the third and fourth go to what you were talking about. But the second factor on page 16 is the risks associated with potential future environmental regulations and litigation that could ensue if EPE continued as a co-owner. These risks have become particularly acute over the last several years as coal has become an embattled EMB-ATT-LED resource. This factor clearly favored alternatives to the coal-fired Four Corners. Do you disagree with that finding?
No, I certainly believe that could easily have been part of their concern.
So when did coal become clearly embattled or become an embattled resource?
I suppose you could argue that it was at risk, but back in the early 2000s, when people became gradually aware that we were facing a climate change problem and that renewable resources would be needed in the future. But as you know, that of course has been not a universally adopted viewpoint, unfortunately. And now we have a significant part of the country that to this day doesn't accept that. And there are regions where their regulatory and state administrative agencies are trying to protect coal rather than trying to make it go away. So that it's been in the crosshairs for a while, but it hasn't been obvious where the outcomes would shake out, unfortunately.
Mr. Graves, thank you. I know you've been on the stand a long time, but I appreciate you engaging me so directly.
Sure, happy to chat with you.
Thank you, sir. Mr. Gifford, redirect.
No redirect, Your Honor.
Mr. Gifford, again, thank you so much for your testimony. I truly appreciate it, and the commission does as well.
Thank you very much.
Okay, you're excused.
Thank you.
Your Honor,
Thank
this
you.
is Mary Nessie. I forgot to move my exhibit 3 into the record, and I move that at this time.
Is that the certification of stipulation?
No, that was the
No.
interrogatories that I asked Mr. Graves about that he answered.
Okay. I'm not sure that exhibit is still is marked. I looked at it. I took it off screen because frankly I moved along. I've got a lot of different documents in my PDF on my PDF screen here, and that one is one that I moved off a while ago. But if I go into your NEE folder that I downloaded again, let's see if exhibit 3 is here. It's here somewhere. I want to make sure that I was not mistaken. Yeah, it's not marked. It's still not marked.
I believe that actually when you opened it, you said, "Oh, I see the marking. It's marked correctly."
This version is. Yes, this version that I just opened, I found the first page of it. It says NEE exhibit 3 at the top. So is there any objection to that exhibit?
Sorry, I just want to make sure I'm on the right exhibit, Ms. Nanasi, and Your Honor. That's the interrogatory 3.5 that you had Mr. Graves read, Ms. Nanasi. Is that correct?
Yes, and I also asked him about new energy economy 3.4, and he agreed.
Yes. Okay. Yeah, no objection. I just wanted to make sure I was in the right place.
Okay, thank you, sir. Hearing no objection, new energy economy exhibit 3 is admitted.
Thank you. I'm sorry,
Okay.
I forgot to do it at the time.
No worries. Thank you. With that, I see Ms. Eden is with us. Would you mind, Ms. Eden, if we took a 15-minute break? We've been with Mr. Graves for quite a while this afternoon. Would that be okay, Mr. Gifford?
That would be fine.
Thank you, ma'am.
Certainly.
Okay. 3:45, folks. See you then. Thank you.
Mr. Lee, can you hear me okay?
Yes, ma'am.
Great. And I do have a bit of an accent, so I feel sorry for you.
Don't worry about it. We'll find a way through. I can't hear you, Judge.
Hang on just a second. All right, Mr. Lee, can you hear me?
Yes, sir.
Okay, I thought I had that problem with the earbuds again. Ms. Eden, before we turn to your testimony, I wanted to address something with counsel regarding the continuation of the hearing, or hopefully ending the hearing on Thursday if we can get some cooperation on moving witnesses around. Mr. Borman, your witnesses have in total 1.6 hours of cross-examination remaining, or to do, or have performed by the parties. And tomorrow is a relatively light day because we have 1.1 hours for the community group's witnesses, and then the only other witness is Mr. Dauphiné. Would it be possible to shift the staff witnesses to tomorrow after the other witnesses? If we do that, Wednesday is a heavier day, and then Thursday is a heavier day in terms of Dr. Fisher and the other witness who remains to testify. So, who is Mr. Sandberg. So, but still, even there, we could move those staff witnesses to Thursday, preferably tomorrow because it's a relatively light day. If we have cooperation, I think we can finish Thursday.
I can tell you, Mr. Hearing Examiner, I have informed my witnesses about the possibility of testifying early in this case, although I did not indicate that it could be Wednesday, and so I'll have to check. But I will see what I can find out and get back to you before we break today.
That's why I'm interrupting Ms. Eden's cross-examination, is precisely for that purpose. So thank you. And would there be any objection to me shifting the staff witnesses to earlier than Mr. Sandberg or Dr. Fisher?
No, Your Honor.
I think I'm thinking that if we pursue this approach, we'll be done on Thursday. We'll still have time to discuss the legal issues. I called it an oral argument last Friday. I'm not entertaining. I'm going to retract that. I want to have a discussion, not an oral argument. It's premature to have an oral argument, but there is room to have a discussion to frame the issue. So we'll call it a framing discussion, if you will. Hopefully now on Thursday morning or Thursday afternoon. We'll see where we are. Okay, with that, with PNM, please call its final witness.
We are pleased to call our final witness, Your Honor. We call Elizabeth Eden to the stand.
Welcome, Ms. Eden. We need to swear you in.
Would you please raise your right hand? You do solemnly swear the testimony you're about to give in the matter now pending shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good afternoon, Ms. Eden.
Good afternoon.
Ms. Eden, could you state your name for the record and tell us what you do?
Yes, I'm Elizabeth Eden. Often go by Lisa, and my title is VP and Treasurer.
And Ms. Eden, do you have in front of you what's been pre-marked as PNM Exhibit 18, the rebuttal testimony of Elizabeth A. Eden?
Yes, I have that testimony.
And did you prepare this testimony or was it prepared under your direction?
It was prepared under my direction.
And do you have any corrections to that testimony?
No, I don't.
And Ms. Eden, if I were to ask you those very same questions today on the stand, would your answers be the same?
Yes, they would.
With that, Your Honor, we move the admission of PNM Exhibit 18, the rebuttal testimony of Elizabeth A. Eden.
The objection? Hearing none. PNM Exhibit 18 is admitted.
Your Honor, Ms. Eden is available for cross-examination.
Thank you, Mr. Gifford. Mr. Albright, I see you have 7 minutes reserved for Ms. Eden.
Yes, Mr. Hearing Examiner, thank you. Good afternoon, Ms. Eden.
Good afternoon.
I'm Jeff Albright with J. Albright Law LLC, and I'm here on behalf of Bernalillo County this afternoon. Obviously, there's rebuttal testimony I'd like you to turn to. Let's begin at page 6, if you would, please.
Yes.
Okay, and at line 2, you talk about the Standard & Poor's downgrade the credit ratings of PNM and commented on the historically challenging New Mexico regulatory environment. Do you see that that language there?
Yes, I do.
Okay, in that comment, you referred to April 6, 2020. You see that date there at line 2?
Yes.
And that was after the passage of the ETA, correct?
Yes, the ETA was passed in 2019.
And that they did see that at lines 8 as a credit positive. Do you also see that?
That's correct.
So are you also familiar with previous testimony where there's an anticipation that with securitization, that the ability to get a AAA rating bond is what I would call more likely than not through the securitization?
Yes.
So what is the current rating for PNM right now with regard to bond rating?
It is BBB.
Okay, which is investment grade, correct?
That's yes, it is investment grade.
Okay.
Not far away from below investment grade, but it is investment grade.
But it doesn't have a negative watch, correct?
That's correct.
And so with the securitization and the prospects of getting a AAA bond relatively high, at least from previous testimony that we've heard, would you anticipate that the rating of PNM would have a negative effect on getting a AAA rating under the securitization?
I'm sorry, you have to ask that question again.
Okay, let me try rephrasing a little bit. We've had testimony and you've acknowledged that there's testimony that says that under securitization, there's a good likelihood of being able to get a AAA rating through the securitization, through the bonds that the consumers are going to finance. Would you agree with that?
Yes.
Okay. With the BBB rating, would you see that as hindering the ability to get a AAA rating under the securitization?
Well, the AAA rating comes from the ETA and the statute and the financing order and the state pledge. That's the whole reason you get a AAA rating. So the statute is set up such that you get the AAA rating.
Okay, so that will be, is your opinion that will be independent of PNM's rating?
Yes.
Okay. And conversely, if the securitization results in AAA ratings for the bonds under securitization, would you see that as helping or hindering PNM's BBB rating?
I would say that the securitization legislation is, like I said in my testimony, credit positive. And so the rating agencies really look at that legislation as a way for the company to transition out of coal and get cost recovery. And so there is some certainty and predictability surrounding the legislation. So that certainly has impact on our ratings.
So back to my question again, I'll try to rephrase it, but I'm not sure that I really can. With the securitization, do you see the securitization improving the BBB rating for PNM?
Well, the securitization legislation has already been passed. So the rating agencies incorporated and provided comments associated with that ETA and said that the legislation was credit positive. So they have taken that into account in their ratings.
And that's where I was going. You, with that understanding and with the act already being in place, it's your opinion that they've already taken that into account with the existing BBB rating for PNM?
Well, they have taken the legislation into account, but then you have to also put the legislation in place by getting approval of the securitization of both San Juan and Four Corners.
But those, if the securitization goes through, if it's approved, everything is approved here on both San Juan and even the lease agreement for Palo Verde or the Four Corners power plant, all of that would be part of the bond ratings for the securitization, correct?
So when you say bond rating, are you talking about the AAA bond rating on the securitization?
Yes.
Yes. So the securitized bonds, the legislation is really set up to achieve that AAA rating.
All right, and would you turn to the bottom of page 9, please?
Mr. Albright, since it was only 7 minutes, those 7 minutes have elapsed. I didn't give you a warning. I'll allow you to ask one more question.
I would like to ask one more question with your permission, Mr. Hearing Examiner, and that relates to the bottom of page 9.
Go ahead.
You indicate that PNM was downgraded, I'm speaking at line 18, that PNM was downgraded 2 times over a period of 4 months as a result of the commission's rejection of PNM's proposed fuel clause in the 2007 rate case. Do you see that language?
Yes, I do.
And that case was April 24th, 2008, when the decision was rendered in that case. So my question is, what makes you believe that it was solely the result of the decision in that case and not the economic climate that we were beginning to embark upon in 2008, 2009 with regard to the recession?
Because the first downgrade actually came after a recommended decision in that case. And so it was, and also the rating agencies published reports, and they were very clear on what the reasoning behind their downgrade was.
Okay, Mr. Herring-Zemmer, that's my one question. So thank you very much. Thank you, Ms. Eden. I appreciate your time.
Thank you.
Thank you, Mr. Albright. Okay, up next we have CCAE. Ms. Zuri, you have 5 minutes.
I have no questions, Mr. Hearing Examiner.
Okay, thank you, Ms. Zuri. Ms. Zanazi, 10 minutes.
Thank you. Good afternoon, Ms. Eden.
Good afternoon.
Isn't it true, Ms. Eden, that after the 13390 UT first San Juan abandonment case that PNM was required to take a write down of 50% of its undepreciated investments?
I don't have I don't recall exactly the write down in the 13 case. It's 8 years ago, so I don't have that those numbers in front of me. I'm sorry.
Could you go to New Energy Economy Exhibit 11, please?
Okay.
And then if once you're there, could you go to page 5?
Okay, hold on.
And that's the certification of stipulation in case 13390, Ms. Zanazi.
Yes, sir.
Page 5, yep.
And the certification of stipulation that we're referring to, this is from November 16th, 2015. Could you go to page 5?
Okay, I just want to see what's in front of me here. Okay.
And could you just read the last full line to the last full paragraph, starting with PNM should be allowed?
PNM should be allowed recovery of 50% of the undepreciated value of units 2 and 3, estimated to be 257 million as of December 31st, 2017.
And does that refresh your recollection that this is what the hearing examiner ordered in 13390 on November 16th, 2015?
And so is this the hearing examiner or is that the final order?
This is the certification of stipulation, the hearing examiner's recommended decision.
Okay.
Do you agree that that's what it says?
I just read it to you, yes.
Okay, and 50% of $257 million is 128 million and $128.5 million, correct?
That sounds correct, yes.
Thank you. Could you now go to New Energy Economy Exhibit 12? And this is the final order in that same case, 13390. And if you would, the pages are on the bottom, and It's page 12 of 27. If you could go to that page, please.
Okay.
And could you sorry, I'm lost my place all of a sudden.
I'm waiting.
Okay, the second to the last line on that page. Ooh, this can't be the right one. Okay, let me just, I will get back to that. Subject to check, I'll get back to that in a second, but subject to check, would you agree that PNM stock price on or about the date of this final order was approximately $30 per share?
Again, this is 2015. I don't remember what the stock price was in 2015, so.
Is it true that despite the fact that PNM was required to take a $128.5 million write-down, PNM stock has risen and continues to rise substantially since then?
I'm going to object to lack of foundation.
Sustained.
Ms. Eden, are you aware generally with the price per share of PNM stock? Is that something that you are aware of?
Yes.
Okay, so now I'm going to ask you that again. Is it true that despite the fact that PNM was required to take a $128.5 million write-down in December 2015, that PNM stock rose right after that decision and has continued to rise substantially since then?
Well, there's lots of reason why a stock price rises. So I'm not really sure what the correlation here between the two. So there's lots of reasons that the general stock market has also gone up quite a bit in the past 10 years.
Thank you.
4 minutes, Mr. Nazi, 4 minutes.
Thank you for that. But the stock price of PNM did not go down after the write-down. That's what I'm trying to get at.
Again, I would have to look at a stock chart, and I have to look at where the stock price was and what happened in the market. I don't think that one can just say you had a write-down and your stock price went up or down. You just have to look at the stock price and analyze how the stock moved and what the general market did. There's lots of reasons why stock price goes up and down.
And could you just answer this question? I understand that, that's fair enough. But after the write-down that PNM experienced as a result of the 13,390 case, PNM stock has went up and has continued to rise. That's all I'm asking you. And I understand that there's other criteria for that.
Objection asked and answered.
No. Overruled.
So I don't know if the stock price arose after the write-off. And again, the stock price has gone higher, but there's been times where it's gone down and there's been times where it's gone up. And if it was $30 in 2015, now it's higher. But it's also, I can also say that the market has also had, the general market has also gone up quite significantly in the last 5 years.
Subject to check, if the stock price was approximately $30 in December of 2015, and today's share is approximately, it's almost $50. Does that mean that PNM shareholders have increased their share value by approximately 66% in that time period?
Well, it depends on when you got into the stock. So there might be some investor that got in later and some that got in earlier. And yes, you have to do the math. And if you bought it at $30 and you're selling it at $50, you've made $20 in return.
And there have been other write-downs since 2015, correct? Like for balanced draft, and then also exclusion of acquisition adjustments, particularly with the nuclear purchase?
We have encountered other write-downs, yes.
And despite those bumps in the road, if you will, in the last 5 years, PNM shareholders have done well, maybe even very well.
I would say that there's a lot of other influences on the stock price. PNM is one utility. We have another utility is in Texas. And so the PNMR stock price is not only reflective of PNM's situation, but also of our Texas utility. So lots of things goes into a stock price. Write-downs is a small portion that goes into a large analysis on how you're running the company, how the company is doing, a variety of things. So I disagreed with your notion that while you have had write-downs, the stock has done well. I don't think that that's apples and oranges.
But it is your testimony that the stock has continued to rise and that PNM stock is doing well despite some of those write-downs.
Again, I think that that's my testimony is if you say that the stock price was in 2015 $30 and today it's close to $50, that shareholders have received a return. However, I don't know how they've compared to other utilities. I can't speak to how they compare to the general stock market. And when you come to the stock market, it's all about relative, how you're doing relative others.
Thank you. And now I found out, can I have this one last question? I mean, it's one last.
Can you see me on screen when I do this?
Does that mean, I'm done then? Okay.
Go ahead, one more.
Okay.
I'm just curious. If you guys are watching me, I'm trying to give nonverbal cues as well as verbal ones to not try and step on your cross-examination. So
Really
go ahead,
appreciate
one last question.
I made a mistake in my question before about Exhibit 12. I transposed the numbers. Could you go to page 21, not 12 of 27? And once you're there, could you read, please, the full last sentence of that final order in 13,390 that was at the end, delivered at the end, mid-December of 2015. 26.
Again, which one did you want me to?
Page 12, page 21, excuse me.
Yes.
And it's the sentence that begins with the federal and state cases cited by PNM. And you can ignore the parentheses and just finish that sentence if you would, please.
The federal and state cases cited by PNM response to interveners April exceptions May 1st, 2015 at page 31 to 32 supports its assertion that there is a risk of recovering the entire amount of a plant retired early due to regulations requirements, and therefore the certifications recommendation of 50% is reasonable, perhaps even generous. This approach is best described here.
Thank you so much. Have a good afternoon, Ms. Eden.
Thank you, Ms. Nanazi. Mr. Elliott? I think you're next. I had you down for, given this is that final change, you had 145 minutes overall. You were left with 51 minutes now with Ms. Eden.
Thank you, Mr. Hearing Examiner.
About how many minutes do you have, actually?
Well, I have, I wrote 42 minutes for myself as what I anticipated, but it's entirely possible. The conversation may be very engaging and interesting, and if possible, I may want the 51.
Well, you know why I'm asking, because it's getting late in the day. So
I do. I will make it by 5. I have childcare, so that's not even an option.
And we've got several cross examinations after you too. So, but not putting any pressure on you, but I've starting your 51 minutes now.
Thank you. Good afternoon, Ms. Eden.
Good afternoon.
I've not had the pleasure of meeting you before. My name is Gideon Elliott. I work for the Office of the Attorney General.
Nice meeting you.
It is nice to meet you as well. I would like to start with your background and your resume. You are currently the Vice President and Treasurer for PNMR, right?
That's correct.
And how long have you been in your current position?
Since January or February of this year.
And your resume also lists other positions you've held within the company. And I noted that you were the Director of Corporate Strategy. Is that right?
A long time ago, yes.
What approximately when was that?
I believe that was I would say 2007, 2008, perhaps.
And what exactly is corporate strategy, just out of curiosity?
It's working with the executives to develop strategy.
Okay. And in your capacity as Vice President and Treasurer, do you report to the PNMR board?
No, I report to the CFO.
And that is?
Don Terry.
Okay. Did you work with Ms. Sanchez in preparing PNM's filing in this docket?
No, I did not. As you know, I was a late addition to the party.
Okay. Your resume also states that, or I'm sorry, it's actually in your testimony, that you oversee the engagement with rating agencies. Is that right?
That's correct.
And also direction and management of finance staff and external resources. Would that include engagement with Mr. Atkins?
Not for this. I mean, I've certainly talked to Mr. Atkins, but I was not the one who brought him into this case.
Okay. Do you oversee any of the work with Evercore?
I've had dealings with Evercore, but there's various parties that also interact with Evercore.
Can you spell Evercore?
EVERCORE.
One word?
Yep.
Thank you.
And you're aware that Evercore was retained in 2018 to assist the board in providing services related to the merger?
Yes.
Okay. Do you serve on any committees within the company that report to the board or to
one more question. I guess I can you rephrase that?
Sure.
You puzzled me a little bit.
Do you serve on any committees or boards within PNMR?
Yes, I serve on a corporate investment committee that, and I also serve on a benefits governance committee. As an officer of the company, I am officers of other entities across the PNMR umbrella. And that's, and I could be, so I could be a board member of those subsidiaries.
Okay, thank you. Do you ever make any reports to the board or attend board meetings?
In my current capacity, yes, I often attend the finance committee when the board meets.
Okay. And does that include ever sitting in on the executive sessions?
No.
Okay. In your capacity, do you also assist in preparing SEC filings?
My group provides information to the SEC filings, but I'm not the one preparing it.
Okay. With respect to your responsibilities interacting with the credit agencies, these include Moody's, S&P, and is the third one Fitch? Is that correct?
We only have two ratings, and that's S&P and Moody's.
Okay. And these companies make periodic reports to PNM, is that right? Or reports on PNM, excuse me.
Yes, they publish reports.
Okay.
On PNM. Yes.
Do you ever meet with the companies or have communications with them before the reports are generated?
There's I think you asked several questions into one.
I can break it out. Do you meet with the companies before the reports are generated?
We meet periodically with the companies. And when we talk about the companies, I assume you mean S&P and Moody's?
Yes,
yes.
You refer to them as agencies, but they are for-profit entities, right?
So we do meet with them, usually once a year. We often have calls with them periodically as well.
Okay. Did you meet with Moody's prior to their September 1, 2020 report on PNM that you cite on page 5?
No, I did not.
Okay. I noted on page 5 that Moody's had issued a report on September 1st, 2020. And then they released a second report on September 4th. Is that right?
Can you point me, I'm sorry, to the testimony here?
Certainly, page 5, footnote at the bottom of the page, number 3. And
Yes.
then on page 6, line 8, it says on September 3rd, 2020, continuing to line 9, Moody's published an update to the credit analysis of PNMR. I believe Mr. Albright had asked you a little bit about this.
Yes. And your question?
It seems as if this was a change from what they were saying on the 1st of September, which was with respect to PNM, and then what they were saying with respect to PNMR.
Well, there were 2 reports, one for PNM on September 1st, and a second report for PNMR on September 3rd.
Okay. And the 2 weren't related. One didn't influence the other. Let me strike that. Is it normal that the rating agencies issue their reports so close to one another?
They do issue separate reports, particularly Moody's, on the holding company, as well as our sister utility, TNMP, and then PNM. So they do have separate reports for each entity that they rate.
In your conversations with the rating agencies, do you present materials or information regarding the ETA and its application to the Four Corners power plant abandonment?
So the rating agencies both take input from the company, but they follow legislation, they follow regulatory work, they make their independent analysis on the environment. So I would say we are one input and we will give our perspective, but they will make their independent analysis on various inputs.
So yes, PNM did provide materials or information on the ETA as it applies to Four Corners?
We would have provided information to the company on the ETA and how we would see it apply both to San Juan as well as Four Corners.
Did that information include reference to the modified stipulation in 16-276?
Well, when we had when we received the modified stipulation and when the final order came from the commission, we would have talked about the final order and the outcome of that final order. They would have also followed that regulatory proceeding very closely and would know what the final order said, independent from us.
So you did provide it, yes?
We provided what?
Information on the revised order partially adopting the certificate of stipulation in 16-00276.
Yes.
Okay.
We provide updates to the rating agencies, in particular when there are cases in front of the commission, and when their final order comes out, we'll have a discussion with the rating agencies.
With respect to this abandonment docket, have you had any specific conversations with the rating agencies regarding the 16-00276?
I'm not sure I follow your question.
Did you have any conversations with the rating agencies since September 1st, 2020, concerning the abandonment of the Four Corners power plant?
We would have, I was not in the position at the time in September 2020. As I said, I came into this position in January or February. But when we do file cases in front of this commission, we will generally let the rating agencies know.
Okay. Let me ask you, when did you first learn of the merger with Avangrid?
I was aware that there was a merger discussions in summer of 2019, I believe.
So you knew of the merger before Mr. Falgren, is that right?
I don't know. I would say.
Let me rephrase that. Let me rephrase that. You knew of the merger discussions prior to the announcement of the merger.
Yes.
Okay.
I knew there were discussions about the merger.
Did you know those discussions were with Avangrid?
Yes.
And how is it that you knew of these discussions?
I provided support in those discussions.
Okay. Are you familiar with the definitive proxy statement filed on January 5th of 2021?
I have seen it, yes.
Okay. Do you have that available to you?
I don't.
Okay. Well, let me ask, who asked you to provide support for the merger discussions?
I believe the general counsel did, Patrick Apodaca.
Okay. And at what point did you, are you aware that one of the provisions in the merger involves the requirement that there be a exit from coal with the approved abandonment of Four Corners.
I'm going to object to Mr. Elliott's characterization, Your Honor. Perhaps he can rephrase the question.
Ms. Eden, can I refer you to, please, what has been marked as Exhibit BC6, that's Bernalillo County Exhibit 6.
Hold on. Okay.
Can you turn to page 3 of it's marked page 3 of this proxy statement.
Yes.
And under merger with Avangrid, 2020 business highlights. Are you there?
Okay. Yeah.
I believe it's the fourth dashed point there. Facilitation of PNM resources, continued commitment to exit coal with the approved abandonment of San Juan plant in 22 and continued efforts to exit Four Corners coal plant prior to the expiration of ownership and coal supply agreements in 2031. Were you aware that the exit from Four Corners was a condition that must be met in order for the merger to be consummated?
Your Honor, I'm going to object again that Mr. Elliott's characterization of what this is not what this says.
Well, let me refer then to
why don't you refer to what it says?
Sure, certainly. Ms. Eden, are you generally aware that there are conditions that must be met for the merger transaction to close?
The merger agreements have lots of things that needs to happen before the merger can close.
Are you familiar with?
Wait. Please don't step on the witness's statement like that.
I'm sorry, Mr. Hearing Examiner.
Go ahead, Ms. Eden.
No, the merger agreements have lots of provisions in it.
Are you familiar with the provision? I think it's section 6.19 regarding Four Corners Power Plant.
I know that there are 2 conditions associated with the Four Corners Power Plant.
What are those?
They are a definite agreement to exit, as well as that we need to make all the applicable regulatory filings to obtain the approval, and both of those conditions have been met.
The definite agreement for the exit of Four Corners has been met?
Well, there's an agreement with NTIC associated with Four Corners. And obviously that agreement needs regulatory approval.
Right. And so is it your understanding that the commission must approve that agreement because it was filed with this application?
I said that the two conditions that are part of the merger agreement have already been met.
But you also said it requires regulatory approval.
Well, I said that the definite agreement with the NTIC has, we've already entered that into, we've entered into that agreement. And then we also need to make all the applicable regulatory filings, and which we also have done.
Okay. When did you learn about the purchase sale agreement initially, or when did you learn, strike that. When did you first learn about Mr. Falgren's efforts to find an exit from Four Corners Power Plant?
I'm not sure when I learned about Falgren's efforts to exit Four Corners. That was, I was not working with Mr. Falgren at the time. At the time, I was the VP of HR, and then I was head of IT. And so I had no interaction with Mr. Falgren on the Four Corners project.
What about the payment of $75 million for to NTEC for the coal supply agreement? Were you also not involved in that?
No.
You were not involved in that?
No, that was Mr. Falgren is the one who had the negotiations with NTEC. And I did not have any interaction with Mr. Falgren on this particular project while I was VP of HR and the CIO.
When did you learn that the one of the provisions of the merger agreement was an exit from Four Corners?
I don't recall. I think that first of all, I think the characterization of you talking about Four Corners, they called it divestiture in the merger agreement. Just wanted to make sure we had that straight, but I did not participate in any conversations associated with Four Corners in my work associated with the merger. And so I don't recall when that happened.
Turning to your testimony, I was struck by, well, starting on page 3, I was struck with the first line 14, that you don't believe write-downs are an issue in this case because PNM's application is governed by the Energy Transition Act. Did you hear the conversation prior to with Mr. Graves, between the hearing examiner and Mr. Graves?
I heard portions of it.
Okay.
I did not listen to Mr. Graves' testimony today. I was preparing for my own testimony, so I didn't really pay attention to Mr. Graves.
Okay. Well, subject to check, would you accept that the issue of write-downs does appear to be present in this case?
Well, I believe that we filed this abandonment under the ETA, and that the ETA applies to this case. And I even think that Attorney General's witness, Ms. Crane, said if the ETA applies, then there will be cost recovery. And the cost will be fully recovered.
That's your opinion, yes?
That's my opinion, and I think that there's several other witnesses in this case that have provided the same opinion.
So when you meet with the rating agencies, are you telling them that PNM is guaranteed cost recovery under the ETA?
When we meet with the rating agencies, we are sharing that we have made a filing under the ETA to abandon Four Corners.
I know, but my question was, are you telling them when you meet with them that it's your opinion that you're guaranteed recovery?
When we meet with them, we share our reasonings why we assume that we will get recovery for the cost associated with Four Corners Power Plant. But I also said earlier, rating agencies are independent agencies, and they will look at lots of sources. They will follow regulatory filings. They will follow the legislation. They will receive lots of input besides the company.
Okay. I know you don't agree with the Attorney General on this issue, but let's assume for the moment that the ETA does not apply to the Four Corners abandonment. And let's further assume that the abandonment of Four Corners is a condition of the merger. Do you think the rating agencies would look more favorably on a decision to approve the merger but deny recovery of Four Corners? Or do you think they'd look more favorably on 100% recovery and no merger?
That's a big hypothetical that I'm not sure that I can answer.
Your opinion.
Well, those are two hypotheticals to start with. And I disagree with your hypothetical, so I'm not sure I'm equipped to answer that question.
Which part?
I disagree with the write-downs, and I disagree with the merger condition.
You think that Avangrid could close if there wasn't a divestiture from Four Corners?
There were two conditions in the merger agreement. And like I said before, those conditions have been met.
Okay. Well, turning to page 5, lines 18 and 19 of your testimony. You say that Moody's and S&P have stated that New Mexico is less.
I'm sorry, can you hold on? Which page
Yes.
did you say?
Page 5, lines 18 through 19.
Yep.
You say that Moody's and S&P have stated that New Mexico is less credit supportive regulatory environment compared to other jurisdictions. Do you see that?
Yes.
How do you define a supportive regulatory environment?
Both Moody's and S&P publish reports on regulatory environment, and they have both of them have put New Mexico's regulatory environment in last.
So what does a supportive regulatory environment mean to you?
Supportive regulatory environment means you get timely recovery, you have certainty and predictability, and you have a regulatory framework that's supportive in ensuring that you're earning your allowed ROE. And so, yes.
Okay. And if New Mexico is a less supportive regulatory environment, does that mean that they view the PRC as tending to put more emphasis on customers and rates and less on company profits?
These are their words. They have put, they are using the words less supportive regulatory environment. And so I can't speak for the rating agencies. They have in many write-ups talked about the challenging regulatory environment in New Mexico.
Have you met with any of the rating agencies since the merger has been announced?
I have not met with them. I have
Have you
talked
spoken
to
with them?
Yes.
Okay. And how do they view the merger?
It's positive, stronger parent, which is a good thing for the rating agencies.
So,
and I do. Go ahead.
I'm sorry, please.
No, go ahead.
So if there's a write down, wouldn't it be the negative impact be offset by the positive impact of the merger?
I disagree that it's that simple, that one positive cancel out a negative. It is a credit positive for Avangrid to buy PNMR. Avangrid is a stronger parent and have a stronger balance sheet. However, PNM is rated on a standalone basis. We issue debt on a standalone basis. Our ratings are on a standalone basis. And so that direct impact from the regulatory environment and how your credit metrics perform is a much stronger, has a much stronger impact than the indirect effect you get from Avangrid being owned by Avangrid.
Maybe I don't know the answer to this question, but if PNM were to take a write down, let's just say 200 million write down, could that be offset or counted against the goodwill, which I think is 2 billion. I don't know if is it sitting with PNM or is it with Avangrid, the goodwill? Where is it booked?
You're getting into accounting here, and I'm a finance person, so you're testing my knowledge. But I believe the goodwill sits on Avangrid, and if you have a write down, it's part of PNM.
Okay. My last question is the $75 million that's being paid to NTEC. It seems like a fairly remarkable occurrence where PNM is making such a payment. Why do you think that payment's being made? What's your understanding of the reasoning behind it?
To benefit customers, to get out of their obligations associated with the coal supply agreement.
Okay. I'm sorry, I do have one more question. During the 8 years that you refer to on page 10 of your testimony, this is when PNM had a rating below investment grade. The company's rates reflected the actual embedded cost of debt, at least at the time of each rate case, right?
That's correct.
Okay. I have no more questions. Thank you, Mr. Hearing Examiner. Thank you, Ms. Eden.
Thank you.
Thank you, Mr. Elliott. You made it in time for child pickup duty. Fortunately or unfortunately, we'll just chug along or persist, as some people say, after you excuse yourself.
Pickup
Thank you very
duty is
much.
important.
Thank you.
Most important thing, if you're talking about children, absolutely. But I see that Mr. Gerhart is primed and ready to go with his headset on, so he must have some questions for you, Ms. Eden. Mr. Gerhart, I think you had 15 minutes reserved.
Yes, thank you, Mr. Hearing Examiner.
Please proceed.
Good afternoon, Ms. Eden.
Good afternoon.
Would you please turn to your rebuttal testimony, page 7, line 13?
Oh, sorry.
Please let me know when you're there.
I'm there. The wonders of Zoom meetings.
Exactly.
Mhm.
So on line 13, you write both
Oh, I thought
rating.
you said it's line 7. Am I line 13?
Sorry, I may have misspoken. Page 7, line 13.
Okay.
So you write, both rating agencies expect utilities to recover and earn a return on their full investments in a timely fashion. Do you say that? See that?
Yes.
My question is, are you aware of any statements by credit rating agencies that they expect utilities to fully recover imprudent investments?
No, I don't believe so.
Okay. In the next sentence, you write, in the case of PNM's undepreciated investment in FCPP, the rating agencies correctly view the ETA as providing certainty of recovery. Do you see that?
Yes.
So I want to try to understand this sentence. I assume that that sentence is referring to a situation in which PNM's application for abandonment is approved. Is that correct?
This sentence assumes that the abandonment is approved under the ETA and that the ETA statute applies to this case.
Thank you. So just to be clear, you're not saying that if, for whatever reason, the abandonment application were somehow denied, you're not asserting that the ETA in that situation would guarantee cost recovery for PNM, are you?
You lost me a little bit there. Can you rephrase the questions?
Sure. So no problem. Let me try. Let's just assume for the purposes of this question, for whatever reason, the commission were to deny PNM's abandonment application. In that circumstance, do you believe that the ETA provides certainty of cost recovery to PNM?
I think we're getting into legal conclusions here, and I am not equipped to speak to that. What I think the rating agencies are viewing the ETA, that it's frankly, even Moody's said it's a blueprint for the company to transition out of coal. And so they know what the ETA says and what it stands for and what's allowed under the ETA. And so with this, so they believe that there are some certainty of recovery due to the ETA statute.
Thank you. In your experience, do the rating agencies track recommended decisions and final orders in PNM's rate cases?
When you say track, what do you mean?
Let me rephrase. In your experience, are the rating agencies aware of recommended decisions and final decisions in PNM's rate cases?
I would say yes.
And would you expect the rating agencies to be aware of the recommended decision issued in PNM's last rate case?
Yes.
Okay. Would you turn back to your rebuttal testimony to page 8, line 23, please?
Okay.
So I want to make sure I'm understanding what you're saying here first before I ask you questions about it. My understanding is that you're saying here that a disallowance of Four Corners costs would send a signal that New Mexico is not a healthy environment for investment. Is that accurate?
I think that if that my opinion here is that the case is governed by ETA. And so there's nothing in the ETA that talks about disallowing costs that were already in rates as of January 1st, 2019. And so if the commission would negate that and the ETA would not apply, that would be a bad thing. And I think Mr. Atkins also talked about that in his testimony last Friday. He said it would be a big red flag if the commission would sort of circumvent the intent of the ETA.
So is your opinion in your rebuttal testimony limited to a situation where, in your opinion, the ETA applies as a matter of law, and for some reason the commission chose not to apply the ETA? Is that the situation you're describing?
I think that my testimony is both saying that the ETA applies, and as a result, there is the definitions associated with abandonment cost is clearly defined in the ETA. And as a result, the company, all those costs associated with Forest Corner Power Plant should be securitized, and the customer should get the benefit of that really cost-effective financing tool, and the company should be able to take those investments and put them to use for the benefit of customers.
Okay. So for the purposes of this question, I realize you're not offering a legal opinion, and I'm not asking you for one.
Thank you. Thank you.
Just for the purposes of this question, let's assume we're in a scenario where abandonment is denied and the ETA has not been triggered. So in that situation, is it your testimony that there is some categorical reason for the commission to never issue a disallowance for imprudence?
No, I don't think that's my testimony. Right.
Okay.
5 minutes, Mr. Gerhardt, 5 minutes.
Thank you, Mr. Hearing Examiner. I'm actually finished. Thank you so much, Ms. Eden.
Thank you,
Mr. Hearing Examiner.
Thank you, Mr. Gerhardt. We're at that hour, we're after 5, but I think we should just try and, with the parties and the court reporter's indulgence, complete the cross-examination of Ms. Eden.
Thank you, Mr. Hearing Examiner.
Of course. We're almost there, but we have Ms. Beatles from Western Resource Advocates, who has 10 minutes.
Thank you, Mr. Hearing Examiner. Good afternoon, Ms. Eden.
Good afternoon.
With respect to your interactions and communications with rating agencies about the applicability of the Energy Transition Act to Four Corners, did you also advise them, the rating agencies, that PNM may have waived its right to full recovery of Four Corners undepreciated capital under the ETA by staying in a rate stipulation that was approved by a commission order that also said the prudence issue would be deferred until your next rate case?
That was a mouthful, so you have to restate that, please.
I know. I tried to shorten it as I was writing it out. So you agree that the commission's final order in the 16276 rate case, that stipulated rate case, you agree that it deferred any findings of imprudence to the next general rate case, right?
They deferred the prudence review to the next rate case, yes.
Okay. So, and then PNM proceeded to implement the rates that were approved in that final order that adopted and accepted the stipulation, right?
Yes.
So did you also advise the rating agencies that PNM may have waived its right to full Four Corners recovery under the ETA by staying in a rate stipulation that was approved by a commission order with that proviso?
I'm not sure what you mean by advise the rating agencies, and I still don't fully understand your question, Ms. Beatles.
I'll try to break it down a little bit more, but I'm going to use up my whole 10 minutes doing this probably. But so you were answering some cross-examination by Mr. Elliott for the AG's office about interactions and communications with the rating agencies about the applicability of the Energy Transition Act to the Four Corners situation, right?
Yes, we've had discussions with the rating agencies associated with this Four Corners abandonment and how it relates to the ETA. Yes.
In those discussions, did you ever advise the rating agencies that PNM may have waived its right to full recovery under the Energy Transition Act? Without further prudence review?
I'm not sure what you mean by advised, and I still don't understand the question. I'm sorry.
In those discussions, did you ever state, so let me take it out of the characterization of advice. Did you ever mention or state to your rating agency contacts in presentations or informal conversations, or however you had those discussions, whatever context you had those discussions, did you ever mention that PNM may have waived its right to full recovery under the ETA by implementing the stipulated rates?
I don't understand what you mean waived our full, what rights have we waived? I don't understand that.
Yeah, well, I don't want to testify. And I guess if you don't know what I'm talking about, you probably didn't mention it to them. Is that right?
Well, I'm sorry, I don't know what you mean by waiving our rights under the ETA.
So you agreed that that final order in the last rate case said that they would defer the prudence review till the next rate case, right? We've established that. Okay.
Yes.
And you also agreed just now that PNM went ahead and implemented the rates that were approved in that case, right?
And the rate increase associated with it 2016, yes, was implemented according to the final order.
And that case was not a litigated case, it was a stipulated case. PNM was a party to a stipulation, is that right?
I think it was a partial stipulation.
So did you ever consider that PNM may have waived, like relinquished or foregone its full recovery under the Energy Transition Act by implementing those stipulated rates subject to a later prudence review?
This sounds like legal conclusion, and I don't have expertise associated with neither regulatory or legal, so I don't think I'm the right witness to answer that question.
Yeah, thank you for that response, but the applicability of the Energy Transition Act is a legal issue to begin with. So, and I think your responses are telling me that the answer is no, that you didn't consider that PNM gave up its right to full Energy Transition Act recovery at Four Corners by implementing the stipulated rights.
I don't think that one can give up rights when the statute didn't come into play until 2019.
And I believe Ms. Sanchez and other PNM witnesses have testified at this hearing that PNM had a lot to do with that statute getting enacted. Do you recall that?
I don't recall that.
Okay, I think that's all I have, Mr. Hearing Examiner, because let me just ask one more question in confirmation. So it doesn't sound, because you disagree that PNM could have given up any right under that statute, it doesn't sound like you considered it or communicated that in your discussions with the rating agencies. Would I be correct?
I don't think that I'm agreeing to your analogy. I think I don't understand your analogy, and so I don't know what the company has given up, Ms. Beadle.
Yeah, well, I'm not asking you to agree. I'm just asking you what you have mentioned or stated to rating agencies. And I think what I'm hearing is that because you hadn't considered it and you don't agree that anything was given up, it sounds like you did not mention that in your discussions with rating agencies. Can you confirm that?
Again, I don't really know what your premise is. I don't understand the premise. And so then that would be hard for me to mention to the rating agencies if I don't understand your questions, Ms. Beadle.
But you would remember if you had mentioned that to the rating agencies, correct?
Correct. But again, I don't understand what your premise and what your question is all about.
Mr. Hearing Examiner, can you ask the witness to respond to my question? If she recalls whether she stated that to the rating agencies in any of her discussions with them about this situation?
Well, let me approach it this way. Ms. Eden, in talking to the rating agencies, did you talk about the disallowance of any capital investments in Four Corners that the hearing examiners found in the certification of stipulation in case number 16-276 UT?
Yes, so when we talked to the rating agencies associated with the 16 case, we also reviewed information associated with the RD and the final order. And so those things would have been discussed.
And those were discussed after the passage of the ETA?
Those would have been discussed at the time of when the RD and the final order came out.
Did you talk about them afterwards? After the ETA passage?
That I can't say what was talked about, because at that time I was the VP of HR and the CIO. So I was not in the treasurer role, but I believe we have very transparent conversations with the rating agencies. We are sharing, and they ask very detailed questions about our regulatory environment, our regulatory outcome, and how certain things would apply. So I believe they are fully aware about the outcomes of the 2016 case, and also the implication associated with the ETA.
Have you ever spoken with the rating agencies about the ETA or anything about the ETA?
I have not personally spoken to the rating agencies regarding the ETA, just because by the time the ETA was passed, I was in the role of the VP of HR.
Okay, there's another question there, Ms. Beatles, but I'll have you ask it if you want to.
I'm missing it. Sorry.
Are you aware, Ms. Eden, of conversations that the rating agencies have had with PNM executives about the ETA?
We would have talked as the treasurer team. Like I said, we are very transparent with the rating agencies. So the treasurer at the time would have talked about the ETA and how, when it was passed and what it entailed.
And what were the substance of those communications that you recall?
Again, I don't have firsthand knowledge, but they would have talked about the ETA, just because that was a major passage, and the rating agencies also talked about, wrote about it.
It's okay. As an expert for PNM, you can share hearsay with me.
And that's what I said.
Secondhand
Yes.
conversations.
Yes.
Well, you said firsthand.
You asked me if I had, and I just wanted to make sure that I was clear. It wasn't me who had those conversations, but the treasury team would have had conversations regarding the ETA, when this legislation was introduced and when it was passed.
And would they have talked about the proposed disallowances on the imprudent investments in the 2016 rate case in relation to the ETA?
Again, those disallowances would have been talked about when the RD and the final order came out. I'm not sure they would have been talked about during the conversations with ETA.
Beatles, any more questions?
That's all.
Okay. Thank you, Ms. Beatles.
Thank you.
Water Utility Authority, Mr. Harris.
Thank you, Mr. Hearing Examiner. The Water Authority has no questions at this time.
Staff.
Thank you, Mr. Hearing Examiner. I do have a few questions.
Okay. 10 minutes.
Understood. Good afternoon, Ms. Eden.
Good afternoon.
Good afternoon. Could you?
I guess it's almost good evening, right?
You know, I was thinking about saying that, but anyway, could you turn to your exhibit EAE1, which is your educational and professional summary?
Yes.
Okay. And I'm looking at this and I see the area where it's marked employment, and it states that you've been employed by PNM Resources, or PNM, since 2001. Is that correct?
Yes, I just celebrated my 20th anniversary.
And you identify, well, congratulations, first of all. But you identify 10 different positions then you've held. You see that?
Yes.
Okay, could we walk down through this and kind of find out the dates of that you held each of these positions? You don't have to give me like from March 25th, 2005 to whatever, but if you can give me a ballpark idea of when you held each of these positions, that would be helpful.
You're going to test my memory. Okay, so where do you want me to start? Where do
Why
you
don't we
want me to
start at
start?
the top? Vice President and Chief Information Officer. When
Let's start at the position that I have right now, which is the Vice President and Treasurer. And I've been in that role since January, February of this year.
Okay.
And the Vice President and Chief Information Officer, I was in that role approximately a year, so January, February of 2020. The previous role, VP and of HR, I think I entered that role in April or May of, let's see, 2018. Would that be 2019? Yeah. Yep.
Till about January of 2020.
Yeah, that January, February timeframe, correct.
Okay.
And then the Vice President and Treasurer, I believe I started as April of 2015. The Executive Director, Financial Planning and Business Analysis, I believe I held that since May of 2012. The Assistant Treasurer, I started in 2009. I cannot, I think it was in the spring. I just can't remember the month. Could have been early summer.
Okay, and I think that's probably enough. We've gone back far enough. I don't want to, drive you into, a seizure trying to think of these dates. But just, I think in response to a question, Mr. Elliott, I think you said that you were a finance person. Did I hear that correctly?
That's correct.
Okay. Thank you. Those are my questions. Have a good evening, Ms. Eden.
Well, you too.
Thanks.
Thank you, Mr. Borman. Ms. Eden, I just had a quick question on page 5 of your rebuttal testimony. Line 15 or line 14 onto line 16, you say that it could be Moody's would be likely to downgrade its rating of PNM by at least 1 notch from B, that's capital B, lowercase a2, BAA2 to BAA3, even if there were no material harm to PNM's financial credit ratios. Is PNM's current credit rating or rating BAA2?
That's correct.
Is BAA3 investment grade?
Yes, it is.
What's the next rating below that?
That's below investment grade.
Oh, and what signal is that, or what designation?
BA1.
BA1. Okay.
Mm-hmm.
Thank you, Ms. Eden. Mr. Gifford?
Thank you.
Your Honor, I know better than at 5:30 on a Tuesday to have any redirect.
All right, Ms. Eden, thank you so much. It's always a pleasure to have you as a witness.
Thank you. It's a privilege to be here. So thank you so much.
Thank you, ma'am.
Thank you.
Okay.
Bye.
Bye-bye. That has concluded our examination and presentation of PNM's witnesses. Now, and that concludes our substantive work for the day. Now, housekeeping issues. Mr. Borman, were you able to find out if your witnesses could testify tomorrow after the witnesses who are already reserved for that time
Mr.
period.
Mr. Hearing Examiner, I was able to get in contact with each of my witnesses, and each of them are able to testify tomorrow. I guess I would prefer that they go after the scheduled witnesses tomorrow, but they are available to do so.
That would be my intention, is that they would go after the witnesses I have listed. And they'll go in the order that they're on the pre-hearing order, Exhibit A, which is Mr. Johnston, Ms. Davis, Ms. Kitso, and then Mr. Dauphiné. So it would follow, after Mr. Dauphiné would be Mr. LaSalle, then Mr. Tupler, and finally Ms. Tashema.
Yes.
Okay, so that's done. We're going to
Mr.
have
Hearing
staff's
Examiner?
witnesses tomorrow unless there's any objection to that.
Yes, Mr. Hearing Examiner.
Mr. Tisdale.
Thank you. In communication with both PNM and WRA, it appears that they both intend to waive their cross-examination of Ms. Davis. And if
That was
is
my
in
next-
fact, if
That
that's
was my next order. Yeah, go
Oh,
ahead. I'm
excuse me.
sorry. My bad. No, my bad. Go ahead.
My apologies. If that is indeed the case, then it might save us a few moments and save Ms. Davis from having to appear tomorrow if we were able to stipulate her testimony in this evening.
Do we have the consent of both PNM and WRA to waiving cross-examination?
Yes, Your Honor.
Yes, Your Honor.
So.
That was Ms. Beatles.
Yes, it was, Mr. Lee. I'm sorry for not.
Sorry, Ms.
introducing-
Beatles.
Yeah, identifying
So-
myself.
To be clear, we're talking about Carol Davis's testimony. And we're talking about a waiver of cross-examination by PNM and Western Resource Advocates. Is that correct?
I believe that's correct, sir.
Okay, that zeroes out Ms. Davis for cross-examination. Would you mind seeking to make the formal stipulation of admission into evidence tomorrow morning?
That would be fine to do that in the morning.
Okay.
Can I let Ms. Davis know that she won't need to appear for that stipulation, Your Honor?
Yes, sir.
Okay, thank you.
You're welcome. Thank you. There was another thing. Oh, we need to deal tomorrow morning with the ongoing dispute over taking administrative notice of relevant pieces or portions of the record of case number 16-276. We'll it's that tomorrow morning or sometime tomorrow. I'm not sure exactly when, but we'll be addressing that tomorrow. Okay. Ms. Beatles?
WRA, it appears on your schedule, has the only cross-examination of Mr. Dauphiné. And my issues and questions do not rise to the level of being the only party asking any cross. They're just not that significant. And now that I've taken another look at them, so I waive our cross of Mr. Dauphiné.
Okay. Ms. Gould?
Yes, sorry, Mr. Hearing Examiner, I'm appearing by phone because I don't have very good internet at the moment.
Okay.
We appreciate WRA's waiver of cross, and we will be prepared to stipulate his testimony in either right now or tomorrow morning.
Tomorrow morning would be great.
Okay, great. We appreciate that.
and-
Thank you.
And I just want to mark that though, you or Mr. Gould should be aware that to the extent there is a disputed issue that Mr. Dauphiné raises in his testimony, that we discuss that in order to not lose that that issue, whatever the issue may be. Okay. But with that proviso, yes, we will stipulate the admission of Mr. Dauphiné's Dauphiné's testimony
Can I just
tomorrow morning.
can I just get clarification what you mean? Will you perhaps need him to appear at a different time? Or are you just talking about legal issues that the attorneys will discuss at the end of the hearing?
The latter.
Okay, great. Thank
Whether
you.
whether it's a mixed issue of fact and law or whatever it is, if there's a disputed issue there, I don't want it to fall into the cracks.
Okay, but
That's
Mr.
something that the
Dauphiné.
lawyers can handle. It's something
Okay,
that the
great.
lawyers can handle for sure. Because
Okay.
and an indication is that PNM waived cross-examination. And I would imagine that the disputed issue would have been potentially in that direction. So yeah, so we've got Mr. Dauphiné taken care of. He will not have to appear during this hearing either.
Okay, great. Thank you, Mr. Hearing Examiner.
Thank you. And thank you, Ms. Beatles, for that accommodation, I guess. Is there anything else? Okay, if not, then we will recess for the evening and I will see everyone at 9 a.m. tomorrow for the presentation of the community groups, witnesses, and Mr. Johnston, Keatso, and then the staff witnesses, because that's what we're down to now, I believe. With that, have a very pleasant evening, and I will see everybody tomorrow at 9 a.m. Thank you.
Thank you, Your Honor.
Take care, everyone. Mr. Lee, thank you so much. Sorry we went long tonight.
You bet.
Take care.